Our idea today is really to move beyond narrow technical issues, to explore those kind of cross-disciplinary matters, to really look at this from different lenses, to have a discussion, to have panels, to have that capacity to take an engagement that is truly multidisciplinary, something that we do here at Jesus College quite often. The college I'd just like to welcome you to was actually set up in the 12th century as a Benedictine nunnery, all-female crowd to begin with. But in 1496, Lord Alcock, then Bishop of Ely, came to the site and found that there was some unexpected situations, that the nunnery was not performing as one would expect. I'll let you look up the history of that. It's rather controversial. And so it was turned into an all-male college and remained so until 40 years ago. We're proudly celebrating our 40th anniversary of becoming co-educational in the college. At the time that Lord Alcock set up a college, it only had 6 fellows and 6 students. And as you probably observed with the plethora of people outside today, we've grown hugely since that point and have a large number of potential people interviewing here today. In terms of the representation, they represent the full diversity of the university's disciplines, and that's partly why we delight in hosting events like this. AI, machine learning, big data, law, all of these things have been topics that the Intellectual Forum has looked at over the last few years since it was created in 2016. And so it's with that in mind that what we hope for today is that you'll be able to have these kind of multidisciplinary discussions. We delight if you tweet at Jesus College as well as at the university and at the relevant organisations. But we did want to take this chance to welcome you to the site, but also to thank our wonderful support, both from the university itself, from the Cambridge Public Policy SRI, from the Leverhulme Trust, and specifically also from LexisNexis, Thought River and Heart. Without their help today, this wouldn't be possible. So we'd like to thank them and thank also Dr. Marku and Dr. Simon Deacon, who are, I believe, Dr. Deacon is actually on his way, held up on a flight, so he will be with us soon. I know he's scheduled to do a welcome. And as such, we've had Dr. Jennifer Coombs say that she will instead take his place wherever she may be. Where are you? Do you want to come up? I apologise, I am far from a subject expert, but we are delighted to have you here with us today. Thank you so much.
Okay, thank you very much, Sarah. Of course, we're here to talk about the computability of law, the use of machine learning to replicate aspects of legal decision-making is already well advanced. A number of legal tech applications have been developed by law firms and commercial suppliers, and they're being used, among other things, to model litigation risk, to data analytics for informing decisions on legally consequential matters, including probation, predictive policing, and credit evaluation. The next step will be to use machine learning to replicate core functions of legal systems, including adjudication. The use of algorithms to aid judicial decision-making is currently being trialled in China's 3 internet courts, in Hangzhou, Beijing and Guangzhou, and also in Estonia. So far, these experiments are limited to commercial disputes, which are small scale and, in principle, relatively straightforward to resolve. But more ambitious claims are being made for the use of machine learning in the legal sphere. Insofar as the legal process can be abstractly viewed as computation, inputting information about evidence and laws, and outputting a decision, some predict the growing use of AI systems that tirelessly apply the same high legal standards to every judgment, without succumbing to human errors, such as bias, fatigue, or the lack of the latest knowledge. While in the short run, the next few decades, more data and improved machine learning are likely to be complements to human judgment rather than substitutes, some argue that over time, the goal of a functionally complete law will come into view. Governments will use machine learning to optimise the content of the law and to generate a stable and predictable legal system whose oscillations will be continuous and yet relatively insignificant. At the same time, there are already signs of pushback against the use of machine learning in the legal sphere. Critics point to the biases in current algorithmic decision-making processes, which systematically disadvantage the poor and minority groups. Concerns over the constitutionality of automating judicial process prompted the passage of a law in France, which bars the use of personally identifiable data of judges and other court officials with a view to evaluating, analysing, comparing or predicting their professional performance, real or supposed. In this context, there is an urgent need for informed debate over the uses of AI in the legal sphere. This is where Lex Ex Machina comes in. Our speakers today will help advance this debate by identifying and addressing legal and ethical risks associated with algorithmic decision-making and helping us to understand the potential of and limits to the computational techniques underlying law-related AI. We've brought together legal academics with researchers in STEM disciplines, the social sciences, policymakers, legal tech developers, and civil society organisations to explore these questions and what computable law means for the autonomy, authority, and legitimacy of law as a social and societal institution. As Sarah said, Professor Deacon isn't quite here yet, so we're kind of just waiting for him. I think in the meantime, we have a video from Dr. Marco, which will hopefully be up soon. This is a short introduction, and then we'll move on to something else.
We have a video to play. So we're supposed to have a talk from both Dr. Malco and Simon Deacon, as we've said, but unfortunately planes were delayed and apparently there's an air traffic control issue that has meant some people are held up from Stansted this morning. Simon is about 10 minutes away from what I am told. So what I'm going to do is, rather than try and occupy time and space in an inconsiderate way for you all, so I'm going to say we will begin with Simon in 10 minutes when he arrives with his scheduled talk. I can only apologise for the inconvenience. As I'm sure you're aware, with the election of last night and various other things that have gone on, there has been some delays in him getting here. And also, from what I'm told, there is a very, very, very long traffic queue the whole way down Babram Road. So for those of you who are from Cambridge, you'll realise that that means he is getting here when he gets here. So I will give you a 10-minute break. We're expecting him to be here at 10 o'clock. So,
is there more coffee?
There is indeed coffee outside. Do you think that Cambridge University could function without caffeinated beverage being available at all times?
Oh, this isn't Cambridge University, this is the college.
light of the fact that Professor Deacon and Dr. Marku haven't been able to make it for the first session, I know Professor Deacon is on his way. What we're going to do is start the first panel. So for this panel, I'm going to hand over to Dr. Jennifer Kuhn, who's going to begin by introducing, and we will have some people coming in via Skype. So there will be some video and some Skype in footage for this. Please do enjoy. Thank you.
Thank you very much. So as Sarah said, we're just going to crack on. Our first speaker on this panel is Professor John Morrison from the School of Law at Queen's University, Belfast. Yes, unfortunately, according to the agenda, it should be Lyria Bennett-Moses, but she is Skyping in, and we need to tell her to Skype in like an hour earlier than she was supposed to, so we're kind of a wee bit... Yeah, so John's going to go first. He's going to talk about towards a democratic singularity, algorithmic governmentality, the eradication of politics, and the possibility of resistance.
From a standing position?
If you want, it's up to you.
Okay, why not? Thank you very much indeed for asking me along to this. I don't have a PowerPoint presentation. I decided to go old school. But I do have a very good title. I'm going to say it again because I'm so pleased with my title. Towards a democratic singularity, algorithmic governmentality, the eradication of politics, and the possibility of resistance. What good timing to be giving a paper on this topic just after the election. I want to think a little bit about how the digital life world, as you might term it, affects politics generally and democracy in particular. I mean, we know that we get elections with lots of publicity material from Russia or wherever. And we also, perhaps some of us use some of the websites which will tell you how to vote tactically. Things like who should you vote for, and there's a BuzzFeed one, and vote for policies, so you can do a tactical voting. Well, that went well, didn't it? Not really. But what I want to think about is something a little bit more full on than simply fiddling around at the edges of the democratic process. I want to try and think about a sort of possible future where we might have something approaching an algorithmic governmentality. And let me just illustrate that by a little quotation from a novel which I'm reading by Joanna Kavenna. It's a dystopian novel which describes a perhaps not too distant future where there's a tech super company called Beetle, which harnesses big data and develops a series of what they call life chains, which are predictive ways of interpreting what goes on. And in the book it says, due to the zettabytes, which is a real word, due to the zettabytes of data we have amassed, we have a unique understanding of the human soul, of its desires and intentions, of the desires and intentions of humans in general and humans in particular. So I want to try and take us into a world where something like that is not too far away. But my paper starts, just to try and follow the structure, it starts with a section which really looks at some of the disappointments of democracy in an internet age. Sometimes it seems as if increasing participation and increasing knowledge is the way in which democracy can be saved. If only people knew everything and had a chance to talk together, everything would be fine. So the paper looks at this through a governmentality lens. The first section says, well, what's going on here? And in fact, it seems that what we have in a consultation process, either online or otherwise, is really a more complex engagement. It's a more structured engagement. It's one where consultees, in a sense, make themselves up in reply to the strategies of consultation. And the fact of their engagement makes them representative. The paper talks about how in 2005, a commentator was saying, we have all this information about the Iraq War, so much content, so much connection, but yet nobody pays any attention to it. There's a fantasy of participation. There is a kind of a technology fetishism, an idea that if you just connect people together, everything will be all right. But in fact, of course, what really happens is that lots of this interaction is put into a safe space online, and real politics continues elsewhere. So the paper looks at and refers to some earlier work about how one really can only understand this fully by developing a governmentality analysis, which suggests that this promise of wholeness and so forth is one which is, I say, highly structured. But But what I'm thinking about now really is moving on a little bit from that kind of scenario to look a little bit into the future. And here I think I'll quote from Gilles Deleuze's work on societies of control. He wrote a postscript to this in 1992. And I like the way he remarks about how different types of societies can be matched to different types of machines. And it's not because machines determine how societies work, but rather they sort of express social forms capable of devising them and using them. So, for example, clocks, simple levers and pulleys, seem to suggest older societies of disciplinary sovereignty, whereas more complex factory machines using energy and so forth would tend to suggest a more productive process, a surveillance society, with all sorts of fears about entropy and machine breaking and all that kind of thing. But as Foucault points out, these formulations are transient. The spaces of enclosure of earlier societies, the prisons, the factory schools, and so forth, will pass away. And now it seems we have a new technology, the idea of a digital technology, which perhaps is the appropriate one to think about for the current and future world. What I'm thinking about here is the computer and all those devices. They're totalizing capture of information across every facet of life, which represents the present society and the future society of surveillance and control. What Bauman and Lyon describe as liquid surveillance. And indeed, Deleuze talks about this idea of liquidity too. He talks about enclosures are molds, distinct casings. But controls are a modulation, like a self-deforming cast that will change continuously from one moment to another, like a sieve whose mesh will transmute from point to point. It seems to me that this description begins to capture the wider, more ambitious project of control and surveillance and discipline that we have now. Now I'm pushing the phrase digital life world to cover this. I'm trying to encourage people to use that. In a sense, I got that phrase from a new book by Jamie Susskind, but I think I'm using it to refer to something even wider than he does. I'm trying to talk about power relations within this and in all their historical specificity. The ways in which technology is organized and supplied and consumed, and the way in which it constitutes us as users and as consumers and citizens and so forth. So my argument is familiar to everyone in this room, I hope. Ideas around big data, data mining, pattern recognition, machine learning, datafication, data valence, personalization, etc. allow massive volumes of data to be collected in a velocity and with a velocity and a variety that makes conventional forms of analysis impossible. So instead we use AI. The Internet of Things is enabled by 5G. Will gather information from a whole range of things and allow this ingestion and processing of information. Think also about things like geographical information systems involving global positioning, geodemographics, remote surveillance systems, reusing existing data, finding new data. So we're getting a way in which information can cut across cultural self-definitions of community. Focus on socio-economic characteristics in ways that can dissolve ideas of place and replace this with a whole range of inferences drawn from other factors. Cultural groups can thus be represented as mere aggregations of individuals in a way that undermines their legitimate claim to be a group and, in a sense, dismisses their political agency. This is also interesting because it's lively data, as Lupton describes it. It's dynamic, it's flowing, encapsulates any and every aspect of life, from the length of a phone call to likes on a social media site. A couple of other things I just want to highlight about what's going on with this new approach to data. We have to think about how it connects in to relatively older technologies, things like the Universal Product Code, barcodes, radio frequency identification, RFID technology, which uses electromagnetic fields to automatically identify and track tags attached to objects. And it also connects with wider converging technologies using biometric, genetic, and even olfactory devices to make a whole range of judgments that underpin categories of social sorting. Nanotechnology, biotechnology, information technology, and cognitive technology together provide a paradigm change on a level that is similar to, but exceeding, the last industrial revolution. So what we've got here is what's been termed surveillance assemblages, and I wanted to draw in on that. And I want to also point out, as Zuboff has, of course, in her recent and most interesting book, that this sort of surveillance is not restricted to law enforcement or even to the state. The state is perhaps less of a problem, or certainly no more of a problem, than the corporate world, where there is a process of commodifying experience into data and marketizing it. How am I doing for time?
Don't worry about time.
Okay, don't worry about time. Oh, go back to the beginning again then. What we've got, I think, as a nice quote from Hoy and Monaghan argue, there's a variety of state and corporate powers which between them have turned the internet into a global surveillance dragnet. Zuboff, I think, captures the relentless inevitability of this very well. She says, surveillance capitalism's rendition practices overwhelm any sensible discussion of opt-in or opt-out. There are no more fig leaves. The euphemisms of consent can no longer divert attention from the bare facts. Under surveillance capitalism, rendition is typically unauthorized, unilateral, gluttonous, secret, and brazen. These characteristics summarize the asymmetries of power that put the surveillance in surveillance capitalism. They also highlight a harsh truth that it is difficult to be where surveillance is not. As lots of other industries are lured into the race for profit that comes from surveillance technologies, we find that this whole idea of rendering data becomes a global project of surveillance capitalism. But it seems to me that just thinking about this in terms of surveillance alone, and indeed discipline alone, doesn't really capture the ambition of the new models. We have datafication, we have dataveillance, we have indeed a whole new model of knowledge production. And it's one which operates on different lines than hitherto. Algorithmic tools offer an aura of objectivity and rationality and legitimacy that's derived from their empirical underpinnings. Algorithms are epistemologically performative. Unlike theory, they make no claim towards truth, only to function. As Larry puts it in Big Data and Society, algorithms cannot be wrong in any theoretical or mathematical sense. So what we have on offer here is perhaps better seen as a new form of government. Algorithmic government is about extracting facts, entities, concepts, and objects from vast repositories, and as calculative devices create subjects and objects of interest in this way, they make these subjects and objects perceptible and amenable to decision and action through the eluctable power of inference. Following Antoinette Rouverie, I think this is best seen as a new governmentality, achieved through the accumulation and interpretation of vast reserves of data. It's one where people, as the subjects and objects of government, are simultaneously present through their everyday action and absent in the sense of not having any individual agency beyond the data. The data becomes the governable reality, the everyone. In this way, within this particular governing conjecture, the way in which individuals see themselves and are constructed as units of governance is radically changing alongside the means of governance. The target of this governmentality is the future, what people might do, what they might buy, how they might act, how they might react. And the resources of big data are endlessly analyzed, and they can master the future through this power of inference. Now, all this seems to me to have very profound consequence. In essence, it introduces this idea of algorithmic governmentality, which draws upon and seeks to involve governable subjects who function not as real individuals with politics and association and so forth, but rather as temporary aggregates of infrapersonal data gathered at and exploitable on an industrial scale. The knowledge that algorithmic government draws upon is not created by individuals, by people talking to each other and forming political parties or whatever. It's simply taken from their data trails. It isn't given any meaning by political or other frameworks of reference. Instead, it appears ineluctably from the data. It's to be found present, albeit hidden, within the data trails that we leave behind. At the same time as kind of destroying our agency, our political identity, at the same time, it seems to offer a false emancipation by appearing to be, by its very nature, all-inclusive. Everything's there. If you complain, well, we'll just take that on board and improve our data set. It'll be self-correcting. The promise of algorithmic governmentality, for me, means that the project of government is changing. It's now about predicting and responding to predictions within this digital world that is uncoupled in many real ways from natural experience. This produces what we might term, following Foucault, a new truth regime, one that's centered around what is visible from the data. It involves the departure of individual agency, the disappearance of politics, and certainly the disappearance of any notion of consultation, of your vote counts or whatever. Now, this is something that I think is more serious than what we've seen before. It's very different from simply looking at things like, PageRank or EdgeRank or what's trending. That just shows what's popular online. This actually purports to be about everything, about your life. Consider that Facebook's algorithm popularly is thought to be able to require only 10 likes before it's able to predict your opinions more accurately than your colleagues. Only 150 likes before it exceeds your family in being able to estimate your preferences, or 300 before it can forecast your views better than your spouse. We're talking about something that's completely on a different scale to that, something which has got the power of removing your agency and saying, we know you better than you know yourself. Drawing upon the almost total picture to be provided by the data streaming in from the Internet of Things and elsewhere, this project can claim the advantage of almost total comprehensiveness. The very notion of a representative sample is over. In a world where everything is captured, N equals all. We could harness this to develop ideas of voting apps or whatever, but I think the project's much more serious than that. I think what's going on will be rather like what Jose and Fisher argue in the context of risk assessment in criminal justice. It is a new epistemology, and it's one which signals a rejection of any essentialism in how we think about people as individuals and about human nature. If there is no deep structure, but only surface behavior, it becomes impossible to speak of any individual as a case within a larger systemic whole, such as a gender or class or whatever. The algorithmic episteme assumes no social subscription, identifying individuals only as the sum of their actions. So it seems to me that the practice of algorithmic government has the power and potential to undermine and then transcend many of the fundamental attributes of citizenship as they appear as part of the bargain within the government-governed relationship. Many of these are anchored in ideas of individual privacy, of selfhood, and spill over into wider ideas of civicness, community, and citizenship, and indeed the whole idea of the liberal state. I think the threat from this is at that sort of level. Algorithmic government is, in Foucauldian terms, a new technology of government. But it's more than that. It's a technology of government that wins the arms race started in the mid-18th century by statisticians who rendered modern forms of government feasible by naming, numbering, controlling the world through the deployment of statistical power. Now there's a conjunction of the big Foucauldian concepts of knowledge, biopower, and population, and they're coming together in a new governmentality. I'm going to finish now.
Quickly.
We're prepared to give up our rights very easily on this. As Tim Wu remarks, consumers on the whole seem content to bear little totalitarianism for convenience. But the reason why I think a governmentality perspective is important, because governmentality, as we all know, also contains within it the idea of resistance. Foucault famously saying, where there is power, there is resistance. And one of the things I want to do in the rest of the paper, which isn't finished yet, so I'm not going to force that upon you, is look at ways in which we can develop forms of resistance, both in legal and other forms. But as I say, that's the bit that is yet to come. Thank you very much.
Good. Thank you very much, John. Our next speaker is Dylan Thampapai from the College of Law at Australian National University. He's going to talk about copyright and the singularity, Frankenstein's dystopian doctrine. This is a cheery thought.
Alrighty, thanks, Jennifer. I do have slides, but I'll circulate them later and just use them as talking points for this talk. So, I'm something of a skeptic about this concept of the legal singularity, and as I hear about things of algorithmic governmentality and decision-making affecting citizens, I have this sort of rising sense of panic, in part because in Australia we're just reeling from the robo-debt scandal, which resulted in at least one suicide and a whole raft of false debts being claimed against welfare recipients. So this is an extraordinarily controversial idea that we would hand over decision-making to algorithms. Now, it's possible that the technology might develop to a point where this could actually happen, but we're quite a long way off of that. So what I wanted to do in this talk was to really not simply talk about this legal singularity concept in an abstract sense, because it's easy, I think, to talk about the rule of law, law as a system, and we can talk about these big concepts, and that's all great. But the problems come in the details, as they do with most doctrines, and it's when you actually have to apply them. Different stakeholders, much disagreement on the meaning of fundamental concepts. Take, for example, exploitation within contract law, or fair in terms of fair use or fair dealing within copyright law. Those concepts can draw out very different meanings from a variety of actors. So the idea that a single algorithm or set of algorithms is going to come along and have a meaning that everyone is going to buy into is quite frankly very, very hard to believe. So before I get into the talk, let me just give you one or two slight disclaimers. So I have expertise in law. I'm a copyright law, contracts, and I guess in this nascent field of artificial intelligence law, I've got some expertise in that. And I came to artificial intelligence primarily because of the impact that AI is going to have upon copyright law. It will fundamentally change the entire nature of copyright law. That's going to happen. Whether that's a good thing or a bad thing, that's open to debate. I've got qualifications in economics and commerce through a Master of Commerce, but I do not have a computing science background. So there are two singularities that are at play here. There's the technological singularity, on which there is a well-developed body of academic thought, and that divides computer scientists. So I'm a believer, to some extent, in the technological singularity. That probably will happen. On the legal singularity, on the basis of my expertise, I'm a complete skeptic. So make of that what you will. But so what I propose to do is to talk about the technological singularity, then try to consider how that might come over into the legal singularity of this nascent concept that people have started to write about. And then talk about what this will all do to copyright law, and then offer you some critique. And at the end, I guess I'm just going to urge you to be incredibly cautious in this area, not to proceed without an extraordinary amount of safeguards. So obviously I'll start with the technological singularity. There has been a lot of debate about this concept of a technological singularity. Foremost amongst these is the writings of Werner Winger, whose paper on singularity suggests that there will come a time where there are computers that are awake. In effect, that there is a superintelligence that emerges. The computers are basically this interconnected superintelligence that far outweighs anything that human beings could do. And the basis of this is the trajectory of technological development. So drawn from Moore's law, that the tech will move to exponential level of development, and that we will come to this point where the world as we know it ceases to really exist, because the technology is so far in advance, it's superhuman, and we can't really predict what it could do. Now, along the way, there might be other things that happen. We might have transhumans, so that you're part human, part technology. We might have situations where the interaction between the human being and the superintelligent computer effectively renders the user some form of superhuman. All of this means that everything becomes unprecedented, unpredictable, and moves at a rate which we haven't contemplated. So all of our assumptions upon which we build law become redundant. And the law is reflexive, right? It's always kind of looking back. It's interesting in this sort of interdisciplinary field to see that tech people tend to really look forward. Law people, particularly law academics such as myself, really do tend to just look backwards and mull over things that have happened. So it's an interesting idea where the assumptions and rules that underpinned large parts of our society would cease to apply. So Good described the singularity along these terms. So the first ultra-intelligent machine would be the last invention that man need ever make, because the machine would be so super intelligent it could then make inventions that would outstrip and exceed anything that human beings could possibly create. Winger suggested, and I think that there's a degree of optimism in this. Well, it suggests that the superintelligent machine could be a tool of human beings, but it also suggests that it's possible that it might not be so. And so that's a crucial point, because once the superintelligence emerges, it's so far in advance of where human beings are that effectively we are to the superintelligence what, I hate to say this, what rabbits are to human beings. So that's an extraordinary situation. So there are two ways of looking at this technological singularity. The first is dystopian, and the second is utopian. So in the dystopian sort of analysis, let's run with my rabbits metaphor. If we are to the superintelligence what rabbits are to us, well, what are they? Sometimes pets, sometimes food, sometimes scenery, sometimes completely irrelevant. You create this extraordinary superintelligent machine, why would it stay around to resolve petty disputes between human beings? Would it not have better and more important things to do? It's like having a servant who can do literally everything that you want them to do, but they're 1,000 times or 100,000 times smarter than you are. For how long is that actually a stable or realistic scenario? The other issue is that, not so much the singularity, but as AI develops and we move along to the singularity, you have a massive impact on the labour market, because the things which we currently have a monopoly on, creative, skilled labour, that will be seated in some part. And this is partly why this is so controversial in copyright law, which is all about human creativity. So human beings would lose a monopoly in the market for creative, expert, analytical labour. The algorithm would take over. That's a very dystopian scenario. And in particular, the paper which we based this conference on was looking at the legal singularity in the context of tax. And again, it was a very utopian situation that everything would be perfect, this perfect tax system which would run seamlessly, everyone would pay a fair amount, no disputes, no dramas. Well, number one, that puts all the accountants out of business. Number two, where is this tax base coming from? If the AI has developed to that point, surely there are going to be job losses. You might recall there was an IMF report a year or two ago, which lazily at the back end of the report suggested a generation or two of long-term unemployment as AI took off. Surely that would have a massive hit on the taxpayer base and on many other things. Okay, so the utopian view of the technological singularity suggests that this superintelligence is going to be like a giant, omnipresent friend to human beings. So just like God, but digital. So that is possible. I mean, we're talking about things that are all hypothetical, so yes, it is possible. There is a concern that should arise here that even a benevolent God is still a God. So there would be some influence, would there not be, on human behaviour in a way that would have to constrain, to some extent, human liberty. So the superintelligence would subtly influence and guide human behaviour in a way that is fundamentally at odds with our understanding of what it is to be human. Okay, so let's come to the legal singularity. So I think it's difficult to talk about the legal singularity without admitting or accepting that it's going to be consistently impacted by the event of a technological singularity. And the technological singularity is not going to be a single point in time. It's going to be an ongoing process because development 1 leads to development 2 to 3 to so on, and it's all very exponential. So the legal singularity should then logically, because law always has to react to new situations, right? So the legal singularity then always has to change as well. It always has to adapt. And part of the business, and part of the business that why we have legal academics and law firms and all the rest, is because the transitions are never perfect. There's always some sort of controversy for us to write about, research, to charge clients for, and the like. I'm still very sceptical that if there were a technological singularity and there was a genuine superintelligence, that it would sit around and resolve human disputes. It might simply be too trivial for it. Another point is that the superintelligence, which would necessarily be eventually a non-human intelligence, might have very advanced and very non-human ways of looking at things. And this, there's a black box problem around algorithms and AI. So you might have your equivalent of the Heartful debate, but played out by bots in a general adversarial network or something along those lines. Sorry, I'm getting the tech all wrong. But, the problem is that there would be sort of parallel systems running here. You've got a tech system developing law, thinking about law, but it's not human readable. And then you've got a human system, or human beings who are the subject of it, who are just sort of desperately trying to cope with this consistently changing system. So deeply problematic. Conceptually, the legal singularity, at least as articulated by writers like O'Leary, is very difficult to argue against because it's hypothetical, and as a purely conceptual thing, it's perfect, right? Because it's, again, I'll use the God metaphor. No one's actually seen it, but apparently it's going to be omnipresent, omnipotent, and infallible. So it's really hard to criticise something like that. But law as a discipline is fundamentally about resolving its own fallibility, fundamentally about negotiating new situations. My concern is that whilst we have law to sort of prevent brute physical force, we might just be replacing that with brute computational force. And that just sort of, it ceases to serve human beings. Okay, in terms of how this would affect copyright, I'm happy to elaborate on this a bit later. AI affects copyright in terms of the ownership bargain, infringement fair dealing, and the user rights, so other free use rights. It basically radically will change the system because it introduces a new actor into the system. So I'll just offer I might skip ahead and just offer my critique. So we've seen code as law at present. Robo-debt is a good example, a non-copyright one, but very dramatic. And that has been very underwhelming, very deeply problematic. So the evidence is actually troubling, I think. So it's the first point of critique. The second is that code as law might tend dangerously to over-enforcement. So problematically, particularly in areas like copyright, copyright works because it's under-enforced. If copyright was perfectly enforced, if you got everyone for peer-to-peer infringement, it'd be a disaster. Think about all the libraries and orphan works and all the rest. You don't want that. The system works because it's under-enforced. Once you have a perfect property system, perfectly enforced, completely dysfunctional. Another issue is that laws, rules, and concepts are deliberately imprecise. So again, fair use, fair dealing. Fair is a very negotiable thing because attitudes change, circumstances change. Exploitation in contract law is, I think, one of the best examples. Simply in things like the doctrine of unconscionable conduct, people can't agree on what is or what isn't exploitation. And if you want to take a real politics view of contract law, even after 100, 200 years of modern contract law, we haven't come to the point where we will admit that exploitation is actually a necessary incident of contract law. So yes, we've got concepts, we also have unarticulated concepts. So the algorithm has to deal with all of that stuff. So the other thing is that attitudes, values, beliefs change over time, and that affects the legal system. Occasionally you have giant evolutionary leaps, occasionally you have missteps. I'm just skeptical as to how the algorithm is, on the evidence we've got, how it's going to deal with all of those things. So I guess in closing, what I would say is that a lot of things would have to happen before the legal singularity should become an accepted thing. You would at least need some sort of international treaty protecting human rights. You need some domestic instruments. And so I guess in closing, skepticism, I think, is healthy in this context, and we should call for safeguards. Thank you.
Okay, our next speaker is going to be joining us via Skype, I assume. No? It's Lyria Bennett-Moses from the Faculty of Law at the University of New South Wales. And she's going to talk to us about her paper titled Not a Single Singularity, Understanding AI in the Context of Judging. Okay.
Thank you very much for having me and allowing me to present all the way from Sydney, Australia, to global warming. Nevertheless, I hope you all have a fabulous time at Cambridge. I wanted to present on the idea of a legal singularity and what that might mean and what that might look like. So starting out with the idea of artificial intelligence, this term is somewhat problematically used when applied to the legal literature. So in computer science, it represents a field of inquiry. But when the term's used outside that context, it's problematic for several reasons. So how do you measure it as a lawyer looking into that field? Often people do things like talk about a kind of Turing test. Does the machine perform in the same way that behind a curtain you might believe it's a human? In other words, can it simulate humanity? But part of what I'm going to argue in this paper is that the simulation of humans, particularly human lawyers, is not actually the same thing as the real thing, even if it can pass a Turing test. The reason I find the concept of artificial intelligence to be the wrong one is that it's anthropomorphizing, but worse, doing so within a particularly positive frame, which is this idea of intelligence. So whatever machines are able to do, or whatever this field of computer science produces, is not going to be intelligent in the same sense as when we speak about humans. But the difference between machines and humans, irrespective of how advanced the technology moves forward, is that computers will always perform in line with their programming. One can intentionally produce randomness, but one cannot, if you like, produce rebellion, which is quite different to what one might encounter with humans. So bringing this back to the legal context, for example, judges have often shifted course. They've often tried to change what had been understood as the law. In other words, they've rebelled. And that is something that the simulation of which is not ever going to be able to do the same as what the judges are doing. So instead of the idea of artificial intelligence, a different concept that I like a little bit more is Roger Clark's idea of complementary artifact intelligence. This term recognises that computers perform well at some tasks, typically those requiring reliability, accuracy, and/or speed, and are most useful when there are issues of cost, danger, or mundanity, but still require some kind of human direction. So the idea of building smarter machines is then not understood as a race against humans or a measure of how good are the machines relative to humans, but rather as understanding what produces optimal human-machine systems that interface effectively, efficiently, and adaptably with both humans and other artifacts. We then come to the idea of the singularity. And this is how it is often sketched. There's a linear sort of thing. Humans don't improve all that much over time, whereas machines sort of take off and transcend us. My concern about this is its dimensionality. So this is suggesting a kind of linear path where intelligence is measured on a scale perhaps like IQ, from sort of 0 all the way up to some kind of superintelligence. So instead of this sort of one-dimensional idea, and I now want to move into the idea of legal AI, or AI applied to the legal field, I'd like to think of it more in the sense of what kinds of things can it do? What are the different ways in which we might want to measure its performance, rather than a sort of one-dimensional race? So the first dimension we can think about is simply the idea of, are there useful tools that can be applied, for example, in ways that increase access to justice or reduce the cost of providing legal services? And these are not easy. So even along this dimension, work is required. There are plenty of bad apps, if I can call it that. And I give some examples in the written paper, one in particular that was produced by Victorian Legal Aid. But it's possible to design things poorly so that they aren't easily updatable, so that they don't reach their target audience, or because they're clunky and hard to use. If you build apps like that, then they're not replacing human lawyers. They're not even helping human lawyers deliver necessary legal advice. But it is possible to conceive of projects that will do this better and better and broaden out the space, if you like, that is covered. And there's a number of sort of projects underway that are purporting to do this. One is DataLex. So DataLex is a project being run by AustLII, which is the Australian Legal Information Institute. They were very early into the legal expert system space, but have sort of resurrected the DataLex project more recently. This is the idea that you can rewrite statutes with hyperlinks to the actual statutory text, but rewrite statutes so that it operates, if you like, as a chatbot, as a Q&A. Now, the idea of DataLex, and it operates under the AustLII Communities Forum, is that this can be built out as a legal tech community, right? Everyone can go into the system and add more of this code that therefore turns more statutes into this sort of machine readable version that allows the machine to turn it into a chatbot. And if enough people participate in this project, one could imagine potentially doing this for all of the Australian statutory corpus. This is very much in line with something coming out of the public service in Australia, but also elsewhere, which is the rules as code idea. In other words, why not do this ex ante? Don't wait for an OSLE project. Instead, start out drafting legislation in a way that is machine readable, either alongside the human readable version that we're all used to, or as a supplementary product that is transparently published and therefore made available to people building regulatory code for their own systems, or for people wanting to test eligibility for government benefits against a government-run portal and so forth. So all of these ideas are really about expanding along this dimension. Let's build out this space. Let's have more tools and more tools that are useful in providing legal services. One can also look at that dimension in a slide like this, which seems to grow every year. Lots of different projects solving lots of different parts of the puzzle. So not only the sort of expert systems I've spoken about, but all kinds of other legal services, from systems that can automatically read contracts and pull out relevant clauses, to systems that can do discovery and so forth. And there's this broad landscape. And again, this is all along that very much that first dimension. We have more and more useful tools. But not everything that is created is useful. One has to ask for each of them, does it solve a problem? Is it well designed? Is it actually helping? This is now moving on to our second dimension, which is the question of capability. And it's not independent of the first dimension, but obviously related to it. But the question here is that's being measured is different. What can tools accomplish? What can they do? So one starts out, for example, with pre-programmed logic, like expert systems, and they can do some things really well and not do other things. So the rules as code movement, the idea of rewriting legislation in machine-readable format, will allow people to, for example, find out, perform very basic calculations for welfare entitlements, for example, but won't tell you whether you're acting reasonably and so forth. It can't interpret. But nevertheless, that doesn't not make it useful. It's still there on the first dimension, and it's still a capability on the second dimension. The point is, it only takes you so far. It can't deal with, for example, discretion. So you have then tools that do things like machine learning, which is useful for predictive analytics, right? So you might be able to predict, am I likely to win in the litigation? You might even be able to predict whether conduct is reasonable based on natural language processing from historic data combined with a sort of machine learning predictive tool, and be able to say, given these facts, is it likely the conduct would be found to be reasonable, would be found to be negligent, and so forth. That adds a new capability. We can now build tools that we couldn't before, and then there's still that question on the first dimension, do we do it? And do we do it well? But we have expanded the capability. Now, machine learning also has limitations. People have written on various things, from the challenge of bias to the inherent conservative nature of machine learning, because it's always looking back to historical data. It doesn't predict a break from the past, but nevertheless adds to the capability. And natural language processing similarly means we can now analyse judgments, analyse text in ways that we couldn't previously. So that's very much the second dimension. The third dimension, and you have to imagine this coming out of the page like a Z-axis in a three-dimensional grid, and again is not independent of the other two dimensions, but is something worth thinking about separately, is the question of appropriateness. In other words, should we use this kind of tool in the context for which it's been designed? And there are absolutists here, like Volokh, who suggest that that isn't even a question. If a tool passes a Turing test, if it can fool us into thinking it's as good as a human, then who cares? But there are others, and important voices here, that say, no, it's not just the capability, if you like. There are other questions or other times we need to be cautious about using different tools. Weizenbaum, who built the doctor application, the sort of psychoanalytic tool, talked about the fact that the tool wasn't wise. And I think we can talk about the same kinds of things in law. Is simulation or prediction the same as judgment? Is it important to retain the contestability of decision making so that people can argue about decisions using the language of law and not simply the language of data? Do we retain an internal perspective on law where people see legal rules, and judges in particular see legal rules as things to be followed? Do we have problems with particular kinds of tools like machine learning that are methodically different and alien to the kinds of logics we expect to see, particularly in judicial decision making? Can we think about these tools as ethical in the same way, and do we need them to be ethical? All of these ideas are not mine. They're already in the literature and cited in the paper. But the point that they all make is that it's not just about the end product. The process itself matters. In much the same way, and in the case of elections, that we don't say, well, we've got the polling data, let's not bother with the actual polls. The process is what is important here. Now, can one say that that means that all of the tools to date are never appropriate to use? Of course not. There are many contexts in which tools are appropriate to be used. But what the point along this axis is that we haven't gotten very far along this dimension. We haven't yet built AI tools that can replace judges, for example, because they can't have the same kinds of process. There's something missing there. That means that for various different reasons, we're not comfortable with it replacing judges. Does that mean it can't be used for any kind of dispute resolution? Well, no. We already allow people to step outside the court system, for example, using private adjudication mechanisms. And for the same kinds of reasons, as long as there is sufficiently informed consent, I don't think we should have a problem with people choosing to use these kinds of tools if that's how they want to resolve their dispute, as long as there's fully informed consent. It isn't just a question of the size of the matter, though. For some people, really small matters might be important, and I think, therefore, we're not yet at the level along this Z-axis where we can outsource even all small claims to an automated system. Now, as I said, there's a variety of process challenges along this dimension, and we're unlikely to resolve all of them at once. It might be that some of them can be resolved by some kinds of new AI before others can. So again, I don't see this as a single moment of singularity. Rather, instead, there are, as the technologies develop, we get more comfortable with potentially more delegation to these kinds of systems or not. I'm leaving that question open. But again, I'd rather not see it as a one-off, once and for all, but as, moving along and expanding out the contexts in which these tools might be appropriate. So the final step is, if you like, the future imaginary. Can we make further progress? What kinds of new kinds of AI might shatter through the challenges that have been raised in relation to the appropriateness of automated decision-making, particularly in the context of judging? So it's not going to be the pre-programmed rules, it's not going to be data-driven inferencing like machine learning, and it's not going to be the simulated production of text like natural language processing, but could it be something else? So one thing I suggest in the paper is the sort of imaginary of uploaded brains. If we could take current judges and completely upload them into a silicon brain or into a physical robot, would that be acceptable? Would that overcome all of the objections? I still don't think it would overcome all of them. It would overcome some of them, provided you could sort of test the artificial judge to test that it really did think and process information in the same way as the original human. But there would still be challenges. It would still be inherently conservative. If you imagine we had an uploaded judge from the 18th century, we wouldn't necessarily want that judge deciding modern cases. So there would still be real concerns to raise about this. But, ultimately we could ask perhaps whether people believe that the machine judges share a similar consciousness to themselves, but are also similarly oriented in current moral and social understandings. And if we could ever get there, and I can't even imagine what that AI might be, then maybe we'll have broken through all of the barriers. But my prediction, if I have to make one, and this is a hard space in which to make predictions, is that we won't hit some kind of magic single moment legal singularity. We'll simply make progress along the three axes in ways that are related but also different. Thank you, everyone, and I look forward to your questions.
you very much. I think three, I think quite sceptical papers about legal singularity. I share that scepticism, I have to say. I think we'll basically just open up 2 questions and try and get some discussion going. Does anybody want to start? Okay, so I guess I have a question, actually, first of all, for John. The title of your paper talks about resistance, and you began to talk about that a bit at the end, but didn't really get into it. I wonder if you could possibly give us some of your thoughts on what resistance to algorithmic governmentality in this kind of context would look like.
Yes, I mean, I'm sorry you got the wacky paper first. I thought I was sort of on third, so I give you the more speculative stuff. I suppose I looked further into the future, a future which I agree may well never happen. But if it were to happen, I think the issue of resistance is the important one. And I have a section in the paper, I've started writing it, but I didn't present it, which talks about our puny efforts at resistance. It seems to me that the way we think about these things involve ideas of consent, which is pretty puny because we know that people are willing to give consent. We've done it ourselves. Panic Christmas shopping, you're going on the site, yeah, consent, whatever. You're giving it all away. That doesn't help us. Privacy generally doesn't really help us. We think about humans in the loop, perhaps about being a way of ensuring that we can resist some legislation about humans in the loop. If we can keep a human in there in the supervisory capacity, is that a basis of resistance? I think it's not. I think the whole idea of thinking about this through a governmentality lens suggests that our way of thinking about things changes profoundly. And I think there's evidence from those systems, Compass and Heart and those sorts of things, which have humans in the loop, that there's still a change in the way we think, and a change which is perhaps not for the best. I suppose the other forms of resistance are simply about breaking up the giant tech companies that are doing this to us. And I'm interested to see the minister from France who was talking about radical changes and so forth. I guess we're thinking about those sorts of things. As I said, my title for the heading of this was our puny efforts. We need to do more.
Okay, thank you. Any questions?
I'd like to ask a very narrow point of LIDA, but if I've pronounced your name correctly. You mentioned about using machine learning and predictive analytics.
Oh, sorry, I think we have a microphone actually, so that she can hear us. Okay.
Thanks. You mentioned using machine learning and predictive analytics to determine the difficult question of reasonableness, and we've talked quite a lot about these very open standards and the difficulty of coding for these things. What data do you think that machine learning might draw on to predict reasonableness? Do you imagine that would simply be an exercise in looking at past case law, or could it be more imaginative, more creative, and draw information about social norms from different spaces?
So the logic of machine learning is quite different to the logic of legal reasoning. So when a judge has to decide a question of reasonableness, sorry, I'm getting an echo in my speakers. So are you getting it okay? I'm going to take this off. When a judge has to decide reasonableness, they look in a particular kind of way. So there's particular doctrinal things they can look at. They can go back to historic case law and they can say, well, this case is similar and that was reasonable, or there's this distinguishing feature and so forth. The way machine learning works does it a very different kind of logic. So it's not doing it in the same way necessarily as a judge would do it, but you can nevertheless take a lot of historic case law, not list all the relevant facts, or get natural language processing to extract the facts from the written judgments or elsewhere. And then you can try to say, well, what are the patterns there, right? And the patterns might not be things that the judges actually express to be relevant. They might be completely different things. But nevertheless, it's possible, hypothetically, and one has to sort of run a test to see if it works, to do that exercise and be able to predict with some particular degree of accuracy whether or not conduct would be found to be reasonable. And you can then test that against, you know, particular cases from a data set where the machine didn't know the answer until after the algorithm is run, and see, you know, what is the false positive and false negative rate of that. Now, is it doing this, as I said at the beginning, it's not doing the same thing as what a judge would do, but it's nevertheless potentially predictive. And they have managed to predict a lot of different things using these kinds of methods. The question is, what, for me at least, is that might have a particular capability, and that might be useful for parties, for example, who want to predict the outcome of litigation and try to form a view on whether to settle or not. But it's not appropriate to use the prediction that comes from a system like that in place of an actual judgment. In other words, it might be a good capability. It might have really high accuracy rates potentially. You'd have to run the trial, but that doesn't answer the question of appropriateness.
Thank you. Any other questions? Let's put up a few, I think. I think Roger had his hand up first. Justified, it was close, but...
Well, thanks very much. I wanted to ask Larry a question. I don't know whether Dylan would have a view on this as well. And it's a question about, well, we start with humans advising on the application of legal rules or adjudicating, and then we're talking about a scenario in which smart machines are advising on the application of legal rules or adjudicating. But the in-between period is one where we have hybrid arrangements and where we have both human involvement and smart machines working in some sense in tandem. And I'm just curious whether you have any thoughts about the viability of mixing and matching humans with smart machines. I mean, in Lyria's case, the acceptability axis might be something that you would try to delegate to the human who's involved in that particular kind of scenario. But I just wonder whether, of course, you know, over-reliance or under-reliance in that relationship would be problematic. And I don't think we have any empirical experience yet of how that would operate, at least in these kind of legal settings that we're talking about.
Well, I'll start by saying I completely agree with your initial answer that I don't know how much empirical evidence we have. We have a little bit. So we can sort of see, for example, the reaction of the US judges to something like Compass. And I don't think that's a very healthy relationship. So if you get a black boxed output that says person is dangerous or person is not dangerous, there's not very much a judge can do with that other than accept it or not accept it. You can't really balance the output of an algorithm that's based on 100 data points with, you know, intuition or evidence in court. There's no sort of obvious rational way to balance those two things. The only way I think you can do it and have good human-machine interactions is where the human has a sufficient understanding of what the machine is doing alongside the limitations of what it is doing, that it can make a rational assessment of where that weighs into their own assessment. Now, that is, as I said, whether that can be done, and this is coming down to Roger Clark's idea of complementary artifact intelligence, whether you can create good human artifact systems in that way, I think, like you said, Roger, is an empirical question.
Yeah, so quick thoughts on that. Well, firstly, humans are deeply fallible, and not to harp on about the robo-debt scandal, but you know, there you had the algorithm throwing up an immense amount of false positives, and then human beings pushing forward and prosecuting to get money on debts which didn't even exist, which resulted in one suicide and a whole lot of other unhappiness. The other problem is that, you know, if you look at how it's been explicit in human history, it's been maybe less explicit at other times. Human beings, in different groups of them at least, have always sought to dominate or to get power over other groups of human beings. I mean, what else is a nation state but a competing set of elites, right? So what's then going to happen when you chuck AI and these automated decision-making systems is you superpower one of the groups, and the potential for exploitation and for the disempowerment of people who are on the receiving end of that is extraordinary. So I just don't get why we would go forward with anything like this without a whole heap of safeguards. I know the tech's going to move a lot more quickly, but that doesn't mean that the governmental decision-making also has to do the same.
John? Any thoughts?
No, I mean I have thoughts, but I don't know. I mean I think this human in the loop thing I mentioned before is interesting, but ultimately, as I say, I think it does have this sense of, nevertheless, changing the whole way of approaching things, which is a danger.
Okay, thank you. You were next.
I ask a question?
Sure.
It's a question for Dylan. Could you explain a bit more about the suicide that you mentioned? I don't understand. I don't know about that example.
Sorry, I don't think I can. It's been reported in a number of the news reports on the robo-debt scandal and some of the academic articles, particularly I think Terry Carney wrote I think at least 2 papers on it, that there was a suicide as a result of a person being pursued for debts which they didn't have. So what was happening in this scandal was that people were being pursued for so the idea was that people received welfare payments from this government authority called Centrelink, and then the algorithm basically tracked their Centrelink payments versus the income declared to the tax office, and then suggested that there had been overpayments, and that occurred sometimes because an employee was listed one way with the Australian Tax Office and another way with Centrelink, so the person hadn't done anything wrong, and so a false debt was created, which was then handed over to a debt collection agency, and then you can imagine the rest of that. It's very unpleasant.
Okay, thank you. And then yes, question over there.
Yes, I have a question. I found it very interesting that you said in the beginning that singularity from a technological or technical perspective you thought might appear at some point, but then with regard to the law, you are being skeptical. And I find it interesting because people who talk about singularity in the so-called technical sense say that this is going to be about superhumans. It's not even general artificial intelligence, it's superhuman. Now, what could it mean if a system is superhuman, has singularity, but could not do law? My conclusion would be that you're basically deferring to technical by saying, well, that has nothing to do with us. And now we're going to talk about law, but that I find extremely problematic. Basically, I'm going to push you a bit. You're saying that this whole superhuman talk is bullshit. But you're being nice and saying, well, you know, let the technical people believe that in a technical sense. But I think that's dangerous. You agree? Oh, thank you.
So I'll just briefly respond to that. I think it's I guess it's easy to believe in stuff you don't know all that too much about. I mean, it's, you know, for me as a non-tech person, the writings that I've read on the singularity do put forward what appears to me as a layperson to be a reasonably persuasive case. None of the stuff I've seen on the legal singularity I found persuasive simply because it just, I mean, so many problems just come to mind. Technical problems which you would see by being in the field. So maybe those same issues are there with the technological singularity. Maybe it will happen, maybe it will never happen. But the lunacy of just ceding the legal system to algorithms, is, you know, I mean, it's hard to understand why we would do that.
But then the logical conclusion is that technical singularity doesn't exist, because as soon as you zoom in on something, you realize, well, it's much more complex than that.
Yeah, well, it's probably one I should probably defer to tech people. But
I find that highly problematic for a number of reasons, especially from the perspective of politics, of law, because what does it mean then to defer to people who are versed in computer science and they say that they can build something that is superhuman, but that you say can't do law? What does the
lesson one of academia is always respect expertise. And so if you've got expertise in computer technology, I'll respect the expertise. But when it comes to legal systems, I would have thought that more lawyers would be a lot more sceptical. I guess we've already had a Senate commission into robo-debt. I'm sure there'll be another Royal Commission or inquiry into it. It's hard to understand how some of these things got off the drawing board in the first place, given the people in the room must have known the potential problems that would then arise.
Just one sentence, and then there are other questions. So, if computer scientists monopolize other domains of knowledge by saying that they can develop superhuman technologies, then we should not shrink back and say, oh, but that's their expertise. We should say, hey, that's our expertise. Maybe.
Could play chess and beat pretty much everyone on the planet at chess, no dramas. You create a superhuman intelligence that then regulates the lives of human beings, major problem. So there are domains where this is perfectly harmless. There are domains where this will be just terrifying.
Could I have a nibble at that one?
Please, yeah.
I mean, I think I'm in sympathy with your view. I do believe that as lawyers we should make it clear that it's not possible to do this. I personally think it's not possible to do it. I think law is essentially a social phenomenon. I think that machines cannot pick up that nuance. I've just published a piece that's in the current edition of Legal Studies, which explains in more detail why I think that the whole procedure isn't possible. But I suppose in relation to what I'm thinking about now, the democratic stuff, it is about the superhuman. It's about a machine saying, I can determine what the hive mind is. I can measure the hive mind. And I think that's slightly more worrying even than machines trying to reproduce a social thing.
That's what you mean with performativity, that even if the machine can't do it, if everybody believes it can, it has an enormous impact. And I think there are many computer scientists who have an enormous laugh at Kurzweil's idea of singularity. And we should not defer to a part of computer science. We should call it out and say, okay, what are you saying? And look to other people within computer science. But please.
Okay. Thank you. But we'll move on. I think we have a couple of people who have put their hands up. I'll just go in the order in which I saw them, I suppose. And the first one I saw was this gentleman over here. And then
I have a question for Dylan. You mentioned in your talk the risk of over-enforcement for copyright, and I see that also in many other fields. So, for example, in Germany, the tax authorities also use automated systems in order to detect tax frauds. I read recently also that in Australia, they installed video cameras for highways in order to detect people using cell phones while driving. And my question is, do we need maybe special safeguards for this kind of over-enforcement or total enforcement? Maybe that's kind of a new question because so far we have dealt only with the opposite, that laws are not enforced and maybe laws are not really made to be totally enforced.
Yeah, and I mean, I agree with what you're saying. I think, I mean, the problem is that we articulate a rule in a particular way. We don't expect, and we haven't really expected, that the rule will be perfectly enforced. So we don't really have a great deal of thought or theoretical knowledge about what happens in a perfect enforcement system. So we really need to spend some time thinking about what that then looks like, what kind of safeguards that you would put in place. I mean, think about things like contract law is an easy one to use. The doctrine of illegality within contract law. Illegality plays a mediating role between saying, look, a statute says this, your contract interferes with the statute in this way, but we're going to balance the rights and interests to decide whether to enforce the contract or not enforce the contract. So sometimes, you can't enforce the contract at all, hard rule. Other times you can because the justice suggests that you should. The danger of a perfect enforcement system in property is a lot of productive uses which are technically unauthorised and against the rules would then be forestalled. It's like if you set a rule around your property saying that no one can enter my land without my permission, and then your neighbour's kid hits the cricket ball or tennis ball over the fence and wants to go retrieve the ball, but they can't do that because you've got this rule saying no one can enter the land without my permission. Unproductive. and unproductive for the kid to have it go and try to get the permission. Maybe you're not there, maybe there are other reasons. So, yeah, this over-enforcement system is problematic, and I'm increasingly starting to think as we go through this discussion that what we need is some sort of human rights ethics framework at an international level, dealing with AI and technological development, and likewise at a domestic level. And that particularly as a copyright scholar, many of the international economic treaties probably need to be rethought and reconsidered along these lines. For the moment, if you take copyright, the debate's really been about, can AI enter the system as an actor with property rights allocated through it to a human being? We haven't really come to deal with these issues of complete enforcement systems, which I think is nightmarish. Where we've seen that kind of before was with technology protection measures. And what eventually happened was we had the Stevens and Sony decision in Australia in the High Court in 2005. Okay, that was rapidly outmoded by a change in legislation. But the High Court had to draw a hard line on the enforcement of these TPMs because they started to interfere with fundamental property rights for consumers. But then eventually what happened was that the companies discovered that if they were too harsh with these TPMs, the consumers would push back, so they stepped back.
Okay, thank you. I think the question of over-enforcement is interesting. I think if you want to know how people react to over-enforcement, look at how people have taken the introduction of video referees in football, which is, everyone keeps saying it's destroying football because things that are technically offside but actually people would have got away with are being flagged. Anyway, it's pretty bad. The next question would come from Sui Leng, just up in the second row there. Okay, Zi's going to bring you the microphone.
Hi, Sui Leng Harris from the Legal Education Foundation. I wonder whether, and this is sort of going back to the previous question and discussion, I wonder whether part of what's happening here is that the discussions around AI are surfacing some of the inadequacies in how law understands itself, lawyers understand themselves and understand legal expertise, and whether perhaps one step in resistance, as it were, and certainly a constructive and important step, is for lawyers to better articulate what is legal reasoning and what is legal expertise, and to therefore, from that, be able to identify domains that can or should be automated, that might be able to be, handed over to AI, versus domains which have a sort of human quality that ought not to be handed over to machines. And just a brief plug in that vein for a report on digital justice by my colleague, Dr. Natalie Byram, who's our Director of Research and Learning at the Legal Education Foundation and has been looking at the move to digital courts and tribunals. And in order to assess the impact of that shift in terms of access to justice, Natalie sets out careful analysis of what is access to justice based on the case law, and from that identifies a number of data points that could be collected and used to help assess what is happening in access to justice terms in these digital systems.
Thank you. I absolutely agree on Natalie's report, by the way. So if anyone has a chance to read it, please do. That question, I suppose, is really for all three of you. Yes. So I guess we'll start with John, then we'll go to Dylan, then we'll go to Larry.
Well, I certainly agree that law has been misinterpreted by AI people. I think the problem started in the 80s and the 90s when AI people came along in that first flush and thought law is all about syllogistic reasoning and therefore it's ripe for us, and they had a go and they made an absolute mess of it. They didn't understand that law is, as I mentioned before, a complex interpretive social process. But I do think you're absolutely right as well to say that there are certain areas, perhaps in administrative decision making, but certainly things like eBay. I mean, the largest dispute resolution mechanism in the world is eBay, which is an entirely online virtual system. So it has its uses and its values. But I think if we think about what adjudication is in a proper sense, we have to go sort of thinking up the scale to the full panoply of a court and rules of evidence and transparent reasoning and so forth. As you go further up that scale, the value of any AI approaches, I think, diminishes.
Yeah, I think that there's an identity crisis that law will have, and I guess maybe one precedent might be the movement of economic scholars into law as a discipline at the universities, when they thought that everything in law could be, put down to equations. They say law is economics is a dismal science. Law is much the same, but it's not a science. So, sorry, bad joke, but I mean, you can't reduce everything in law to an equation. Simply, there are things that are just too complex, too problematic, just non-mathematical. Astic and Cobell in Australia in the High Court this year on unconscionable conduct, when the High Court split 4-3 on the question of exploitation of Indigenous Australians in a commercial system in outback Australia, where the Indigenous community was, the Aboriginal Australians were subjected to a commercial lending system which basically involves surrendering their bank cards, personal details, etc., and this person getting access immediately to their bank accounts. It's horrific. But the court split on whether that was unconscionable or not, because the intentions behind it had been good, to avoid particular social problems, but the way it played out was pretty bad. So it's the sort of thing where it's a very complex case, and it's a case which really goes to the heart of the Australian legal system, like Al-Kateb, for example, the question of indefinite detention of asylum seekers who aren't proven to be refugees. Those sorts of things are very difficult to put down to some sort of equation. But there are a lot of other legal decisions which are just routine things. Some disputes are routine, and maybe they can be, I hesitate to say, possibly they could be automated.
Okay, thank you. And then Lilia.
I want to go to the question of language and how we describe the two different sides of this particular equation. So we talk about legal expertise, but when we think about what lawyers do, or what good lawyers do, and certainly in particular what judges do, I think it goes beyond a question of expertise. So there is expertise involved. There's also a particular methodology that takes place within a particular culture. So I would say that, rule of law values, rule of law culture, human rights comes in there as well, ethical orientation, the argumentation and the idea that two sides each get to represent the best view of their case, which is then put before a judge and so forth. There's a whole set of things that goes on in the way the legal system works that goes well beyond a simple question of, is a particular person an expert in something or not? And it's the same problem when you go to the other side of the equation and you look at the label we put on all these technologies, this idea of artificial intelligence. Because my question is, I suppose, that's a really interesting choice of word for me. For machines that fundamentally execute a particular process, they're simulating things that we might in humans call intelligence, but that's not the same thing as being intelligent, or for that matter, in any real sense, thinking. Machines learn without thinking. Humans learn by thinking. They're not the same thing. So I think if we really understand what it is the machines are doing, and they're doing fascinating and important things that can play a really important role in making aspects of delivery of legal services and the legal system a lot more efficient. But if we really understand what the machines are doing and we go away from sort of the mystery of the idea of artificial intelligence, I think we get to a much better idea of where they play a role and where we need the humans to continue to do what they do with their expertise, but also with their cultural and social orientation.
Thank you very much. We have a bit of time left in this session, so I think there's a question down at the front just here.
Hi. Sorry, I'm not from the law legal background. I'm just wondering, when you mentioned about using machine learning to helping like lawyer or judges to dealing with the legal case. So my concern personally is so how you preventing the bias happen? So data will always has a bias. One famous example is Amazon. They're using machine learning to helping recruiting engineer, and it end up they always filter out the female. because historically, the best engineer, they're always male. All right? So this thing will always happen, even in the legal case, I believe. So how we measure this wouldn't happen in the real case?
That is quite a technical question, but I think we can probably ask, if we assume, or we can probably reasonably say that the legal system has some degrees of biases in it, it has historically been discriminatory, how could you perhaps introduce automation into the legal system without reproducing those effects? Any thoughts from any of the three of you?
Well, I attended a conference last week, or a workshop last week, about safety standards in automated vehicles, and I was struck by the number of standards that there are in place around technical things like what, you know, the level and quality of training data and so forth. And there is room, I think, for lawyers to get involved in that and say, well, you know, look, this shouldn't just be, is it sufficient? Are these standards for the production of the algorithms? Are they sufficient for technical reasons? We should also get involved by saying, are they sufficient for, you know, rights protection reasons, for looking after issues of discrimination and so forth? So there's a room, I think, for lawyers to get involved in technical standards for the development of these things. I did put that to the audience, which is largely technicians, and they thought it was a bit odd. But that doesn't mean we shouldn't keep doing it.
Does anybody else want to come in on this? Yeah, Lyria?
So the challenge of bias is a challenge, as you mentioned, of the legal system broadly without AI, but it's also a very different kind of challenge when you're dealing with any kind of data-driven inferencing. So whether it's just humans doing statistics and drawing inferences from that, or whether it's a machine doing machine learning, you're going to get particular kinds of bias, but you also get, interestingly, the means to make much more conscious decisions about what you do with that bias. So we have bias because we have a biased society. So the data we have is inherently collected in the context of that society and so displays bias. But once you know that and you understand that, you can make very explicit choices. You can decide, for example, to take into account a particular variable and therefore reduce the disparate impact on an otherwise disadvantaged group. So I'm going to go back to the robo-debt point, because what the New South Wales is doing with New South Wales government is doing with its debts is in many ways the opposite of robo-debt. They're using machine learning to try to detect vulnerability and then not chase those debts and prioritise the chasing of debts of people who are A, likely to pay, and B, likely to pay without ending up in a terrible life situation. The challenge is, have they tested it? And this is an open question, I don't know the answer. Have they tested it, for example, to see whether their vulnerability measure has a bias in gender, in race, or in anything else? And unless you actually test it and know, even something that's seemingly good can have a differential impact on different groups. So it's a question of, does that matter? And then what do you do about it? But the wonderful thing about machine learning is you choose the metric against which you optimize. So you can remove the bias if you make a conscious decision to reduce particular kinds of disparate impact, for example.
Thank you. Anybody else? Any questions? Okay, we have a few actually. Yeah, okay, so I saw you first, so we'll go with this lady at the back, and then we'll come down the front and then up to Colin.
I wonder if the panel has a view on what all this means for the teaching of law. I can't speak about the English system. In Scotland, the requirements for universities to teach technology are pretty minimal. Do you think that we need to do more in terms of teaching, for example, legal theory and incorporating some kind of basic understanding of AI into the mandatory courses that are taught for the purposes of a law degree?
Excellent question, thank you. I guess you all teach in law schools, so we can basically open up. I think last time we started with John, so we'll go from the other end and start with Lyria.
So I can say what's happening at our university. We have done a curriculum review of all core courses to work out what is the basic technological knowledge that a student needs to have in that particular course. So if you look at something like AI or data-driven inferencing, we've introduced that into courses around administrative law and how it's used in decision-making there. And we've also introduced it into the courses on the criminal justice system and the kind of risk assessment tools that are used there. So there's that issue. There's then electives you can introduce. So there are particular electives around this. I teach a course in law and technology. I'm also introducing a course in probability and statistics in law. And then finally, for people with who want particularly deep expertise, we actually now offer a dual degree program in data science and decisions law, as well as computer science law, which has been around for some time. So that's sort of a much deeper option for students that want to go the whole yard.
Cool, brilliant. Dylan.
Yeah, so look, I think that one of the interesting things about the emergence of artificial intelligence in recent times is how it's re-enlivened disciplines like philosophy and I guess legal theory as well. I think what will have to happen is that we will have to fundamentally change the way we teach law, that either artificial intelligence is embedded in a number of the subjects that we teach, so that we change the curriculum in contract law, intellectual property, and many other subjects as well. Or we have a separate subject dealing with artificial intelligence. One of the other problems we do have in Australia is we have simply too many law schools. So that might at some point require a rethink, though I'm not calling for that to happen today. I do think that we would have to address the impact of artificial intelligence on the labour market. And so that we would have to really think about how we skill up graduates to do things that AI can't do, and what it means for entry-level employment. So that's a really big issue in law schools. There's a massive difference between teaching in a first-year program, where the students are incredibly relaxed, and teaching in the later year classes where the students are hitting the job market. Now, it's reasonably good in Australia because the economy is pretty good. So if the economy goes slightly south for tech reasons or other reasons, that angst level will go up. So there are a number of social, technical, pedagogic concerns that would have to come in.
John.
Very quickly, I mean, I think this what we're talking about here is a disruptive technology. It's a fundamentally disruptive technology, and it's going to disrupt legal practice. There's no question about that. I don't think that lawyers of the future will be anything like lawyers now. I think there'll be many less of them. We already see that the role of the paralegal is disappearing. There's a multi-million-dollar market in programs to assist lawyers at various levels and so forth. I think if you look at tables about occupations likely to be superseded by machines, I think lawyers are about halfway down, slightly below cloakroom attendants. So I don't think that the future for lawyers is a very strong one in the new world. I think we have to recognise that. We have to say that some bits of law are capable of being computerised, if you like. Other bits aren't. We have to develop proper understandings of the nature of what law is and what the difficult bits are, what the political and moral bits are, and what bits we can cede to machines. I think law schools are very slow at responding to that. My own law school, time for a plug, has got a new Masters in Law and Technology, which we hope is going to address those sorts of issues. There wasn't a lot of competition when we looked through doing our research on it. I think there will be many more in the future.
Brilliant, thank you. And then there's a question down at the front here.
Sophia Adams-Barty, Director of Strategy at Simmons Wavelength. I just want first to make a slight observation. It seems to me that the last two questions dovetail really beautifully, which is there's a really significant problem with the use of AI-based tools in the law when the literacy within the profession, both at the practical end and within the courts, is almost zero, about questions of have you cleaned that data? Does it come from dirty data? What's its potential? What does accuracy look like? What do you mean by probability? None of that makes any sense. I speak as the ex-director of policy at the Law Society. I can say that freely now in a way that I might not have done previously. But onto my question. It seems to me, and I would love the panel's reflection on this, the more I have these conversations, the more I feel that we're just in a massive clash of purpose, which is in the sciences. and particularly in computer science, the object of the discipline is to seek to get to a point of absolute accuracy, right? To get that probability as absolutely finely honed as possible, to get to a definitive answer. But it feels to me like the practice of law and the delivery of law within our social structure is one of fungibility, particularly where we have moral evolution and values changing. The common law specifically speaks to that. And the more I hear of this, the more I just feel that these two, we're awfully diplomatic about the fact that maybe we can develop a shared taxonomy and so on. But I just wonder, are we all being a little bit too optimistic about the fact that the very core purpose of these two disciplines are at counter to one another?
Dylan.
Well, I'm not optimistic at all. I'm deeply sceptical. I think that this rush into automated decision making is, again, I was really going to close with saying, don't drink the Kool-Aid, because basically, this is faith without enough evidence, and the evidence you do have actually is actually pretty bad. So I'm definitely not an optimist, but I agree. The disciplines are fundamentally different. Law tends to look backwards. Computing science tends to look forwards about what is possible, and you make the point about accuracy. That's it's an excellent point. I think it's okay that the interaction between the disciplines is polite, but at some point we do have to sit down and just accept the hard realities that the end games and the drivers are different. And even within law, you can't really say that we've all got the same agendas. We don't. Law is a whole set of competing actors with very different agendas, very different values. And law is this constant struggle for what will the rule be, how will the rule apply. And we have very different views on that, and for different reasons, because our interests lie differently. So, how you code that, I don't know.
John.
Well, I've had 4 or so years' experience working on a Leverhulme interdisciplinary network with computer scientists or technicians, engineers, and it's been really difficult. I mean, really, really difficult, because we do speak different language, we do have different understandings. But I would say many of them are interested in the issues, that they're not simply guys with screwdrivers in the top pocket or whatever. There's a whole range of people who are very thoughtful, and I think it's part of our job is to give them the vocabulary and the concepts to use in their work, in exactly the same way as it's their job is to make their world understandable to us, so we can put our bit in. So I think what we have to do is the very, very difficult job of sitting down with people from different disciplines and trying to develop, if not a common language, at least an understanding of each other's conceptual world.
Okay, thank you. I think as someone with a background in law who works in a computer science department, I feel the need to find a way to communicate across those disciplines very keenly. Lyria, please, your thoughts.
Yes, I think that point about the different sort of motivations and goals of the two disciplines is a really important one. And let me just hone down to a minute on that word accuracy, because I think that's really helpful. So when you have something that's predicted, you can take different accuracy measures, false positives, false negatives, and so forth. And that's useful and interesting, and even useful in a legal context applied in some situations. But when you take a judgment, when you look at a judgment from the Australian High Court or a Supreme Court of any country, you don't say, "Wow, that decision was really accurate," right? You don't say they predicted themselves really well, they got it right. You say other things if you like it, right? You say it was really perceptive, or you say it's taken the law in a direction that is protective of human rights or not. You can say these things about it. So we argue about law in very different terms, and what makes for good in law is often quite different for what makes for good in machine learning. And I just think that is a really important observation, from which I will go to 2 very brief places. One is how important it is for lawyers to understand what these tools do, at a sufficient level of detail, not learning programming, not this lawyers learning to code stuff, but to understand the nature of the kind of inferencing they're doing, so that they can ask the right questions about appropriate usage, because that is really important in legal education. But the second thing is the importance, I suppose, of the system in deciding what tools to adopt in what circumstance, to be conscious, very conscious of when lawyers want something like accuracy, and there's times that we do, right? So potentially in discovery, choosing what kind of documents get discovered, potentially that is what we really want. But in a lot of situations, that's not actually the end game. And where it's not the end game, I don't think it's appropriate to use tools like machine learning.
Okay, thank you. We'll take two more questions. First one from Colin, then we'll go to John. And the eagle eye among you may have noticed that Simon Teakin has arrived, and he'll give his talk after the session before lunch.
Thanks for raising these questions. And building on what we've just been talking about, are there any ethical red lines for you? So you've mentioned the paralegal tools, research tools, debt collection tools. And going back to the lady's map on the screen with all the territory of all these different tools, there's perhaps dozens there, but there's maybe going to be hundreds in the next few years. What are the red lines for you? Just because we could, should we?
Who wants to take that first? Any thoughts?
Well, the one concern I've got increasingly is this, well, many concerns really, but privacy is a huge issue. And, privacy, confidentiality, there's a further confidentiality problem that's come out of the robo-debt issue apparently in recent days. I think that the big issue is that, for this system to operate, it needs access to a whole host of data, but we are the data. And many things that we do, we might not necessarily, they're not wrong things, but you wouldn't want everyone to know about. So privacy, confidentiality, human dignity, all of that then gets endangered. But I think there are many red lines here. Red lines, red flags. Yeah.
It's a great question. A very good question, really. It's rather difficult to answer, I think. I think privacy's gone. It's long gone. It'd be nice to protect it, but I think it's too late. I think there are certain decisions which are, I suppose, are about justice, we think, and others are about convenience. We're happy enough to have commercial settlements, send back goods or whatever, sorted out by an algorithm. But I think if it gets towards those sort of justice issues, I don't know what they are yet. We'd have to spend some time trying to work out what they are. Obviously, there's some clear, bright lines. Liberty, etc., would be one of them. But beyond that, I don't know. It's a really important question.
Always be in the loop. Should a human always be in the loop?
Is that enough, even if they are?
That's a good question. Lyria, red lines.
I think it's a really contextual question. So I don't know if in the abstract I can say this is my red line. I want to know what the tool is and what it's being used for. But I'd say what I'm trying to capture in the difference between at least my second and my third axis is the importance of that question. That it's not simply a case of how wondrous and what is the capability of the tool, but the importance and necessity of saying, for that tool in this context, is it appropriate to use it? So I don't think it's a single red line. I think it's a red line we have to answer every single time we put something into application.
Okay, thank you. Then our last question will come from John.
Thank you. First, two contextual points in a way, one of which relates to the last discussion. The first contextual point is that there's a really strong whiff of technological determinism about this whole event. It's basically saying this is definitely going to happen, and it subscribes in a way to the technological narrative, which is that it's technology that drives history and so on. That's the first point. More importantly, the point about the interdisciplinary thing and the rest of it. I'm an engineer, and I'm very struck by how deferential lawyers are towards this technology. If you look at this from even a remotely informed historical perspective, what you'll notice is that we are, at the moment, in the middle of another tech boom. And the tech boom in this case is quotes, machine learning, disguised as AI. But the truth of the matter is, this is a very flaky technology, really flaky, not just in its applications in terms of bias and other things, but also right at the heart of it. There's a really serious, unsolved theoretical problem at the heart of machine learning, which is the gradient descent problem. So in these discussions, we have different disciplines. It could be humanists, sometimes it's now lawyers, and that's saying, well, this stuff is absolutely wonderful, and our problem is how are we going to adjust to it? And I think a certain level of detachment and skepticism, this is the cryptocoin de nos jours, as it were. And it won't last. Like the other booms don't last, we run out of it in the end. But when you're in the middle of it, it seems very difficult to say this is actually the future and for sure.
Cool, thank you. I mean, I think actually one thing I noticed working in the computer science department is that it's much easier to explain law to tech people than to explain the tech to law people. I think a large part of that comes from people just they don't understand the tech and they sort of take it on face value of what they've been told about it. But I would very much appreciate quickly, I suppose, before we move on to Simon, the thoughts of our three panellists on John's point.
Well, thank you for that. That's quite reassuring in some senses, I have to say. But I do also feel, to some extent, if we're thinking about the sorts of issues that I was talking about, in some ways it doesn't really matter if it doesn't work, as long as people think it does, which is quite worrying in itself.
Dylan.
Yeah, I don't much to add, but I'd echo that point. It's worrying if people, whether it works, whether it doesn't work, it's worrying that people think it works, and you slide towards a tyranny of sorts. It's concerning.
And Lyria, just quickly, your thoughts, please?
I hope I'm not being overly differential. So when I talk about, for example, changing education in law schools, the reason is so that lawyers can question, not so that they can, and so they can question the particular technique used, that we go down to the level of understanding that machine learning is data-driven inferencing, essentially, and that has limitations. We don't use magic words like artificial intelligence, which give you this sort of image of, I think the word used before was God, but, this sort of magic idea of what it can do, and that lawyers are able to interrogate the limitations of tools in particular contexts, so that, for example, they don't get used where they shouldn't be because they do have limitations. So I try not to be too differential, and but nevertheless, I try to understand what's actually involved as much as I can coming from outside.
Okay, thank you very much. I'd like to say thank you also particularly to our three panellists, John Morrison, Dylan Thampaplai and Lyria Bennett-Moses, and thank you all for your questions. We will now have Simon Deacon, who's going to talk about Ex Machina Lex. Thank you.
Good.
Thank you very much. I have to drag it out of the bit. I have to drag it out of the bit.
Okay, well, I really do apologise, everybody, for not being here at the start of this conference. I was examining a thesis in Strasbourg yesterday, and as you may know, there are strikes going on in France, and I was meant to fly back last night, but had to fly this morning. It's been a fantastic discussion so far. There are some slides, but if they come on screen, then maybe I can refer to them. But I want to pick up on some of the things which have just been said in a fantastic session we just had. Including John Norton's very final point about the nature of the technology and the way in which it works. The paper that Chris and I have written for the conference, oh yes, there it is, thanks very much indeed, yeah, is about how far law can be computed. And we're trying to develop a theoretical framework for understanding both disciplines, law and, in this case, computer science, and to consider how law and technology might complement each other, might sometimes compete with each other. And we're concerned to understand, in particular, how technology has, I think, always been mediated by law. So we're accustomed to thinking of law as responding to technology. Technology works tremendously quickly, and at the moment, law is catching up. But we want to stress the sense in which even radical technologies, like blockchain or machine learning, take place within an economic and societal context that's regulated and governed by law. So certain laws, IP laws, protect intellectual property, even in relation to something like Bitcoin, which appears to be self-forming and self-regulating. Much of the underlying IP was protected by non-disclosure agreements. Something like penicillin is another example of a technology for its own time. Penicillin was a technology for the middle decades of the 20th century, for a time when there were powerful nation states, and when they were able to mobilize a scientific technology, a medical technology in this case, for the protection of populations. So penicillin, you may know, was discovered well before it was put to use. It was only used, it was only commercialized under the pressure of war and the impulsion to provide a medical technology that could deal with the implications of a mass war. And after World War II, technologies like penicillin were further developed in the context of universal healthcare. So technology is always of its time, is always mediated by other social forces. They include the law. Bitcoin is a technology for our own time, I would suggest, partly because of its more libertarian orientation, but also because Bitcoin creates many negative externalities. Bitcoin is associated with organized crime, and is associated with money laundering, and to praise it, in a sense, is to be part of a wider body of thought which questions the role of the state and assumes that society can be self-forming. Bitcoin is of our own time, but even Bitcoin can be governed and regulated. It's not beyond control. Ross Anderson and colleagues in the Computer Lab have explained in a paper using both law and computer science how it may be possible to trace the criminal use of Bitcoin. And I just give this as one example of a technology which is frequently thought of as self-organizing and somehow beyond the law, but really isn't at all. Again, if we go back to the first industrial revolution, binary coding, describing knowledge in binary terms just isn't new. The Jacquard loom is just one example of an early machine which was in essence a computer, as you can see. What the Jacquard loom did, through the binary coding you can actually see here, was to capture the knowledge which existed in society at that time about that particular industry. So what was done was to code, literally, the tacit knowledge of a whole community in guilds of silk workers. That knowledge was tacit. You had to be an apprentice for 7 years in a trade to really understand it. The point of time serving was to experience it and to acquire knowledge by being part of a community. That knowledge was preserved, often through concerted efforts to maintain its secrecy by keeping outsiders away from the guild, keeping them out. The ability of entrepreneurs to code that knowledge into the machine, of course, completely destroyed the purpose of the guild. The machine could produce high-cost silk products at low cost and standardize them and create a mass market where previously artisans had only really been dealing with elite markets. So the Jacquard loom is an interesting historical case of a kind of machine learning, a kind of coding process, putting tacit social knowledge into mathematical form with enormously disruptive implications for the economies and societies of the time, and maybe a warning to us about the implications of such a radical technology, but a reminder that it's not really all that new. We have been here before with various technologies. Again, origins of AI are very interesting. We've spent some time today talking already about what AI might become, maybe even what it is. But the origins of AI are also very, very interesting. In the 1950s, some of the pioneers of AI, like Herbert Simon, consciously tried to design early machine learning systems, or AI systems as they were then called, using not the human brain as a model, which is now the tendency, but the corporation itself. The bureaucratic structure of the corporation was used by Simon to build models for what became AI. And that's also, again, a reminder that when we talk about AI, this technology is embedded in a corporate economy, and in a sense, mathematically reflects back, a little bit like some sort of simulacrum, features of our world. We're having our own world reflected back to us in mathematical form much of the time when we talk about artificial intelligence, given its specific origins. Now, of course, we've already been discussing LegalTech and the singularity, so I won't spend much more time talking about this. But I do want to dwell on what exactly machine learning is, or at least what I take it to be. The idea that the algorithm in a machine learning program is able to adjust over time to data coming in, that it's apparently able to learn. This is, in deep learning models, one of the innovations which is driving the current debate that we're having. So it's not new to use statistical inference, but it is new to have so much more data to work with. And that's a consequence of the way the internet has created machine-readable data on an unparalleled scale. Also, there are new mathematical techniques involved in identifying algorithms which have these adaptive properties. That's new. And the third thing which is new are developments in the precise material engineering of these processes, which create scale effects, which make all this much more economically feasible. So again, the science is being driven here by what's economically feasible as much as anything. But this is a learning process, and it critically depends, again, on the ability of an algorithm to capture features of the world in mathematical form. This works well when the world is reducible to a binary code or some other mathematical formulation. Now, there are two basic ways of thinking about this. One is that the world is fundamentally mathematically tractable. Maybe the fundamental structure of the world, both the material world and the social world, is mathematical. Many have claimed this. Pan-computationism, going back again to Leibniz in the early 18th century, where we find binary coding, but also, as Giovanni Sartor has shown, a lot of interesting discussion, because Leibniz was also a jurist. Okay, we talk about jurist computer scientists. Leibniz may again be a model here. He pointed out that in many cases the law reaches solutions not by some sort of computational process at all, but by assuming, for example, that one side has the burden of proof, right? Something like that. So law uses many techniques which are not mathematical, maybe not even scientific at all, but are fundamentally dogmatic or conceptual. They're just assumed. In fact, Leibniz appears to have abandoned his pan-computationism at a certain point. Einstein probably didn't say, is attributed to him, not everything that counts can be counted, and not everything that can be counted counts. But he should have said it if he didn't, because it's a very important observation, not just for computer science and AI, but for teaching statistics to lawyers in particular more generally. Just because we can count something doesn't mean it was worth counting it. Right? This is how I teach stats to lawyers when I'm trying to explain an econometric model. I say, look, just because we could count this doesn't mean that it was worth counting it. And there are many things that we cannot count that really matter for understanding some basic economic questions about causality and correlation. There are social forces, social reference, that we are not able to count. And this means that we must always look carefully at any econometric model. The points that have been made this morning. It would be really good if lawyers could understand better the AI processes used. But that's also true even of something apparently a bit more basic, like econometric analysis, although a lot of AI is really the same as the techniques used by econometricians, just scaled up. Now, if we can't count everything, this may be pointing us in the direction of a limitation to what we come to know as AI. Now, I think that to understand law alongside AI means developing a theory of law, just as much as it means developing an understanding of AI as some kind of evolutionary mathematical process. And I want to suggest that the legal system has some similarities to machine learning in this sense, that law is a giant kind of institutional machine or social machine for producing learning. And what we should be comparing when we think about AI is not how the algorithm works compared to the human brain. We should be thinking about how the algorithm works compared to social processes of learning, including the law. And I'm using here theories of legal complexity, evolutionary game theory, and systems theory, because that body of work tells us that the law is constantly updating itself. The law evolves in a particular way. It uses the doctrine of precedent, as Carl Llewellyn argued, both negatively and positively. The law is not, as we lawyers know, I think, simply about the application of known rules to certain fact situations. Those rules themselves evolve, and they evolve in a reflexive way in the light of new information, new data from society. And litigation and legislation are among the crucial mechanisms by which data comes into the legal system from outside and then actually is coded. The word code isn't inappropriate. It's coded into legal concepts or categories So when we use a shorthand term like contract or property or employee for that matter, in a legal context, it always has a coded legal or juridical meaning. These terms don't mean the same thing to lawyers, I would say, as they mean to business people or in everyday speech. These are highly specialized juridical terms, and it's interesting that the word concept is used. The word concept is used by lawyers, but also by machine learning specialists and scientists to describe categories which are constructed in an emergent way from data. And the critical point in AI is the allocation of weights to particular indicators or forms of data that flow in from outside. And it's exactly the same in law. So if we take, for example, a practical case that all labour lawyers know about, but really all private lawyers are also interested in, I think, who is an employee? Right. Now, we labour lawyers would say the answer to who is an employee is often, well, if it looks like one, it is one, the so-called elephant test, which my students tell me every year is not especially helpful. And that's right, isn't it? It's not very helpful. But we might be able to identify, I would say, a number of indicators of employee status. Right. Do you have a boss? Okay. Are you paid a wage as opposed to a fee? Do you control your own time? Do you own assets? And do you employ other people? Lawyers have identified, some textbooks have identified about 20 or 30 indicators. And these are often grouped into higher level categories. Lawyers know these as things like the control test or the integration test or the mutuality test. And above that is this meta concept, the employee. The weighting is going on here all the time. But the weighting is intuitive. It's implicit. So when a judge says that person is an employee, they've probably taken one indicator out of probably 30 or 40, which critically tells them in that individual context whether the person is an employee or not. And as a labour lawyer, I do this. When I want to discuss the case of a certain person with the university administration, the administration says that person is self-employed or that person is an employee. We have to deal with this all the time in the university. Who is an employee? Who is self-employed? A colleague who I know works for 5 or 6 clients, not employers, at least, and also works for the university, doing pretty much the same thing, is, I say to them, not an employee. He can't be an employee if he's working for clients. He's got so many sources of income. It's wrong to say he's dependent on a particular employer. That's my view as a labour lawyer. But what I've done there is I've chosen one indicator out of many to focus on, and I've weighted it in a particular way because I think that's the decisive factor in this case, and that's my intuition as a lawyer. Could a machine learning program do the same thing? Well, in a way it could, but only if the weights are adjusted over time in some reflexive way to ensure that the algorithm is matching what lawyers do. When we talk about the algorithm predicting the outcome, somebody is an employee, somebody is self-employed, that so-called ground truth has got to be compared with how things are worked out by lawyers. It's one thing to try to identify a face or a disease using machine learning, and even there are severe limitations right now to what can be done by machines. But the point about a machine like that, identifying a face or identifying a disease, is that the disease or the face are invariant to the process by which the machine identifies them. That face would be the same and that disease would be there whether or not the machine identified it. But identifying an employee is not like that at all. The law is constructing or projecting the test of the employee, not just identifying something which exists outside the law. The law is reflexive. And in that sense, its reflexive epistemology is not at all unusual for social knowledge. The entire social realm, in this sense, consists of data which operate in a highly reflexive, loop-like way with the terms used to categorize them. And the same is not true, I would suggest, of the material world. And this is going to put real stress and real pressure on AI systems when they're applied to the social world, which is what law really is about, as opposed to the material world, which is what medical algorithms are essentially concerned with. So this is the argument we make in the paper. We talk about evolution. I can show a picture of a snowflake, and we could talk about complexity if we had a bit more time. But I think that it's important to think of law in this sense as operating in some sort of relationship with its environment, like these complex Mandelbrottian snowflakes, which are created through a kind of iterative loop-like algorithm. The Mandelbrot set is almost the simplest mathematical function you can imagine, where two inputs are combined accumulatively over the time, and critically, with the Mandelbrot set, outputs are treated as inputs in the next cycle. It's exactly the same with any self-referential system, like law. But the point about the Mandelbrottian system, of course, it's layered, as you can see, from this sort of picture. But the point about the Mandelbrot set, to show you a different picture, to go back to the snowflake, is that there is a border or a boundary to the system. What's beyond the boundary is, in a sense, chaos or noise until it's processed. Law has that boundary, and law at the boundary is always going to be fundamentally uncertain and open, and I would venture to say not readily programmable. The vast majority of cases, many decisions, can be programmed, can be understood by AI, but the innovative decisions, and the points already been made this morning, the radical decisions, maybe the dissenting opinions of a court, these are going to be much more difficult. It's going to be much more difficult to categorize those in terms that can be captured by AI. I'm not saying impossible, because I know this is an issue which computer scientists are working on, how far they can build in uncertainty or a shift in expectations or a major exogenous shock. It's not impossible to do that. Economic models do it too. But I would suggest that law works because it's open, And also, of course, if we didn't have the humanly decided cases to benchmark the AI against, the whole process again becomes a loop, but this time a loop which closes off human agency in the context of lawmaking and would freeze the law in a perpetual state that, very far from being an efficient singularity, would just be a contingent accidental inefficiency locked in as a kind of frozen accident. So we would like to pose some questions for AI about how ground truths are identified, and for the singularity supporters, exactly what optimization in public policy is. If we're reaching some kind of equilibrium, like a singularity, where's that really leading us? And the point again that's been made this morning, I won't repeat it, how exactly does the rule of law, though, differ from rule by algorithm? This needs theoretical thought, I would suggest, and also much better empirical evidence, not just about AI, how it works in society, but also about how law itself works. And law may not be perfect. Right? This morning, we're talking about cases like robo-debt, where a machine learning program may identify the existence of a debt really by reference to characteristics an individual might have, which are similar to those of other individuals, or which are averaged out in some statistical way. That's done. Robo-debt and systems like that are made to work because they save costs. The economics drives it. And saving costs is something governments always wish to do. But of course, what robo-debt does is apply that, it seems, rather crude algorithm to the most vulnerable in society. We will still be using, I think, legal judgment, but will it only be for the less vulnerable? We will still have barristers arguing complex cases in court. You may know the most expensive case in English law ever was between two Russian oligarchs. Right. And a lot of very sophisticated legal argument was deployed in that case. The social utility of the case is not the reason it was argued in that way. It was simply the wealth of the parties concerned. So there are real issues here. There are problems with law. Law isn't perfect. And in some cases, there is bias, there is error, and algorithms may do a better job, or they may help to tell human beings when there is an error or when there is bias. They may complement human activity, again, already discussed. This is not, however, to say that human activity should be displaced by the algorithm. That's a very different proposition. So this is our paper. Some of you have seen it already because we circulated it to speakers, but it's online on SSRN. We'd be very grateful indeed for comments or feedback on the paper. And it's nearly time for lunch, so I hesitate to invite any more discussion now, but I'll leave that to the chair, whoever that is, Jen, I think. But we'd be very grateful indeed for comments on the paper. Thank you.
I guess actually, seeing as it is 10 past, unless you want to take questions, we can probably break for lunch. Yeah. Okay, so lunch will be upstairs in the dining room, and it should be served anytime now. Thank you. Brilliant. Thank you, Sam.
For this first session of the afternoon, we have three tremendous speakers, each of whom is very well known in the field of law and technology research. Giovanni Sartor from Florence, Roger Brownsword from KCL, and my colleague Jen Cobb, who's blazing the trail for interdisciplinary law and computer science studies here at Cambridge. We're going to begin with Giovanni's presentation. He's presenting remotely by Skype, and I hope he can hear this and is ready to give his presentation now, if that's right. Hello, Giovanni. Can you hear me? We can't hear you. Okay.
Hello?
Yeah.
Can you hear me?
Yeah, we can hear you now. Yep.
Okay, perfect. I have to switch off the volume.
Okay. Thank you very much for joining us. You have 15 minutes, Giovanni, to give your presentation.
Yes.
Then we'll hear from Roger and Jen, and then we'll have discussion after the other papers have been presented. Okay. Thanks very much.
Okay, thank you. Thank you very much for having me. It's a great pleasure to be with you, even though remotely. And I would very much enjoy having, I would have preferred being with you today, but this was not possible, unfortunately. So I will say a few words about a new research in which I am moving on. This is ERC grant. The name of the grant is Computable Law. This project addresses the regulation of computations. So the idea is that there are today a huge amount of processes and systems that need an integrated legal and technological regulatory framework. This project aims to provide a kind of integrated approach to that. It involves the European University Institute as well as the University of Bologna. So the assumption of my project is that given the scale and the ubiquity of computations, there are, I think, something like 60 billions of interconnected computational devices nowadays. It is impossible for humans to monitor all of this computation and to anticipate their illegal or unethical behavior. And then, besides the number, there is also the speed. The number and the speed of such computations and their interaction makes real-time monitoring impossible. And then a third, but not less important aspect is the development of AI and the complexity, the adaptivity of intelligent artificial entities, their autonomous behavior, and the diversity of their deployment makes it impossible to specify hard constraints at the design stage. Until recently, it was possible to limit the possible harms resulting from intelligent technologies by putting cages against around the robots, or having always a person to accept and assess the output of an automatic and expert system. Now this is no longer feasible. So the idea that inspired my project is that to govern effectively the infosphere, the law itself must become computable, and to some extent, and it must become an internal component of such computational processes rather than an external constraint over them. So my research project fits within the research that has been done in the last 30 years within the domain of AI and law, where different models have been developed, tried to represent legal norms, values, principles, and the process of their application. So finding computable representation of legal information that can also be processed by computational entities. So the idea that is at the basis of my project is that we need to move at this stage from what might be called implicit law by design, that is systems designed in such a way that their harmful or illegal behavior is difficult, to systems that have an explicit representation of the law and can operate on the basis of this knowledge. So the basic idea is that we need to have a kind of hybrid environment involving humans and to an increasing extent also intelligent agents, which is governed by the law, and that these systems can act on legal basis in compliance with the law at runtime without direct human intervention. Such intelligent agents should not only be able to apply certain legal norms and principles, but also to justify their behavior and ask for human assistance also on legal matters when needed and feasible. So my project focuses on the creation of what we may call artificial legal agents, having entrusted with applying the law to their own and possibly also to the behavior of other agents in multi-agent contexts. They should be capable and motivated. There is also an issue of motivation to comply with legal norms and principles that apply to their activity. Activities such as driving cars in the case of autonomous vehicles, making contracts and operating in commercial interaction in the case of e-commerce agents. Obviously, we need to make sure that when the law is made computable, it remains a human enterprise over which we are able to maintain full ownership and control. Thus, it is not only to achieve this outcome, also the socio-technical conditions must be available, incentives for correct design, deployment, and monitoring legal compliance and the development of law-compliant computations. Joint cognitive engagement of designers and deployers is needed, whose choice will determine how these autonomous legal agents will interact and self-govern in order to achieve a legal compliance. So moving more specifically into the focus, the technological focus of my project, first of all, we must decide what legal requirements in what domain and to what extent must be made computable. For instance, in the case of autonomous cars, we certainly want basic road regulations to be clearly specified and made computable. Maybe also some general legal rules or legal values or legal principles to be addressed in situations when difficult choices are needed that involve non-evitable harm. We need to consider what technologies and architectures should be used. And in this domain, I think there is already a lot of very interesting research coming in particular from the domain of AI and law, where we have a number of models to capture legal rules, obligation, permissions, rights, and so on. We have techniques for models for computable legal argumentation. Recently, there has been also quite interesting approaches to reasoning with cases. And then we need to combine top-down compliance with predefined rules, the kind so-called old-fashioned, good old-fashioned AI, the symbolic approach to AI, when humans play a key role in specifying rules and concepts. And also the machine learning trend that has become dominant recently. And there is a lot of work to be done on how the law can be learned. There is a lot of work on the machine learning, neural network, probabilistic models, but also the induction of rules, and how to combine also the use of explicit knowledge with the learning aspects. How to address normative conflicts. Also here there is some relevant work. How to apply rules according to legal values or principles when an autonomous artificial entity is applying rules. There are, as we all know, cases in which the blind application of rules can lead to unwanted outcomes. How to address those cases when a human intervention is possible, so that the system should in this case detect the problem and ask for help, and what to do when human support is not available. And then what formal or substantive legal constraints should govern the design and the implementation of intelligent legal or autonomous legal agent. Here we have to see how to translate legal requirements, such as those embodied in the idea of the rule of law, into computable law. I will go quickly in order not to abuse my time. There is a lot of relevant research in this domain coming from AI and law, but also from multi-agent, the theory of multi-agent systems, computable argumentation, natural language processing, and machine learning as applied to the law. Work on machine ethics and roboethics, but this idea have so far had limited operational success. I would like to contribute to their development. To achieve this purpose, computing and AI and law are not sufficient. There needs to be also a strong contribution from legal theory and also from the domain of philosophy, logic, a number of concepts such as causality, influence, decision games will have to be addressed. To conclude, my project aims to address two case studies. The first is autonomous cars, which is a rapidly developing technology. And in leading projects, as you know, self-driving cars are supposed to take humans to destination without any human intervention. And this was involved having the car govern itself according to a computable model of the applicable laws. It remains to be seen to what extent the law needs to be explicit or can be learned through examples of correct behavior. And then there is also, at least, the much debated issue of how decisions should be taken in cases involving competing legally relevant interests and values, as when harm is inevitable and the issue is to decide whom should be most affected. So here we have various aspects that had to be addressed. Model of proportionate normative decision making, how to complement, as I said, machine learning methods with explicitly formulated norms, the idea of adjustable autonomy, when a car should refer an issue to a human, and when, on the other hand, either because the car can address the issue by itself or because there is no other choice, the car should act autonomously. The idea of explanation of the car's behavior, including the rejection of user requests, for instance, a request to speed up when there is a prohibition to do that. Interaction between various agents and stakeholders, the car, its user, the smart city infrastructure, and the issue of liabilities involved. And then the other domain that I'm going to address is going to be e-commerce, in particular intelligent e-commerce agents whose actions should respect multiple legal requirements, laws on contract, consumer protection, data protection, taxation, and even principles of fairness, good faith, transparency, and non-discrimination. How to monitor also compliance by the agent itself and different parties and its counterparts, and how to explain reasons for its behavior, refusing a loan, raising a price, implementing a contract in an unexpected way. So this is a kind of overview of the research that I plan to do in the next 5 years in the context of this project. Thank you very much for your attention. I look forward to any question you may have. Thanks a lot.
Thanks very much indeed, Giovanni, for this very informative and rich account of your new project. Our next speaker is Roger Brownsword. Roger, thank you. Yeah.
Is this mic working?
I think so, yeah. Sure.
Okay, so, well, thanks very much, Simon. Thanks to you and Christopher for the invitation to speak. I wasn't sure how to compress the paper into 15 minutes, so I won't attempt to do that. Simon's given me a good starting point. In one of his slides, well, in fact, we saw this slide twice, Carl Llewellyn, one of the great common lawyers, and his book, The Bramblebush, one of the most widely read law books of all time. And these were Carl Llewellyn's introductory lectures at Columbia, given in the 1920s. But I'm actually interested in something that Llewellyn wrote about 20 years later. At that time, he was working with an anthropologist. This is really a bit of a detour for Llewellyn. When this was E. Adamson Herbal, and it was, well, Herbal, the anthropologist, spent the time with the study group who were Cheyenne Indians, and this resulted in a book with Llewellyn called The Cheyenne Way, and during this period, Llewellyn developed what he called the law-jobs theory, and his thesis was that any group of any size or scale needed to attend as a matter of urgency to some basic jobs if the group was to have any chance of viability. Initially, the allocation of authority, someone had to be in a position of authority in relation to the tasks that had to be performed. But the two principal tasks, and this is the key point in relation to what we've been talking about, the two principal jobs are, one, the channeling and rechanneling of behavior, if you like, I'd say in modern language, regulation, regulating behavior, subjecting human conduct, as Longfellow says, to the governance of rules, but it's about direction, about signaling, about signposting, steering, guiding, okay? Laying down the basic code of conduct. And the other job is the trouble case, where there are conflicts and disputes arising in connection with the rules. So just think about those two law jobs. Channeling and trouble cases. There are different institutions that deal with channeling and with trouble cases. There are different discourses that are appropriate in those particular places. In regulatory arenas, there's a particular kind of talk. It's policy focused. It's very instrumental. It's about risk management. Okay, and it's also very political. Trouble cases and disputes, characteristically, we're talking about litigation and courts, completely different language and discourse there about the application of the general principles of the law of contract and torts and property and crime to these particular cases that are before the courts. Now, an awful lot of what we've been talking about here this morning, an awful lot of it has been in relation to the impact of technology, and specifically AI, when you introduce it into the context of litigation or the application of legal rules. You want to know what your legal position is, where you stand in relation to the rules, or indeed to adjudication. Okay, and think of technology here as a kind of a wedge. And I'm saying in the paper that the wedge that's being applied here through AI is still a relatively thinnish wedge. Okay, it's the thin end of the wedge that's being applied. It is disruptive, it is significant. And of course, there's a whole lot of skepticism about how far that wedge can be pushed into that particular area. Okay? We've heard from several speakers this morning expressing skepticism about how far we can actually go with that. I want to say, forget about that for the moment. That's not where the action really is. The action, and a much thicker end of the wedge, is in relation to channeling and rechanneling, in relation to regulation. This is a much more hospitable context for technological technologies being introduced to aid the regulatory enterprise, okay, which is trying to get people to act in certain ways or not act in particular ways. This is where I talk about, in my work, technological management. Okay, that we're moving into a zone, and it's already been happening large scale without really anyone very much noticing it, that we're relying on technologies to do regulatory work that rules would otherwise be doing, or to complement rules. And I think that the discourse that will now develop, what I call Law 3.0, is a regulatory discourse, but for the first time, there is a sustained attempt to think about how we can design or architect the spaces in which we act, the places in which we act, and that what we embed within those places, or the products or the processes in those places, take the place of the rules in doing the regulatory work. Of course, the autonomous vehicle that Giovanni's just been talking about sort of epitomizes that we don't need to rely on rules to regulate the conduct of car drivers when humans no longer drive cars. And the same will be true with autonomous vessels and so on. Okay, now just how quickly this is happening. Just my trip from Bournemouth up to Cambridge via London. Okay, the train, I was lucky to get a train, of course, from Bournemouth at the moment up to this big strike action going on South West Trains, which also, interestingly enough, is about AI and automation and people losing their jobs. But once upon a time, if I'd made that trip, as we arrived at Waterloo Station, I could have opened the door of my carriage and I could have jumped off the train onto the platform while the train was still moving. And you may have seen black and white footage years and years ago of commuters arriving at Waterloo Station, and as the train pulled into the Waterloo, the doors, there were all sorts of doors all along the carriages in those days, all those doors opened and people literally, young men normally, just we were hanging off the doors and they'd hit the ground running on the platform. Health and safety people would have, I think, been okay. Now, that didn't happen on the train that I was on as I pulled into Waterloo Station. And it didn't happen because there was a rule saying that that was prohibited. It wasn't like on an aircraft where someone says to you politely, don't, keep seated, don't undo your seatbelt until the plane is stationary. That's the rule. No, I didn't do that, and no one else did it either, because it's not physically possible to do that on the trains anymore. They are designed in a way with central locking systems. You just can't open the door and jump out. It can't be done. Can't be done. Ought not to be done. Can't be done, okay? And again, when I got to King's Cross, once upon a time, coming up to Cambridge, I could have just walked onto the platform and got on the train. No one would have checked the ticket on the way. I could have walked off at Cambridge Station and did that. So, I mean, it was a trust-based system largely. It was, honesty was what mattered there. All right, and that has been compromised by the technology that's introduced at King's Cross and at Cambridge stations now, where basically, well, it's not physically impossible to board the train without a ticket, but it's much more difficult than it once was because you've got turnstiles and all that kind of kit that is at both ends of your ride. Okay, so technological management in those cases, not cases there involving AI, but devices, instruments other than rules, is something that we have been doing. Sometimes I think accidentally we've used technologies or designs that have regulatory impacts, but without us intending them to have particular regulatory impacts. They just have these particular impacts on us. But what I'm suggesting is that the next evolution of law will be from a discourse where we're thinking about how to apply in Law 1.0 the application of legal principles to a discourse in which, or conversation in which, Law 2.0, where we're thinking about what we're trying to achieve. What are we trying to do here? Where are we trying to go? And how can laws help us achieve these policies or purposes? To Law 3, where in a systematic and sustained way, we think about alternatives to rules or principles as the mechanism for achieving our regulatory purposes. So it's a regulatory discourse still. It's highly instrumental, but it's not reliant on rules. And the reason I say this is the thick end of the wedge is not just because of the huge implications it has for compromising the context in which we can respect one another, trust one another, assume responsibility, praise and blame, and many other things that we do at the moment because we do things freely. It's bad for us in that sense. But it's bad beyond that in too many other ways to think about. But the characteristic here is that this is highly instrumental. Now, just like Law 2, the regulatory discourse is highly instrumental. I mean, all the talk there is about what works. And what's attractive about technologies is that they seem to work better than humans, particularly human rules. Mireille, I'm not sure in Mireille's talk whether she'll get to this, but Mireille is very strong on the idea of law being what I call gappy. And I mean, to really press the railway metaphor, mind the gap. Well, yes, there is a very, very important, well, there's several, but there's one in particular, very important gap between the rule, the rule, the prescription, and what you actually do in response to it, whether you comply or not. There is a gap there. And there's a further gap in relation to if you don't comply, whether or not you are actually detected as a not compliant. And there's a further gap in relation to even if you are detected, what kind of enforcement there might be. There are gaps all the way through, and of course gaps in the body of the rules as well. It's very gappy. And technology promises to close all these gaps. Technological management is about cutting out all these pathologies and opportunities for things not operating in the way that you'd expect. It's highly, highly instrumental. Now, there are three things that I think we urgently need to attend to once we've got this in our minds, once we're focusing on channeling and technological management, sometimes in conjunction with rules, but sometimes taking over the rules completely from the rules. The first thing is to try to recover our fundamental and foundational values. We've had questions about red lines this morning, and John, I didn't ask John this question when you were presenting, John, but I was tempted to. It's a question about when you said twice, I think, in your talk about the impact of what's going on with AI on our agency, on our political agency, on our agency, okay? Now, each community, in my view, of course, well, let's assume it's a hard case where there's a plurality of views in the community. It is a community, but there's a plurality of views. So how do you recover foundational values here? Because there's a tendency to flatten everything to interests that individuals have, which are then sort of put on the same plane, and regulators have to try to accommodate these competing and conflicting interests in the best way possible. But there's no sort of hierarchy, there are no foundations. And it may be that the community is resilient enough still to recognise what it really stands for, what distinctively makes it the community it is. I mean, in Europe, we have, Charter of Fundamental Rights, and we have the European Convention on Human Rights that speak to what sort of people we are as Europeans. Okay, and I can see that community by community, this can still be a plurality of values. Some communities might be much more enthusiastic than others. The red lines that have been drawn in France are indicative of France, being nervous about technology intruding in certain places. There are some no-go zones. Okay, so there can be plurality there, but in this plurality of individuals and plurality of communities, there are, what makes this possible? There are certain presuppositions, certain foundational conditions without which none of this can happen. We can't have these debates, we can't have these differences or resolutions without these things being in place. And the two sets of conditions that have to be in place relate, first of all, to the bare existence of us as humans. The bare existence, bare existence conditions. Earth is an unusual planet in the sense that it is conducive to supporting human life. AI, of course, we have existential concerns about, existence concerns about it. But really, it's very, very obvious. I mean, we shouldn't really need school children to be teaching the lessons about, the basic existence conditions for humanity, for humans as a species. Unless our biology has changed or technologies give us some sort of protection that means we neutralize our vulnerabilities biologically, then, we have a set of conditions here without which we can't even get to first base. Now, the other set of conditions is to do with agency. I want to say, I mean, of course, and people generally, when I give a talk like this, say, oh, we understand exactly what you mean in relation to the existence conditions, but what's all this about agency? I'm getting a bit nervous about this. What does agency encompass? Because clearly it is a contestable context. But I'm thinking here that agency is about, first of all, recognizing ourselves as selves and as persons with interests. We have our own interests, pure self-interested view, and about self-development and what I want to be, what kind of person I want to be. It's all I. But I have a sense of what I am and what I want to be. And I have a sense of what projects and, but then it's also a sense that there are others, like me in many respects, but also different. They have their own interests, they have their own needs, but, there are others. And that I can think, too, about how I should relate to these others, where I recognize that they have legitimate interests. So it's about both my self-development for myself and about moral development, and but without any yet substantive morality or substantive preferences being privileged or written into any of this. These are entirely neutral conditions. They're neutralized between us as humans. The existence conditions are neutral. The agency conditions are neutral. If you say to me, I can think of a condition that would not be neutral between agents, then it's not one of these conditions, is the answer to that. Okay, it's not one of the foundational conditions. That would disqualify it. These have to be absolutely neutral between us as persons. No matter what our particular projects or plans are, these are conditions that have to be in place before we can do any of these things in relation to self-development and moral development. Privacy and human dignity, two much maligned values, I think get downgraded because they are truly speaking to these agency conditions. Both cases, privacy and dignity, have a place amongst those agency preconditions, okay? They are part of the necessary context for us to operate as human agents. Okay. They also have a place when they are articulated within particular communities in a particular way. But all these pluralistic articulations within communities or by communities must be compatible with those fundamental foundational conditions. The generic commons, as I would put it, the global commons for human social existence, just that. Okay, the second thing we have to do, because those now become the key benchmarks for legitimacy, we have to respond, as I've just tried to do, to the instrumentalism that is so dominant within regulatory thinking. I mean, Murray again has made the point that there's nothing per se wrong with instrumental rationality. It's a useful bit of rationality. But once it's detached from substantive rationality, once we, are careless, okay, once we're careless about the ends, then we have, this becomes a loose cannon. So Simon's given me the indication that time is it's run out?
2 minutes.
2 minutes, okay. So let me just then sum up what the other two things we need to do are. The first of the two things we need to do is to rethink our understanding of the rule of law. The rule of law. And in three ways. First, we can't have it that the rule of law just applies to the rule of rules. Okay? We have to apply the idea of the rule of law as an authorizing compact to not just rule instruments, but all instruments that are being applied for regulatory purposes. So technologies in the same way have to be subject to rule of law scrutiny and authorization. The second thing is that every community's version of the rule of law has to start by embedding respect for the global commons, for those conditions. It can have its own particular local conditions in the rule of law, but it has to start with that. That has to be the paramount priority for any human social community, that nothing they do will compromise these conditions of existence and agency. And the third thing is that the rule of law can't just be a constraint for public regulators. It has to apply to private parties who are doing things that have regulatory impacts and with a regulatory intent. So the rule of law has to be expanded and extended in these ways. It can't just, I'm not sure we've covered all three, but it can't just be about procedures in the way that Fuller and Raz talk about it. You know, this is going some of the way towards the rule of law, but it has to have that substantive input about the protection of the global commons, and also within each community about protection of the constitutive values of that particular community. Sorry, that's a bit compressed, but I'll try and say more about that again, okay, if I get a chance. And then the third thing, finally, Simon, is that, very quickly I can say it, we need to renew and reinvent the idea, or the ideal that we have of coherence in the law. In those conversations about how to apply the general principles of law, private lawyers especially, I mean, they're obsessed with coherence in the body, in the doctrinal body. There mustn't be any inconsistency within the body of doctrine, and there has to be kind of integrity and, if you say to these people, I mean, what's it for? You know, what's contract law for? What's tort law for? What's property law for? You don't get a straight answer to that, really. The important thing is that the doctrinal body is kept consistent. You know, we want it to... Okay, for its own sake. It's desirable in and of itself. Now, when you get to coherence in a regulatory law 2.0 conversation, it's a different matter. You don't talk too much about it, but I mean, you sometimes hear the European Commission talking about coherence, where they've got a range of instruments being applied to serve some particular, like, you know, the internal market or whatever it might be, they're trying to achieve. These instruments must be complementary. They're not, coherence here means we can't have some instruments pulling against this and others pushing for it. They have to be complementary. Okay, but so far we haven't got a substantive view on the coherence. And this is the third version. This is what we really have to introduce into the Law 3.0 conversation, which is a conversation about the use of non-rule measures, you know, technological measures, for regulatory purposes. We have to make sure that we always got our eye on the substantive ball of, I say, the rule of law and the protection of the global commons. These are, you know, this is what coherence has to become here. Compatibility. You say, well, is that about compatibility with human rights? Yes, for sure, it would be. But yeah, it's about compatibility in that we have to now understand coherence. And there was finally, Simon, I may just put in a plug for a book. There was a question this morning about what about legal education? Well, I have written a book called Law 3.0, which is a pretty radical introduction to law, which I hope will be available within the next 6 months anyway.
That's fantastic, Roger. Thank you very much indeed. Thank you. Our third speaker is Jen Cobb. Thank you. Yeah.
Thank you very much, Simon. I don't know how many of you have actually read Ben Allery's paper on the path to legal singularity. It's very much this idea that basically advances in machine learning, in computational technologies, will lead us to the point where we can automate the full legal process, automate the legal system, and have a full automation of law. I'm pretty sceptical about that as an idea generally, not least as John Naughton's pointed out, that actually these systems don't really work that way and they're not really capable of doing that. But technical problems can potentially be solved. So I think if you need to have any kind of real critique of this idea, you kind of have to take it on the face as if it was actually technically possible and sort of go from there. So first of all, I want to talk about the sociological concept of reflexivity. The idea of reflexivity emerged from the understanding that researchers in the field aren't neutral observers, that where people exist in a situation, they're influenced by their subjective understanding of the situation, and that they in turn act upon that situation. Where researchers are said to be reflexive, this indicates that they are concerned with understanding how the process of doing research shapes its outcomes and feeding that understanding back into their subsequent research practices. So reflexive things bend back on themselves with a circular relationship between cause and effect. Karl Popper, for example, wrote about how making a prediction about something is reflexive in that it can have an effect on the outcome of the thing being predicted. So Simon actually mentioned earlier on the process of law being reflexive, but taking the concept of reflexivity away from its origins and taking a slightly different take on it, I want to argue that law itself functions as a reflexive societal institution. Not only is law a product of its society, but it's also something that affects and alters and itself plays a role in producing that society. As a reflexive societal institution, law can't be neutral. It's contextual and it's contingent on the circumstances of the time. It's imbued with the normative assumptions and priorities, and it reifies the interests and goals of its writers and its practitioners. The subjective assumptions and understandings and priorities and goals of those involved in writing, practicing, interpreting, studying, and applying the law all feed into the impact of law on society, and from there into society itself. So the point I want to make here is that we as a society, we produce law, and that law in turn reproduces us. And it's because law is reflexive that it matters what kind of role it plays in society and what kind of values it promotes and what kind of goals it prioritizes over others. Because of its reflexivity, how we as a society construct and order law tells us much about what kind of society we hope that will in turn produce. We would all, I hope, like to think that the law can be a force for good in the world. The idea that law serves justice above all else in the interests of society is a heady one, and lawyers become quite easily intoxicated on the promise of a better society through the law. But we shouldn't make the mistake of viewing the development of law as always trending towards the better. The law in the UK has historically, and even in the present, tended towards entrenching the power of capital, strengthening the position of the wealthy, reinforcing inequalities, and protecting established interests from outside challenges. As critical legal scholars have repeatedly shown us, law has historically been and remains a tool of hierarchy, of exclusion, of marginalisation, of domination, of colonialism, and of capital. As a reflexive societal institution, the law has not only reflected the historical inequalities and injustices in society, but it's repeated, reinforced, and re-encoded them back into society. This means that when those who believe in the legal singularity tell us that law will be better, I tend to ask, better for whom? To answer that, we need to first understand how Allery and others problematise law. Because law is reflexive, and because the normative values that we embed in law tell us a lot about what kind of society we want to produce, how we problematise law also tells us a lot about what kind of society we want to see. Legal tech and legal singularity proponents often problematise the law as slow and costly and inefficient and complex and unpredictable. Some of those things might of course be true, but how they problematise the law misses the issues a more critical analysis of law and society would highlight. Legal tech and legal singularity seem at times to be proposed as a convenient, natural and obvious solution to these problems with the law, but as with many tech solutions for societal issues, it can sometimes be difficult to tell which came first, the supposed problem or the apparent solution. Allery himself frames post-singularity legal tech as the solution to all of law's ills, and I quote, "The legal singularity contemplates the elimination of legal uncertainty and the emergence of a seamless legal order, universally accessible in real time. In the legal singularity, disputes over the legal significance of agreed facts will be rare. There may be disputes over facts, but once found, the facts will map onto clear legal consequences. The law will be functionally complete. Ultimately, Allery supposes, law will, and I quote again, function extraordinarily well, virtually automatically. Allery's vision is an explicit call for the replacement of the rule of law with the rule of technology, which brings law firmly within the world in which, as Pasquale puts it, authority is increasingly expressed algorithmically. This might not seem like such a bad idea if we assume that the claims about the capabilities of machine learning systems made by legal tech proponents such as Allery were accurate, and if the drive towards legal tech more generally was truly concerned with the well-being of society as a whole. Indeed, there seems to be an assumption underpinning much of the legal singularity proposition that AI will act neutrally, sort of humming away and putting the law to rights in everybody's best interests. But a more critical examination reveals that these are not necessarily safe assumptions. We know, for example, that machine learning systems are riddled with biases, that they're prone to errors, and that the more complex the system, the more fragile it is. An obvious question to ask of Allery's vision is therefore, following the legal singularity, what will the legal system supposedly function extraordinarily well at? As has been long acknowledged, machine learning systems are not neutral. And as Rob Kitchen puts it, just as algorithms are not neutral in partial expressions of knowledge, their work is not impassive and apolitical. Machine learning models inherit the societal structures and power relations reflected in the historical data sets on which they're trained, insert the subjective priorities and goals of their designers, and then setting about organizing the world according to those logics, encode those structures, power relations, priorities, and goals into the future. Just as we as a society produce law, and law in turn reflexively reproduces us, so too with algorithms. Just as law in its reflexivity molds society according to the subjective assumptions, understandings, and goals of those who write and practice it, so too with algorithms. Law as a reflexive societal institution plays a significant role in organizing society. What kind of society would be reproduced and reinforced by machine learning systems after the legal singularity? Law is a human construct dealing with complex human matters, and not everything can be quantified or dealt with by computers. As Nick Sieber points out, there is serious, significant academic concern about what happens when the rigid quantitative logics of computation tangles with the fuzzy qualitative logics of human life. Sociologists talk about rationalization, replacing subjective values with rational thinking based on reason and objectivity. This often involves forms of computational thinking, of quantification, of mathematical logic replacing other ways of seeing the world, other ways that are more suited perhaps to the human complexity of society and of law. Indeed, much of what Allery proposes seems to be based on a desire to eliminate the fuzzy qualitative logics of law by subjecting them to the quantitative logic of machines. And quantification is, of course, itself subjective, contextual, and inextricably tied up with power. Through quantification and rationalization, through the replacement of traditional fundamental legal values with logics of cost saving, speed, and efficiency prioritized through automation, these market logics are brought into the heart of the law. And the reflexivity of law means that they will from there be encoded further into society. As algorithms interpret and analyze society and then send outputs through law back into society, this will affect how society functions. The algorithms of the legal singularity would then reinterpret and reanalyze society that they have produced, reinforcing it through feedback loops. As Mackenzie says, the more effectively that machine learning models operate in the world, the more they tend to normalize the situations in which they're entangled. That law and machine learning both take their designers' understandings of and goals for society and try to reproduce them in the future is perhaps why the idea of bringing law and machine learning together can seem on the surface to make intuitive sense. But it is precisely because algorithms are normative that they feed into law's reflexivity. The legal singularity would bring the goals and priorities of its proponents into the law from where they're reproduced across society. Yet proponents of legal singularity, as envisaged by Allery and others, seem to uncritically buy into the idea that better law is better for everyone. By problematizing law as slow, costly, inefficient, complicated, and expensive, rather than as a tool of marginalization, exclusion, exploitation, and for rareifying the power of capital, they pursue goals that are likely to repeat and reinforce those effects. Without a critical re-examination of the law and of the idea of legal singularity, without rethinking how law is problematized and solutions are developed, and without working towards radically rebuilding the law to work to try to produce a fairer, more just society, legal singularity as a vision and a goal will remain primarily concerned with making the law better at entrenching market logic, commercial imperatives, and a particularly computational worldview. Thank you.
Thank you very much to each of our speakers. And we now have approximately 25 minutes or so for discussion. And I invite questions or observations. Yep. Yes, thank you.
Yes. Thank you very much again for three wonderful speakers. What interests me very much is that we get three, I would say, rather different perspectives on the same thing, where you could have a long philosophical discussion whether it's actually the same thing. But let's focus on law as it is, and as the kind of law that will be produced by LegalTech. And what I would like to do is not ask my own question, but I would so much like to hear Giovanni about what the other two speakers have said, Roger about the other two speakers, and Jennifer about the other two speakers, because this is like so desperate, not desperate in the sense of, but disparate. I would really be fascinated to hear you respond to each other.
Yeah, I think that's a good idea if the speakers don't mind. Giovanni, I guess I also thought that what you were setting out there was a proposal for a project which, in a sense, was quite abstract. You brought it down in the end to a couple of case studies, but maybe some of the more critical perspectives on AI that we heard about from Roger and Jen were not so much present in your account of your project, or maybe I've misunderstood. Would you like to respond first of all? Then I'll invite the others to maybe tell us what they think about your project.
Okay. No, my project is not so much focused on the critique of AI, because my project aims at identifying the condition under which useful AI systems for the law can be constructed, and defining the technologies that can be used. Concerning, therefore, I fully understand the worries that my colleagues have expressed. But I would have a different way to tackle them. So I believe that there are certain applications of AI. I don't know, for instance, detecting sexual orientation from faces that should probably be banned. In the legal domain, there are things where humans cannot be substituted. Our ability to understand other people's feeling and putting ourselves on their shoes cannot be, at least at the stage of the technology, transferred to a machine. I believe that there is a large space for as I said, the computable representation of norms, because we need to have norms that govern machines. So my focus was a bit different, because my focus is on not on how machines are substituting the law as a model of governing human actions, but rather how the law should govern machine action. So it's a complementary direction that I side with Roger worries about how our autonomy may tend to fade in a context where our choices are pre-constraints directed to micro rewards or punishments. All of this makes a lot of sense, but this is not the focus of my research. I am also aware of the issues that the current discussion on prediction and machine learning application biases and so on. Again, I think that we have to engage in a serious comparison of human and automated machine decision making and how they can be integrated, for instance, in judicial decision making. So I would have a kind of more constructive than critical approach towards the deployment of AI technologies also in the legal domain. I don't know if I answered your question, but
no, I think you certainly did. Thank you. I mean, Roger, I thought in relation to your paper was really making the case for some fundamental rethinking of the rule of law in a somewhat wider sense. It's not just about AI or the threats posed by technology. And I wonder to what extent the problem here might be that with law tech or AI as applied to law, if law is reflexive and so is technology to a certain extent, the kind of law tech we get is in some sense a reflection of the sort of law we currently have. So if it's looking more impersonal and somewhat technocratic, that's no accident, is it? And it may be very hard to break out of this loop.
Yeah. Well, I think there are two challenges there. One is a challenge within a particular community which wants to reconstitute itself. It's not. There's nothing mandatory about the reconstitution. It's just that there are resistances built within the structures that militate against any refashioning of the kind of community you want to be. And so that's, I mean, how you unlock that is one question. But the question I was flagging up more on the challenge was embedding the conditions of the global commons in all communities, in all versions of the rule of law. I mean, I regard these as, we talk about cosmopolitan conditions. This is what they are. They're not to be mistaken either for things like just Kogan's, which only get that status because you happen to recognize them. There's something rationally compelling about this. If we are humans, we have the capacity for agency. These are conditions which we can't rationally, we can't even think about compromising. But like a lot of it, I mean, there's a great book on infrastructures by Brett Frischman, I think, who says that characteristically we tend to undervalue infrastructures, economists especially, undervalue infrastructures. Infrastructure is generic. And what I'm talking about with the global commons is the most generic of all infrastructure. It is the mother of all infrastructures, as it were, but it's very thin set of conditions. But that's where you find redemption of, the foundational values for all human communities. And so if there are blockages within a particular community in embedding those values, then that's a more serious problem. And of course, because these are cross-boundary, across community issues, it's tempting to say that actually the stewardship of the commons should not be left to national regulators. That you need regional, international regulatory bodies who have really signed up to this. And of course, then we're into the real politic of international relations, where so this is, you might say, hopelessly idealistic.
Maybe, I don't know. I think the point that comes across clearly, I think, in your paper, Jen, as well, is that, as you say, law isn't perfect, is it? And law has entrenched inequalities, and often does a really poor job in delivering justice. And in the case of something like the global commons, is it too optimistic to think that the advent of AI can be of assistance in removing some of the blockages in some very, very familiar features of the legal system which haven't really helped?
I mean, I think there's probably a place for AI in parts of the legal system. I mean, I'm not saying that we shouldn't automate any aspect of it, or we shouldn't introduce AI into any aspect of the legal system. But I think we have to be exceptionally careful about where we do that, and where we, in thinking that we're solving problems, actually just reproduce those problems, or in fact other ones, or cause new ones. I think that's a very serious concern that I have about this kind of stuff. I think one of the things that comes across in both Giovanni and Roger's talks is this idea that, you know, I think it's around agency, it's around law as actual physical barriers to things, how you close things off and that kind of thing, and how law can govern machine action around that. I said before I work in a computer science department, what's interesting is that computer scientists usually just ask, just tell me what the rules are, I'll build them into the system, and that's not really how this works. But you're right that architecture, for example, can change and constrain and permit different behaviours. So Langdon Winner, of course, wrote about this back in 1970. He had his The Artifacts of Politics paper, which talks about this in great detail. But I think this idea of introducing these sort of computation elements kind of brings us to a point where Winner's kind of view of things is becoming combined with sort of Lex Ex code kind of thing, where we're bringing the two together and we're sort of more dynamically creating that architecture in physical and in virtual worlds. And it makes me think of Gilles Deleuze's The Postscript and Societies of Control that John talked about before. He talked about how with computers, with these kind of new forms of control, they don't necessarily prohibit anything, but they affect what he calls a universal modulation, where things can be tailored quite precisely to individual people to just sort of shape their behaviour and shift them and that kind of thing. And he talked about how he'd had a conversation with Felix Guattari, and he brought up this example of you know, the future smart city in which you'd have an ID card or something that would let you, and everything would operate automatically. You wouldn't be prohibited from going into certain areas, but if you had the right card, you would, the thing would just open for you. And it seems like this kind of thing is what you're kind of getting at, and partly in what Giovanni's kind of getting at. And I think in terms of things like autonomy and agency, which you came back to and John came back to, and I think are exceptionally important things to be talking about in this context, that is something that's probably not necessarily particularly desirable. We probably need to think very carefully about who's setting those rules, who is encoding those logics and those frameworks into those systems, and what is their understanding of what behaviour is desirable, and what is their understanding of how law functions and how law operates. Because it won't be lawyers, building those systems. It'll be computer scientists, and computer scientists generally lack any kind of a nuanced understanding of any of these issues, and I think we need to be very concerned about that.
Yeah, I think that's very interesting, isn't it? The idea of a tailored regulation, which can be achieved through, I guess, the Internet of Things and something like the smart city, it individually tailored for each citizen is really disturbing, isn't it? Because we think of the rule of law as somehow a set of generic rules that isn't tailored to us in the same way. And even money, which opens doors and closes doors for people they haven't got it, has this somehow generic or neutral feature to it, doesn't it? Which this tailored regulation doesn't have. Maybe we could, if it's okay, collect some more questions, because we haven't got that much time. Yes, thank you very much. Yeah, please.
Question for
Oh, sorry, could we just use the mic first, because Giovanni can't hear us. Yeah. Thanks.
Thanks very much for the presentation. The question for any of the speakers is whether you've come across any examples of systems that have been successfully regulated. So in the financial sector, I believe there's not many examples of other than SWIFT, of actually regulated technical systems. And having spoken to a couple of regulators about this, they've said that you can't really tell someone to use one program or another. So to enforce that, use Microsoft Word rather than Excel is just impossible. So, yeah, are there any examples?
Yeah, thank you. Colleague there, thanks. Yeah.
My question is also regards the rule of law, and I feel like one of the things that the debates now and also in the previous panels are showing is that technology is to a degree possibly demystifying also law in a way, in the sense that some of the rules of the principles of the rule of law is legal certainty and predictability. Now the lawyers are suddenly saying, no, law is actually unpredictable. It should be unpredictable to be able to work, and it should be unpredictable in order to accommodate legal circumstances. That's a conundrum that I'm kind of dealing with at the moment, and I'm wondering what we are losing when we are losing the myth of the workings of the law somehow, when technology is seemingly offering exactly what we were previously promising.
Thank you very much. Yeah, please.
I have a question for Roger, because you basically made a plea that the rule of law should also apply in private law relationships, and I just wonder how far that would go. I mean, I agree, because fundamental decisions that were formerly taken by state actors are now taken by companies. So this is this whole movement of privatization of decisions of public values. But on the other hand, I'm interested to know where to draw here the line, because that might be, of course, a little bit problematic and very far reaching, and cutting autonomy and private law relationships. So is it only that you would apply it maybe to very powerful, dominant market players, or would you say, this concerns certain decisions about certain values? So maybe you can concretize a little bit this kind of concept.
Yeah, that really chimes with what I was going to ask about the kind of how far you would take that distinction between public and private, and whether in your kind of law 3.0 there is even a distinction between public and private law anymore. But I also was going to push on the kind of regulatory intent test that you seem to articulate as a threshold for when you would or wouldn't intervene in private law decision making, in private decision making. So, thank you.
Yeah. Another question? No? Okay. A couple of those were directed a bit towards you. Roger, do you want to go first? Yeah, sure.
Could I take those two?
Of course, yeah.
Sure. Yeah, so about the rule of law initially, and its application to parties who assume private regulatory, they act in a way which has regulatory intent, even though they are private parties. And so digital rights management, for example, would be an easy, this is the textbook example probably, isn't it? And we worry about this. Well, we already want to, after Lessig, to assess whether the use of digital rights management is in line with background IP law. So, what Lessig's main concern, isn't it, that digital rights management might overreach on the fair use doctrine, so that people who the legal position is that they could use this in a way that would be a fair use, but the technology prevents them doing that. I mean, I can think of many examples where private parties will resort to a technological measure because they feel that is more effective than, and probably rightly so, than the criminal law or tort law, contract law, whatever it is that's the alternative. But provided they're doing that in a way which is within the background legal bounds, that at least passes one hurdle. One example I use in the book I published earlier this year about a golf club that's having problems with joyriders who are coming onto the golf course and taking golf carts off course to joyride, clearly breaching a whole raft of laws in doing that. Then dumping the golf carts somewhere, or just like supermarket trolleys you get trolley. Okay, so you can say, well, there are criminal laws here which would apply. There are tort laws, there's property law. I mean, there's a whole raft of stuff, but it doesn't work. It doesn't give them the protection. So they then apply a technological fix to the golf carts, so they can't actually take them off bounds. Now, that doesn't seem to be overreaching on their legal rights, although it's achieving the effect through an instrument that hasn't been specifically authorised. Well, our community might want to say, well, that's fine. That satisfies our understanding. Or it might be more demanding and say, no, just the use of technological instruments per se needs to be within a general mandate or, a specific mandate. Now, of course, I say this is very idealistic, because private parties aren't just going to sit back and say, oh, well, that's just fine. You go right ahead and impose these restrictions on things we would otherwise do. No, there's going to be tremendous resistance to this, I'm sure. But, I mean, in principle, I don't see why those who are in a position to use technological instruments for private parties for regulatory purposes should escape the scrutiny of the rule of law. That it should be authorised. In principle, I don't see why not. And I mean, Jess's point that of course, the line between who actually would be a public and who's a private regulator, they could. We know that's already deeply contestable, isn't it? But I mean, I have a sense that this is the right thing to be saying in principle, but in practice, how each community translates it might well be very different. And of course, the resistances and support for these approaches within different communities might be very different. If you are, I mean, like in a community of Airwonians where they've gone right off the idea of technology, you might find that there's a lot of support for this. And but now, I mean, the question. Sorry, if I could just very briefly address the question that you asked over here, which is an excellent question again. I mean, it's actually. I mean, it's always puzzled me too. I mean, first of all, in the Fullerian and Joe Raz is just for me, it's just a restatement of Fuller, really, with a little bit of tweaking. But those seminal statements of legality, the procedural principles of consistency and certainty, all that stuff that we associate with the rule of law. Well, it's not just about rules. It is about usually about duty imposing rules, isn't it? About rules that they impose requirements. So there are certain sorts of other rules in play. You could say the rules of contract law. I mean, there's a big debate about whether contract law rules should be characterised as power conferring or duty imposing. But but I mean, even if you can dodge some of it on these in this way, there is still a question there about, well, I mean, don't we value the discretion and the flexibility that's been written into rules? So whilst, I mean, Fuller wants to say that his 8 principles are desiderata and you can't satisfy them all at the same time in the same sort of way, what seems to be missing there again is a sense of the substantive requirements of the rule of law, because that, for me, would be the counterpoint to this, that yes, you want rules to be certain and predictable and other things being equal, but where they produce great injustice in a particular case, then you don't want the rule to be applied. And that idea of congruence, the rules should be administered and enforced as promulgated. Well, in that case, I think the problem for me is that Fuller, like Raz, doesn't have a substantive component within their versions of the rule of law.
Thank you. I kind of actually wanted to come to the question about the distinction between public and private law that was asked just quickly before coming on to one of the other ones. I tend to view the distinction between public and private law in many ways as an excuse to let corporations do largely whatever they want, in this grand scheme of things. And I think where we are now with the world, with the increasing dominance of society by a small number of big tech companies who are increasingly mediating huge aspects of the world that we live in, we can't really let them get away with that anymore. I think we need to understand that they are exercising functions in such a way, as they take up such a position in society, that they have to be thought of as being at least semi-public, if not just essentially public actors, in completely undemocratic, completely unaccountable, and in many ways illegitimate public actors, but they have taken that position in society, and they have very deliberately chosen to take that position in society, and I think we have to kind of work with that. But the other question I wanted to come back to was the question of whether we can regulate systems, which is an interesting question, but I'm going to challenge you in the framing of it, because we don't regulate systems. We never have regulated systems. We regulate the design and use of systems by people and by corporations and things like that. So yes, we can regulate the design and use of systems by people, and we have done that in virtually every single sector of the economy, and successfully, and so I'm not remotely concerned about that.
I'm not sure whether Giovanni can still hear us. We might have lost a link, I'm afraid. He's waved at us. He was disconnected, unfortunately, but maybe we'll have to pose these questions for him at some other time. That's right. Yeah, sure. Yeah.
I mean, was it the example you got in mind there was about high frequency trading, wasn't it? Or yes. Or in banking.
Yeah, banking, yeah.
Yeah, in banking. Yeah, and where you would be looking, I mean, in many cases, you'd be looking for self-regulation, wouldn't you? I'd like with electronic bills of lading, that kind of thing.
Yes, yeah, exactly. I mean, it's just
Oh, sorry, we need a mic. Quite sorry. Yep.
I guess regulators traditionally have regulated the people who operate the systems, and the people who operate these systems also say that's the best way to do it. But regulators have also traditionally taken what they call a tech-neutral approach to regulation, and some are now asking whether or not they should continue having that approach, or whether they should also mix the principles together with the knowledge of the technical systems and how they function.
Yeah, yeah. I mean, it's very, at the moment, the Financial Conduct Authority here been very, very slow indeed in deciding whether and how to regulate crypto assets and blockchain generally. They, I mean, unlike in many other parts of the world,
Taking their time, aren't they?
taking their time over it. Yeah. So yeah.
Interesting.
And there's been I don't know whether you've heard about a case in Singapore about on a coin exchange where a trade between Bitcoin and Ether, I think, where the Ether was overvalued by about 250 times. And one of the parties to the transaction, of course, was happier than the other. And the long judgment given at the first instance, a hearing on this, but trying to apply general principles of contract law, general principles of property, and to this, there's no bespoke regulatory framework to make a decision about this.
Well, it's really challenging, isn't it? And it's interesting that one of the first cases in which a judge tried to identify the nature of Bitcoin was the Mt. Gox insolvency. And we often say that law is critical. Well, law and economic scholars say, okay, law is critical in an endgame situation like termination of employment or insolvency. And so this is what happens. And so gradually there will be experimentation to some degree around these questions. And now we're getting to the stage where there's a rather more concerted effort, isn't there, going on with consultation over the attempt to define crypto assets. That's right. This has been such a fascinating session. I'm loath to draw it to a close, but I think I should, because there are 2 more sessions to go, and we want to be fair to the later sessions. So we're going to have a short tea/coffee break now, but I would just like us to, again, thank the 3 speakers for this fantastic session. Thank you.
next session, which is a panel discussion, which is why we're all sitting here. I'm David Howarth. I'm Professor of Law and Public Policy at the University of Cambridge. And the panellists are going to speak in the order in which they appear on the programme for 10 minutes each. And we'll be told to stop after 10 minutes so that we can have a proper discussion. And we're aiming to finish, about 10 minutes or so after the programme says, so we can then have another break, and then Simon has agreed to chair the last session in Chris's absence. So we're going to do the presentations one after the other, questions after the third one. And we'll start with John Norton, who, as the programme says, is Senior Research Fellow at Crash at the University of Cambridge. For those of you who are not Cambridge natives, this might need some explanation. It's not about autonomous vehicles, as you although it might be soon. It's the Centre for Research in Arts, Social Sciences and Humanities, artfully arranged in that order. John was previously Professor of Public Understanding of Technology at the OU, and is an engineer by training, and is also well known as a journalist and a columnist for The Observer. John.
Thank you. I'd like to start off with a few general observations. I mentioned this morning, the more than strong whiff of technological determinism that hangs over these kind of discussions. And I think that's, well, I think that's pernicious. And I think that, professions that are proud of themselves, like lawyers, ought not to be too intimidated by the technology. But anyway, but what I've noticed in the last period is a wave of excitement and anxiety about, quotes, AI, in all kinds of areas, and in general, what AI means in this context. And the only thing it means is actually machine learning, usually carried out by large corporations. And we have discovered very quickly that this stuff is flawed in all kinds of ways. And what we have begun to see is what Julia Powles and Helen Nissenbaum have called first wave critiques of it. In other words, lots of people, interestingly, most of the most perceptive critics of this technology are female, in my experience. But the first wave critiques are ones which look for and find the flaws in the outcomes of machine learning systems, for example, bias and so on. And insofar as the industry pays any attention to criticism, it has launched this kind of very earnest set of engineers who say, well, we understand the problem. We understand the problem. We really do understand the problem. Most of these guys are male, by the way. And we're going to fix it. We're going to fix it. And I think a lot of unduly credulous and well-meaning people have accepted their assurances. But my concern about it, and Julia's concern about it, was if you're accepting that sound, you're actually accepting that this thing is deterministic. It's going to happen, and one day the people will fix it. And I simply don't think we should buy into that narrative at all. We need a second wave of critique, and that second wave of critique should, among other things, envisage that sometimes we will ask a question, namely, should this stuff be allowed at all? Should we treat, for example, facial recognition the way we treat radioactive isotopes in medicine, as being useful for specific purposes and licensed for those purposes, and that's it? The other thing, going back to the instrumentalism intrinsic in the technology that we discussed in an earlier session, there's a very interesting book, Re-Engineering Humanity by Frischman and Selinger, which more or less builds quite an impressive and interesting case for the way in which, in fact, one of the impacts of this technology is to re-engineer humanity, to make it more congenial for machines. And I think that's really important. And the last thing was a phrase that came up many times this morning, was this idea of the rule of law versus the rule by law. And which of course is the distinction used by the Chinese regime now, because there is rule by law in China. It doesn't apply to the government, and there's a hint of in these discussions of saying, well, one day we might have to give the same privileges to machines as the Chinese citizens have to give to their government. But I'm an engineer and I take things literally, and for this panel we were set an exam question, and the question is law computable? And my answer is no. But I can see why, and I'll explain why in a minute. I can see why the question arises, and it is a reflection of the kind of zeitgeist of the fact that we are in this feeding frenzy over AI, particularly about machine learning. And I suppose there's a kind of superficial way of viewing it, which says, okay, well, if you look at common law, it's a body of, there's a training set, it's called precedents, and we have judges who are, as it were, who know that, have worked on the training set, understand it, and have absorbed it, and then they kind of make decisions on the basis of it. That's fatuous, but I have heard it raised by some people in this case. So my answer to the question is law computable is not. It's a useful question to ask, I think, in a Socratic sense, because it makes you think about what's implicit in the question, and the two things that are implicit in the question is the concept of law and the concept of computable. Now, as I say, I'm an engineer, and I'm an amateur in this field, and when I was thinking about this the other night, the only book on legal philosophy I have in my study was Herbert Hart's book, which I guess is one of the great classics. And I thought, okay, when we talk about law, we're talking about Herbert Hart's view. And I went back and speed read that book, having not read it for 40 years. And I thought, there are going to be people here better qualified than me, so I'm not going to go there. And we've already covered that quite a lot. But there is a different interpretation. What is law? Well, actually, there's another way of looking at it, which is law is what lawyers actually do. And in reflecting on that, the thing that came to mind was a wonderful book by Donald Shawn many years ago, called The Reflective Practitioner, and that was the problem that obsessed Shawn. What do professionals actually do? And he challenged what he regarded as a prevailing myth, which was that professionals are problem solvers. And he rejected that out of hand. And the grounds for rejecting it were that problems actually, epistemologically, are absolutely trivial things. They are, a problem is a gap between where you are and where you want to be. And you know both endpoints. You know where you are and you know where you want to be. And they're trivial in that sense. It then consists of finding the way to get from one to the other. It implies that you know both states. And in real life, of course, as anybody here who works as a lawyer knows, we rarely do know both states. And what we've got is something kind of fuzzy and unsatisfactory and hard to articulate, and so on. Let's call it a mess. And essentially what Shawn said was, what professionals do is they're the people we take our messes to. And what they do is they do work at hourly rates on these messes to convert them into something. What do they convert them into? They convert them into problems for which there are known legal solutions. And that's one of the things that attracted me to, I want to embarrass him now, to David's book, Law and Engineering, because he has seen and articulated very nicely a way of thinking about this, which was congenial to that view. But one of the things that comes across from that, and indeed from other things, is that there's a misconception that engineering is applied science. And engineering includes applied science, but actually there's a lot more that we don't talk about. I prefer the definition of engineering as it's the application of scientific and other organized knowledge to practical tasks by organizations of people and machines. And that other organized knowledge is pretty serious stuff. It includes project management, it includes economics, it includes craft knowledge, it includes tacit knowledge, it includes politics, and so on. So I think that when you view law as a practice that involves all of this stuff, then you kind of say you have to be joking if you think this is computable. The other thing, the other just a minor point I wanted to say was the other part of the question is it computable? And those of you who know anything about computer science will know that the question of what is computable and what is not is probably one of the most fundamental questions of computer science. And we've been banging our heads on it since Turing and Church in the 40s. And if you really want a sore head, go delve into computability theory. I don't recognize it. So I suppose my ultimate conclusion for all of this is through the exam question this panel was said, is law computable? The answer is no. So then one falls back on the question, was it worth asking the question? And I think it is, because it makes us think about the things I've been talking about. Thank you.
Actually, one of the things about the relationship between engineering and science is that engineering quite often causes science.
Yes, of course.
It's the other way round. Yes. It's not what people think. It isn't the application of science, it's the causing of science. And this question itself is sort of law doing the same thing.
Okay. Yeah. But computer people do the same thing.
Absolutely, yeah, precisely the same thing. So it's that sort of relationship. Right, I think Sophia's next.
That's right.
Adams Batty, who is now the Director of Policy at Wavelength Law, or Simmons Wavelength Law, having previously been Director of Policy at the Law Society. She tells me that she was attempting to escape from the establishment and to go into
not because I've done anything illegal.
To go into an edgy startup.
Yeah.
Except that edgy startup has been taken over by a giant law firm. but so she's back in the establishment,
Yeah,
but
never
still,
technically left.
still
I was
trying
still
to
on gardening
escape.
leave.
It's quasi edgy.
Yeah, quasi edgy.
Yeah. I get to wear not suits.
Yeah, excellent.
That's
Excellent.
the extent of mine not in the establishment. I'm going to stand up.
Yeah.
Mainly because I'm short, and secondly, also, I'm exhausted from having been up all night. And if I don't stand up, I fear I will be boring. So I'm going to stand over here with my notes and see if I can be some sensible addition to the conversation so far, which has been brilliant all morning, I have to say. So yes, thank you so much. I'm Sophia, I'm the Director of Policy at Simmons Wavelength, and just for those who have absolutely no idea what my attempt to leave the establishment was all about and what Simmons Wavelength is, we're a small startup, still are, but we're now part of the Simmons & Simmons family. We're essentially an organisation focused around bringing together a multidisciplinary approach to reimagining legal services. So how can we redesign and repackage legal services around the outcomes sought by using design thinking, software development, policy insights, user perspectives, and so on. And that might give you an idea as to why I approach this particular question of, is the law computable? And in my parlance, should we actually care? Do we care that it's computable? I think that's a relevant question. And the approach that I take, actually, again, is rather informed by our panel's chair. And I think about design thinking. I go back to the theories around engineering and the purpose of building systems around what? Around a purpose. What's the outcome we're seeking to achieve? And I think it's really important that we start there. Many of the conversations that I've participated in of late seem to forget that there is a purpose to the legal system. There's a purpose to the law. And maybe we ought to start there and what it is we're trying to achieve with it before we start to decide whether or not we're going to be applying various technologies to change it or deliver it in different ways. So what is the outcome? What's the purpose? What do we want from our legal system? And therefore, what is the endeavour? Why do we want to be able to make the law computable? Why would we want to do so? What's the wish? What's the desire? What's our end point? Well, the purpose of the law, I mean, we've talked a little bit, and in the previous panel, there were some really interesting conversations about whether or not the law actually gets there. But if you were to ask most people in the room, why do we have a legal system? They'll probably share views that are similar to, well, something about equitable distribution. It's something about empowerment. It's something about promoting the rule of law, about having systems that keep the system as a whole in check, where the power of the government is offset with the rights of the citizen. And at a global level, where we have treaties that seek to keep some form of order. And they're also a potential route to progress. Just bear that in mind, I think.
But I also think it does more than that. I think there's something really quite soft in the law. I think it does something far more intrinsic and valuable to the way in which society operates. It's sewn into the fabric of what the contract is between any one of us. It performs a form of a social function. We heard a little bit about that this morning. But not in hard black letter law terms. What I mean is in daily interactions. And there's a contract there between the individual's choice to opt into that system or not. And I think there is an almost constant balance between do I conform or do I not? And what we're doing there is we're checking in with ourselves as an individual, as a member of society, as to whether or not we believe in the society in which we live. Do I want to conform with the norms of the people around me? And why do I want to do that? Do I feel responsible? And there's something there about a moral, constant learning, relearning, reinforcement, evolution. And I think there is a danger if we check out of that because we don't have to practice that on a daily, second by second, minute by minute basis. We fall into this trap of a moral atrophy, the inability to even care about how we fit into the system in which we operate. I might choose to break the speed limit, but I'll still be racked by guilt if I do it past the school. And I think that matters. It matters to me because as an individual, I feel I need to be part of a society, and I think it matters to us as a species because we are a tribal state. And I think it matters to the fabric of society that we all have that internal conversation. And I don't see us talk about that, maybe because it's a little bit too difficult to describe, or maybe I'm just reading the wrong books, possibly both. So, okay, so having thought a little bit about what the outcomes are that we seek to achieve through having a legal system, through the law, through the application of the law, what is the outcome we're seeking to achieve through this endeavour of making the law computable? And I have to say, I'm not particularly impressed by any of the reasons I've seen for making the law computable, really. Almost entirely, and I spent my last 4 years embedded deeply in the world of legal technology, and I know Martin's going to talk more about that, so I'm not going to go into any of the detail here. But both in the public and the private sector, there's only one rationale. Anyone want to offer a view as to what that rationale might be? Profit, money, cost, yes.
Cost.
Tick, tick, tick. Absolutely. Efficiency, yeah. So in old Whitehall terms, it used to be the 3 E's: efficiency, effectiveness, and they're exactly the kind of E's that still play around. And I fear that there's a problem here, that we've replaced, and actually I don't really think efficiency is an outcome. We've replaced an actual outcome, a thoughtful endeavour. We want to make the law computable because it will do what? We've replaced that by, we want to make the law computable because it makes it quicker, cheaper, possibly more accurate, actually not. As if efficiency in its own right is merit enough. And there's a problem here, because efficiency often has deep tensions with things that we, in this social construct that we have, that we describe as our social contract, deep tensions with some fundamental principles of what I think forms a well-functioning democratic society. Accountability, accessible dispute resolution. You might say, actually, really good computable law might actually increase access to justice. Yeah, if you can afford it. Pretty sure I haven't seen many pro bono offerings on the market that really enable poor people to go into the court system and advocate for themselves. I've seen loads that are designed for the GC market to play and game the system so that they can get the best judgment in the litigation case. Haven't seen anything else. Our fundamental rights around privacy and civil liberties. We've heard about Compass. We talk a little bit about Predpol. I would advocate you all go and look at the Law Society's website. When I was there, we published a report on the use of AI in the criminal justice system. Let me tell you, it's not a good, happy ending. These are all tensions in this run towards efficiency. Why are we using these tools in those sorts of environments? Because it's cheaper. Why are we using AI in the deployment of policing? Because we don't want to pay for more police officers. Why are we using it for custody decisions? Because we think it might be quicker. Why are we using it to help us in parole outcomes? Because we think it might be more accurate. It might keep more people out of prison, and so on and so forth. Unchecked, we move very rapidly from a rule of law-based system, not to a rule by algorithm system, but actually to a rule by efficiency, where efficiency is supreme over everything else. And I don't think that's a society that I much fancy living in. So that was my thesis around outcomes. I'm going to leave you with two other thoughts very quickly because I'm conscious of time. The first is enforcement. I talked a little bit about this earlier today. And the relationship of enforcement. And I believe there is a connectivity here between the choice to enforce and not. And I think if we take that away, we do so at our own peril. We make things too binary. The vagueness of our legal system is exactly what we need in a society where values cannot be absolutely codified. And that leads me to the second point, which is moral evolution. What we believe today is not what we're going to believe in 2, 3, 5, 10, 15 years. Pretty sure of it. And what we need is that grey space in our legal debates to allow us to have that fungibility, as I referred to earlier, to manoeuvre around the edges, to allow us to give space to the evolution. In the most basic terms, people talk about the fact that if all you do is base your future decisions on the sorts of decisions you made in the past, you somehow solidify the thinking of your legal system. I think there's more to it than that, though, which is we need space. I can't remember who said it earlier, space for rebellion. I think that's probably something really quite powerful there. It's not just us as individuals that need agency, but I think the system as a whole needs space for agency. And if you remove that, you remove the legitimacy and the connectivity between the values of society and the functioning infrastructure of your justice system. And if it doesn't speak to society, you end up with a democratic deficit. And then no one cares. And on that rather depressing note, I'll say that I won't pretend that those concepts I've just set out for you don't have all sorts of holes in them, but I think they're thought-provoking enough to make us want to consider, even if the law were computable, would we want to?
Thanks. Thanks. Our third speaker is Martin Ebers, who's Associate Professor of IT Law at the University of Tartu in Estonia, and also a researcher at Humboldt in Berlin. And I suppose most well known in this field for being the founder and president of RAILS, the Robotics and AI Law Society.
Yeah, thank you so much for having me. I will not even try here to answer the question whether law is computable, but instead focus on the implications of legal tech services on consumers, customers, clients, and the regulatory framework we have in this field in Europe, and ask the question whether the legal framework is actually fit in order to deal with the risks legal tech product services cause. So what do we have in the market? Well, we have legal tech products and services providing infrastructures, marketplaces, legal information, sometimes also legal advice in the sense that it is already tailored to the individual client. We have document, contract automation, doing drafting and reviewing stuff. We have dispute resolution services, sometimes also algorithmic automated decision making. All this comes in different forms of communication, forms of websites, chatbots, virtual assistants, and apps. And I think what is especially important is the distinction between hand-coded knowledge and the data-learned knowledge, because it makes a difference if a system is based on logic operations or whether it's based on machine learning and on these statistical correlations that can be found in data. It makes a difference, especially in terms of transparency, explainability, and so on. Well, there are clearly advantages for clients, consumers, customers. Legal tech services increase the awareness of legal problems, might give consumers also wider choice. They might increase price transparency, maybe lead even to better quality or better access to justice, or at least in the sense that especially small claims that usually are not enforced by consumers are now taken to court. But of course, there are also risks for clients. So there might be an access and a choice problem, so that those who do not have access to digital knowledge or digital services at all are excluded. It might be also because legal tech companies are profit-driven, that they do not take a claim simply because the prediction for this, for the outcome of the dispute is negative. We might have a problem of transparency, that the legal advice that is given cannot be explained. How about the quality? So who makes actually sure that legal norms are translated correctly into code? How about the fairness in the relationship between the customer and the legal tech companies? How about redress problems and representation? So when we have a look now on the current legal framework, I would like to highlight especially 3 fields of law that come together. So, and legal tech services somehow fall into the center of all these 3. Well, we have consumer protection that is pretty much about economic rights and both about procedural and substantive fairness. Procedural fairness in the sense that a lot of consumer law is about making sure that the consumer has a free choice. So we have a lot of information duties, we have rights of withdrawal and so on. But it's also about substantive fairness. So think, for example, about the Unfair Contract Terms Directive, giving the courts the possibility to review contract clauses. But in the field of legal services, of course, we have in many, many countries legal services regulation. And this body of law is also largely justified not only by public interests, but also of customer protection. So therefore, in the field of legal tech, in case legal services regulation really applies, we might say, well, there is a paternalistic approach to consumer protection, because on top of all what we have in Europe in consumer law, there's also the legal services regulation. Then we have data protection. It's basically about fundamental rights, but not so much about the substantive fairness, but more about the procedural fairness, in the sense that it doesn't matter so much the outcome of the data processing, but more the way how data is processed. And then we have, last but not least, also some overlapping between legal services regulation and data protection, in the sense that if it falls under the legal services regulation, then we have the legal professional privilege. So then data, customer data, is even more protected. So if we now have a look on how the situation is in Europe, please correct me. I took all this information from a report from 2012 and highlighted here in red all those countries where legal advice, so not acting in court but out of court, just giving legal advice, is seen as a reserved activity for lawyers and restricted. Whereas in all the other countries that are in green, the legal advice is not a reserved activity. And if we now apply this to the legal tech services, then we might ask, of course, the question, is this something that is regulated, that falls under the legal services regulation or not? And most countries that regulate legal advice do it in a sense that they say, well, there is a difference between legal information and legal advice. So in case the legal information is given in a very standardized way, for example, in a manual, in a book, and so on, then it is something that is, of course, not regulated. In case it is tailored and it takes into account the individual needs and the situation of the client, then it is legal advice, and that is then regulated. And in other words, you could also say there is this distinction between the legal product and the legal service, and the legal service is subject to control, at least in many countries. And legal tech now is blurring these boundaries, and the challenges, I would say, that arise from that are twofold. First, there might be the risk of over-regulation of legal tech companies, but there might be also the risk of under-regulation of legal tech companies. And now in the remaining kind of 4 minutes, I will focus basically at the risk of under-regulation. So ask the question, what actually happens if legal tech falls outside the national legal services regulation? And in that case, there's considerably less protection for clients and consumers, in the sense that there are no minimum standards of quality and ethics, there's no neutrality of legal tech providers, there's at least no written prohibition of conflict of interests, there is no legal professional privilege, and there's no redress to the Bar Association, and also there is no mandatory insurance policy of legal tech providers. So this leads then to the question, well, how about consumer law? In case it doesn't fall under the legal services regulation, maybe consumer law, European consumer law, can help. So what is the regulatory framework we can find? We have the Unfair Commercial Practices Directive, we have the Consumer Rights Directive, we have the Services Directive, we have the Unfair Contract Terms Directive, we have or we will have pretty soon in Europe the Digital Content Directive, and then some enforcement mechanisms. And then the first question is, of course, are all these directives or the national law transposing the directives applicable to legal tech services? And there we can find some case law of the Court of Justice of the European Union. So in one case, the court held, yeah, in case we have a client and a lawyer, then the client can be regarded as a consumer and the lawyer as the business, with the consequence that, for example, the Unfair Contract Terms Directive applies to this relationship. How about platforms that are more intermediators? Well, there we have also the Uber case where the European Court of Justice held that under certain conditions also consumer legislation might apply. Also, some legal tech companies are offering their services for free, in the sense that they only want the data of the customer. And there we have, with the new Digital Content Directive, at least a hint that in case the counter-performance or the performance of the consumer is the data, that might be regarded then as a real performance, and with the consequence also that under certain conditions, consumer law applies. So in case it applies, what kind of consumer protection instruments do we have? Well, we have the prohibition of unfair commercial practices, but the problem, of course, here is that we have no established standards of professional diligence when it comes to legal tech. We have information requirements in European consumer law, but most of the information requirements are really standardized information. There's no requirement of giving individual advice, and there are no special safeguards for algorithmic decisions. We do have a right of withdrawal, but only if legal tech is provided as a distance contract. Then how about the quality of the service? Well, it might be possible, but that's still under discussion, to regard legal tech as a digital service under the Digital Content Directive of 2019. But here then again, we have no established objective conformity standards for legal tech products. The same applies somehow also to the fairness check of contract terms between a customer and the legal tech company. We do have the unfair contract terms directive, but again, no established standards for fairness of contract terms if legal tech is not subject to the deontological rules. We don't have a EU claim for damages, and further gaps of EU consumer protection. Well, for example, we don't have special rules for chatbots. We don't have special rules for intelligent systems. There are, of course, new information asymmetries due to big data analytics and black box algorithms. And then there's the general problem. The whole European consumer law is based on the idea of standardization, whereas intelligent systems lead to an individualization and personalization. I can elaborate on that in the discussion. So what's the future framework? Well, there are different approaches of regulators, wait-and-see approach. Some especially the bar associations in Germany, where they were very active in claiming against the legal tech companies. That is seen as a competition, of course, for the established lawyers, and therefore they really try to prevent the legal tech companies to act on the market. And the legal tech companies, they are not law firms, but they are tech firms. So therefore, the bar associations, they claim that they, the legal tech companies, fall under the the legal services regulation. And that would mean, of course, that they cannot act anymore. So this is an ongoing thing that concerns not only Germany, but here's like only one example. The Regional Court of Cologne held that Smart Law, that is a platform run by Cloovers, is a legal service and therefore cannot be run anymore. It's subject to appeal, and so this was like a contract generator for consumers. Last but not least, I think if we talk about the future regulatory framework for legal tech services, I think we should also take into account alternative approaches, such as, for example, the sandbox model that is well known in financial markets and could also be a way forward. Thank you very much for your attention.
Thank you, Martin. That does raise the possibility of meta-tech. So you have a computable law about computable law. Anyway, so we have 10 minutes for questions. Where's the microphone? Oh, there it is. Okay. So who would like to ask a question? Yes. Could you wait for the microphone so that those who need it can hear it? Thanks.
This is perhaps as much an observation as a question. I'm a little concerned about what feels almost like a vilification of legal tech. I think as lawyers, I'm speaking as a lawyer, we have to reflect on why we have ended up here. And it's partly because we're too expensive. And also to say, universities have the opportunity to do pro bono legal tech work. Ulster University, I know, is doing quite a lot of work in the access to justice space. I think we have to be careful to recognise the positives. It's true that government is very much focused on financial efficiencies. But I don't think we should forget that some good stuff is being done in that space, and that, as I say, the cost of lawyering, the cost of legal services is partly responsible for the rise of legal tech. And to that extent, legal tech has to be seen as a positive contribution to access to justice. You know, of course there must be concerns about whether the advice is accurate. Of course there must be concerns about, whether the consumer is protected. But I think there needs to be some balance, and I asked the panel if they would agree with that.
Who'd like to comment?
It's probably worth saying, and I think you're absolutely right, and in the face of potential progress and potential disruption, it is quite common for established professionals, wherever the sector might be, to find that threat to be something worth vilification. And there are lots of potential use cases of good here. My journey to Wavelength started because we developed a open-sourced, voice-operated legal pathway, right, which we gave to the HMCTS to say, if you want to reform the court system, here's a way of doing it, where you don't, as a consumer, as a person on the street, you don't have to be literate. You just need to be able to speak. And by the way, you can do it in any language, because you can just run it off Alexa or Siri or something. There are loads of potential use cases. The concern I have is that the majority, I've done loads of mapping as to where the funding is going into legal tech solutions and where that's coming from, both in private equity or other funding. And the majority is in B2B. It's not actually focused on the access to justice gap at all, even though it could beautifully help in the access to justice gap. Lots of applications which are not anywhere near giving advice. They're more closer to the public legal education space. So understanding your legal rights, early advice. I mean, government, of course, would say, solve that and we don't have to ever plug the legal aid gap. No, that's an absolute lie. We are always going to need to help those with some financial means, because there comes a point where you are going to need representation, and that at the moment is not something you can acquire from a really smart tech piece of kit. But I mean, I speak from sitting within a legal tech company. We see lots of positive uses, but more than often they are automating rather than completely reinventing, and they're working alongside legal providers rather than replacing, other than in the spaces of automating contract review. The old days of having to train a trainee by sitting them in a darkened basement for 5 months so that they might know what a change of clause contract looks like.
Did them a power of good.
It did them a power of good, yeah. They earned their stripes for them. I don't think we need to do that anymore. So there's huge amounts of efficiencies, yes. But I worry that we're not actually focusing on the right sorts of potentials.
John.
A couple of points. Efficiency comes up all the time in these conversations. And if you were to look at what digital technology has done in the last 30 years, one of the things it has done everywhere is it has dissolved value chains. That's what it does. It takes an activity which requires a number of different sort of components, some of which are expensive and some of which are profitable, and it simply dissolves the chain that links the two and takes away the profitable bit. For example, that's what happened to newspapers. Newspapers are value chains. They have expensive stuff called journalism, and they had advertising which paid for this expensive stuff. And along comes the web in 1995, and it says, okay, we'll do the web will do the advertising, and suddenly the value chain gets dissolved. It unbundles almost everything, and we have seen in the last 20 years, in the last 10 years in particular, unbundling with a vengeance. That's why the streets out here are full of guys on bikes with Deliveroo, and so on. So you have it has a general kind of power and function, and that's what it's been doing. AI is a late arrival to this scene. Now, what's that about? Well, part of it is about efficiency, and part of it is about convenience. And the thing about efficiency is that I can see why it makes sense if you're running a company, and I can see often why it makes sense in the public sector, where you're using taxpayers' money and you want to be more effective. What concerns me a lot is the way in which the public sector has started to think of itself as if it were a private business, and therefore to prioritize efficiency at all costs. Now, there are some cases where efficiency really makes sense in the public sector. There are some cases where it makes no sense at all. An example, one of the most inefficient systems liberal democracies have, by a mile, are its criminal justice systems. Because it's fantastically inefficient to run a system which says that instead of the chief of police saying that guy goes to jail, you go through this nonsense about he's innocent until proved guilty, he has to have a fair trial, there has to be a process, there has to be a representative. This is a nightmare of inefficiency. The Chinese don't bother with it, by the way, but anyway.
Same with democracy.
Yes, exactly. But the point is that why is our criminal justice system so inefficient? Some of it, of course, is because we're incompetent at organising stuff. But actually, at the core, it's because our values insist on it being inefficient. Inefficiency is a public good in that area. And in lots, but not all, of public services, inefficiency has to be prioritised rather than denigrated. And I think that that's one of the That's one of the challenges that we have in the public discourse about all of this stuff in relation to both the private and the public service. Jeff Bezos has a saying, which is that show me somebody's margin and I'll show you an opportunity. That's the way it works. That's the way the tech works. And perhaps within capitalism, that's fine. Within the public sector, it's not. And therefore, we have to be very discriminating about deciding what's deserving of prioritizing in terms of efficiency and what's not.
Martin, lawyers' margins caused by restrictive practices, basically.
Well, I mean, it's also true for the German market that B2B legal tech services are more popular, or that the market is dominated by that. But on the other hand, we have also a lot of law tech or legal tech services provided for consumers. So, for example, in the field of to get a speeding ticket, and they have thousands and thousands of cases. Or, for example, there's another platform providing consumers the possibility to check whether their rent is too high. And they have, again, also thousands of cases. Of course, they are all profit companies. But on the other hand, we have a movement also in Germany among the students, because the students, the law students, they began to realize that somehow all this technological change might be a problem for them when they graduate, and therefore they started kind of 2 years, 3 years ago in various universities to form associations, legal tech associations. And what we did, for example, at the Humboldt University is that we tried to coordinate this in a way that we try to integrate also legal tech services into the law clinics we had already. So we have, for example, a consumer law clinic, and they are working then in cooperation with the legal tech or with legal tech companies, providing the software and the access to it, and then they try to build tools. And I think that is a very useful way, because then you have pro bono work, and also you get the students somehow closer to the technology.
Right, we'll take one more question. Simon, is that okay? Okay, just one more. Yes. Over there, thanks. Sorry, no, sorry.
Should we take them?
Well, we'll take them both. Take them both. Sorry, I didn't see you. Martin was obstructing my view. So yes, 1, 2. Yeah.
I'll keep it very short. Maybe just a remark then. I think, from a computer science perspective, law is not computable, very clearly. I think, from a computer science perspective, nothing is computable.
Yeah, that's right.
That it has never stopped anybody from computing.
That's right.
And
this is
this
the
is not
domain
just
problem.
funny, but it's very important. So I developed a theory, if you want to call it like that, called agonistic machine learning. So the basic assumption is no, this is about privacy in the self. No, the self is not computable. What does that mean? What is the implication? That it can be computed in many different ways, and that each different way makes a difference. Some ways are just crap, nonsense. Some ways are interesting. Some ways are in this situation, in view of this task or purpose. Good. So my attitude towards computational law is no, law is not computable. It's important to explain this again and again, and to ask computer scientists themselves to explain this again and again, and then to say, okay, that means that when you develop legal tech, for instance, based on machine learning, that you point out from the choice of the training data to the validation data to the out-of-sample data to the development of your feature space, to the development of your hypothesis space, to which machine-readable task, what performance metric. Each of these choices makes a difference. Each of them have trade-offs between themselves, but obviously also in terms of different types of cost in terms of how much you have to pay somebody, externalized cost. In time, do you want something very speedy? Okay, then you're going to have that's going to be a trade-off with other stuff. So I'm worried if the conclusion of no, it's not computable is we can now afford not to look into the inside of these systems. The conclusion should be the people that are going to be affected by those systems must be brought in. And that's a very difficult task.
Thanks. Beautiful. Yeah.
So I'll also make a very quick, so my question is very quick. And it's mostly that I felt that one of the elephants in the room in this discussion might be the question of labor and the impact of legal tech on the legal profession. And so I'm interested in your thoughts on that, and specifically whether you think that if we assume that perhaps law can be computed, whether that might change some of the ways that we think about law and doing law in different types of professions.
Good. Final comments. Martin, why don't you go first? Two very big.
Yeah, the first was more, I think, a comment. Yeah. And the second, so what's the question?
Should I repeat? So basically the impact of legal tech on the labor force, the kind of legal professionals service.
I think what we can observe already is that there is a high and a higher pressure on the courts to deal with more cases that would never have gone to court before. And in order to deal with this pressure, I think there will be also, being made the consideration whether the legal system itself has to use AI systems or machine learning systems or other ways how to automatize the law.
I'll tackle the labour point very quickly, and then just a very quick reflection on the other points made. There will absolutely be an impact on the nature and size of the legal profession as we deploy technology, whether it be AI or anything that is not AI, which is a whole load of stuff, actually, which is often packaged as AI and isn't. Because there's lots of things that we do currently which are hugely analog driven, and the processes by which we deliver legal services at the moment are absolutely built around the legal profession and not around the user needs. And I think as that changes through the deployment of both the ability to have greater transparency of a process, so some of the technologies available do that, and the ability to bring multidisciplinary teams to that endeavour, you inevitably break that up and deliver it in a different way. Now, in the medium term, I think what that means is you're going to need a whole different load of skill sets to be a successful legal practitioner. Right? So the whole changing of skills track, that will move along. People will chase the value up the chain. So the low value stuff will go. You're not getting paid for contract review anymore. So you go and, you chase it up. You give greater value. You might, if you're in the B2B, give your corporate clients a whole bag of other advice alongside some of this legal insight that you have, to service their needs, which aren't just law in isolation. It's normally a legal problem in a context of a whole bag of other stuff. In the much longer term, I think people are split as to whether or not that's a really disruptive model and you need far fewer people to do that job, or are you just changing the very nature of legal services? You'll probably just need the same number of people, but they'll be doing a lot of very different things. Jury's out on that. And then the final point on that is, if we get the A to J piece right, there's a whole bag of untapped work there that currently isn't going anywhere because no one's got access to justice in that space. And actually being able to service that, even if it's low-level work, would be incredibly helpful to society. So I think that changes the nature. And then very quick, the comment I think I wanted to make there is I think the answer has to be to build our reflections around the user here. If we don't build user-centred solutions, we lose sight of the very purpose of what the impact might be. So, if you put the user at the heart of the problem, you may actually, both in insight, so at design stage, but also at testing and acceptancy and so on. But that is a world away from where we are at the moment, I imagine. Afterwards, we can talk. Yes.
I think we need to talk about this. John.
Just want to say, I mean, you're right in there's something wrong with the discourse between those of us who must use these systems and the coders and engineers who will design the thing to make. There are because the thing is almost entirely fungible. There are a million different ways of coding anything, and what we have wound up time and time again with is one way of coding it, which is what a particular programmer or a particular software team prefers. One of the most staggering things about Facebook, I remember when it first appeared, was the fact that the only thing you could do on Facebook was that, like. And I was outraged by that from the very beginning. There was no dislike. Okay, but the point of it was that somebody had decided that the entire gamut of human response to anything has to be channeled through this very narrow aperture. Well, that's an example of the way in which we have allowed that sort of one-track thinking to persist. It doesn't have to be like that. Part of the problem may well be that we, as representatives of the user, have not been demanding enough in order to insist on a variety of options in terms of how things are done. But that's the problem with that is as much on us as it is on engineers, I think.
I think what I take away from this is it's all about this is revealing the nature of law to non-lawyers in a frightening way. I need to be worried about this. Fred Riddell, great hero of the realist movement, says somewhere in Woe Unto You Lawyers that the law is the killiloo bird of the sciences. The killiloo bird, you'll remember, flew backwards because although it had no interest in where it was going, it was mightily interested in where it had been. That's the view of the law that lawyers give to the world. But in fact, in reality, the killiloo bird has got a tiny reverse view mirror. And that's the bit that's not being coded. So anyway, thank you for the panel.
To the next session and final session as it happens. 3 speakers. Again, looking forward to a very interesting session. Ryan Abbott from Surrey University, Lily Hans from Cambridge, and Mireille Hildebrand from Brussels. Thanks to all of them for agreeing to take part. And first of all, over to Ryan. Thank you.
All right, thank you. Hey everyone, very excited to be here today to speak to you about punishing artificial intelligence, which clearly ranks sexier than my last paper on taxing artificial intelligence, so you're in for a treat. This is an article that Alex Sarch and I at University of Surrey just published in UC Davis Law Review, but which will also be making its way into Simon's new book, so you can read it twice. But better in Simon's new book, right? So people have already talked a bit about some of the amazing human-like things AI is doing now. Of course, a few years ago, famously, Google's DeepMind AlphaGo beat the world's leading champion at Go, and people thought that would take another decade because of how very complex Go is. Go was the last board game at which people could outcompete machines. And so there's now an entire field of human activity that AI does better than people, and not just better, but much, much better. And it's not just doing things like playing games or video games. It's working on StarCraft now, and I tell my students when they're playing StarCraft, you're wasting your time, but they weren't listening to me anyway. It's doing all sorts of useful, practical things, the job of a doctor, lawyer, and scientist, and it's doing criminal sorts of stuff. Not DeepMind, but a few years ago, this was a art project called Random Darknet Shopper. Random Darknet Shopper got $100 in cryptocurrency each week, went on the dark web, bought some random thing, it went up in a Swiss art gallery. You might imagine in doing that, it got a bunch of counterfeit stuff, got some ecstasy, got a Hungarian passport, was posting about this on social media, so sure enough, the police came by and arrested everyone involved, including Random Darknet Shopper, if you could call it that, and Random Darknet Shopper, of course, was an artificial intelligence. If it had been a person, it could have been criminally liable for that sort of thing, and so could the people involved in it. As a legal matter, I think that case is a little more straightforward because, indeed, people were involved in it. Even though the AI was autonomously out doing things in a criminal sort of way that would be criminal for a person, people programmed the AI to do that thing, and even if it was unforeseeable it would buy ecstasy and a Hungarian passport, I think it's pretty foreseeable if you give someone money and tell them to buy things on a dark web, you're going to get something illegal. Plus, they hung the stuff up and whatnot. But machines can do more than this, right? Certainly hypothetically, at least. People contribute to open source programs, so you have lots of people programming these things spread over time and space. You have decentralized AI existing on many different computers, so not just one. You have AI that can behave in ways that are legitimately unforeseeable to people, which means that we can have AI engaging in criminal sorts of activities in ways that aren't irreducible to the wrongful acts of people. Which means, again, you could have an autonomous entity out doing criminal sorts of things with no one practically or legally that you could hold criminally liable, either because a large number of people were involved in it or they contributed to this sort of behavior in ways that weren't even negligent at the time, unexpected things happened, and now you have Random Darknet Shopper out buying, selling ecstasy, moving to an apartment in Miami, and what are we going to do about something like that? Well, you could convict the AI of a crime. That sounds kind of far out, but it's something people have proposed. Increasingly, policymakers, academics, and people who haven't thought very much about it are suggesting we should have rights for artificial intelligence. And rights and obligations often go hand in hand. So if you're going to give a robot rights, it stands to reason you might have a robot be accountable for committing a crime and punish it also. Intuitively, your first thought might be, that's just stupid, but that didn't stop me and Alex from spending a very long time thinking about it. And you might be surprised with what we came up with, right? And the question's not so much, could you punish an AI? Because I think the answer to that's simply yes. Right? Politically, you would have challenges, but
particularly in the UK, Parliament can pass any law it likes. It isn't even bound by a written constitution. So if everyone decides that instead of Brexit, we really need to be dealing with robot criminals, you could wake up tomorrow to a country full of robot citizens who could be convicted of crimes. In fact, English law used to provide for something like this with the remedy of deodand. So as far back as the 11th century, if an inanimate object or an animate object killed a person, it was considered accursed and given to God. That could be a horse or a tree or a hay barrel. And Parliament didn't formally abolish the practice until 1846. So laws change all the time. The law could change to do this. The better question is, should the law change to do this? Because changing the law has costs, particularly radical sorts of changes, and inappropriate changes threaten to undermine the rule of law and trust in law. And if we're thinking, is convicting robots of a crime a good idea? Well, you really have to look at the costs and benefits of doing that. This is somewhat different than the question of, well, if you decide it's a good idea to punish a robot, how would you punish a robot, and could you punish a robot? You could certainly reprogram it or destroy it. Right? That would be an adverse consequence to a number of things. Whether or not it would count as literal punishment to an AI is an interesting question. Hart defines punishment as requiring it to have negative consequences, and AI probably doesn't experience anything, AI doesn't experience anything in a way we would call pleasant or unpleasant. So an AI wouldn't mind being destroyed. Some philosophers have argued that really things have characteristic functions and interests, even things that don't have consciousness, like plants and animals. Maybe animals have consciousness, but a tree that is flourishing has an interest in flourishing, and if you were to chop down the tree, that would be bad for the tree. Right? So maybe in that sort of thin interest sense, an AI has a function, it's programmed to do something, and you're keeping it from doing it. That might be one way of thinking that it's an unpleasant outcome. Other philosophers say, no, you really have to have the capacity for cognition, to have genuine interests, to have desires and beliefs and aims, and if you don't have that, you can't have it. We also do punish people even when they in no way objectively or subjectively experiences it as unpleasant, right? So some people want to go to prison because they're going to get good health care in America, because they want to further a political agenda by being imprisoned, because they just really have always liked the idea of prison. And so convicting them of a crime and sending them to jail for them could be both objectively and subjectively beneficial. We'd still call it punishment. Right? So maybe it's enough that it's just the sort of thing that we think of as punishment. Or maybe this is where punishment and conviction come apart, and it makes sense to say, well, we're going to convict an AI of a crime, but it's not technically punishment in the sense that an AI is not experiencing it negatively. But there could be benefits to doing that, right? One is it could produce general deterrence. So it could discourage other commissions of AI-generated crime where no human being is involved in a criminally culpable sort of way, right? Presumably other AI won't be sensitive to the prospect of punishment, so threatening to punish an AI wouldn't deter another AI, but it could deter the people who build, own, and use AI. For example, if your AI, an AI that you're commercially benefiting from, does something wrongful, we punish and destroy it, and you lose the value of that AI. Or punishing AI could be associated with a fine for the AI's owner. So it would be a way of less directly targeting the behavior of people who ultimately go on to contribute to AI-generated crime. And it could also have expressive benefits. So if you buy ecstasy from random darknet shopper and overdose and die, your parents may want to see random darknet shopper punished, to see the state reaffirm their rights, and that they were unfairly a victim and that the wrongdoer has been punished. Punishment shouldn't just have benefits, though. It should not offend deeply held commitments about the criminal law, like justice or fairness. With people, the most important of these revolve around culpability. So it's at least our default principle that we only punish culpable behavior. And the desert constraint says that someone should not be punished in excess of what they morally deserve. So even if you're jaywalking and we were to kill you and that would make an example and we'd prevent people from jaywalking, we don't really want to do that because it would be unjust. It would violate your desert constraint. Sometimes The desert constraint has a lot to do with moral blameworthiness, requiring an intent that you're going to do something harmful, but can also be based on recklessness or sometimes even negligence, that you're not being sufficiently concerned about legally protected interests. Right? The limitation with AI is a little bit different. So we're less concerned about violating the rights of AI. In fact, we're not at all concerned about violating the rights of AI because AI doesn't have rights. It doesn't experience things negatively, so we could use AI as a means to an end in a way that you'd be concerned about using a person. But we also have a culpability problem because AI really doesn't have mental states in the way that we think about it. And so AI really doesn't have deliberative capacity or maybe the ability to be culpable in the way we do. And so maybe punishing something without the capacity for culpability violates something deep about criminal law in a way we don't like, right? We don't punish infants or insane people, although with people we don't do that because it would be unfair to them, because it would punish them more than they're morally deserving of. AI wouldn't have that problem, but we might not want to punish AI because it's not doing the sorts of things we're concerned about. And that might underlaw the principles of criminal law. Oh, I'm missing a slide. Well, there was a great slide before this. We're going to spend a little extra on this one. So there are some solutions to this problem because, indeed, we already punish artificial persons in the form of corporations, and corporations don't literally have mental states, right? The solution there is that we impute mental states to corporations through respondent superior. We say, well, a company is made up of people, and we're going to take the mental states of those people and say the company had those mental states, and so that gets us over that, right? So maybe for AI, we could do something similar. We could say, well, there's people who build and own and use AI, and those mental states should be attributed to AI. Of course, that's less helpful in the case we're really concerned about, which is the AI where you don't have the people behaving culpably. Right? Another option is to say, well, we don't always require mental states. We do have strict liability crimes. And we generally don't like those because you're punishing someone even when they aren't culpable, right? So strict liability means liability without a wrongful mental state. But for the same reason we're concerned about it with people you haven't really done anything blameworthy, we're less concerned about that with AI because we don't need the AI to have behaved in a blameworthy way. It could be enough just that the AI did something we're really concerned about. Criminal law also requires something be part of a voluntary act, right? So if you batter someone as a result of a seizure, you're not liable for that. You didn't voluntarily act, right? And AI has a similar sort of problem there, maybe. Although maybe AI does have the sorts of reasoning capabilities needed to engage in action. Even if it doesn't, you can have criminal liability based on omission to act. And so punishing an artificial entity based on strict liability without a mental state, even for an omission to act, is something our criminal law already accommodates, right? So it's not that big of a departure to think about doing it for AI. You know, I'm running out of time and don't want to cut into drink, so I'm just going to speed up a little bit due to poor timing on my part. But you could also argue that AI really does have mental states, right? They're not quite human mental states, but they do analogous things to human mental states. So if you had a self-driving car that was tracking someone's walking and adjusting its driving in a way that you could infer from evidence was leading them to collide directly with them, right? That could constitute knowing an intention to commit a certain antisocial act. Right. But even if AI has some benefits and we get over some of these conceptual limitations, there's still costs to doing this. One is it's really quite a significant legal change to punish AI legally, which might require things like giving AI personhood, which would be a very significant disruption we wouldn't want if we didn't have very good need. It could also send the message an AI is like a person, which could lead to, say, rights creep, which is AI getting more rights over time. We've seen that with companies in the United States, which are now essentially people, and they can't quite marry yet, but they're getting close to it. And damaging an AI when it's done something wrong could have spillover effects with all sorts of harms to other parties. So there are some benefits to punishing AI, right, along with what look like some pretty substantial costs. And even though criminal law does seem like it's going to fall short as AI becomes more common and autonomous and advanced, there may be other ways of dealing with the same basic problem, that you have crimes being committed without a person you could directly hold liable. Right? And probably the easiest way to do that is to extend new sorts of criminal duties or perhaps even civil duties, so creating new duties to responsibly design AI, to remain accountable for the acts of AI that's acting on your benefit, or to have new civil claims for damages caused by AI where you currently have gaps in civil liability. Civil liability is probably a better solution right now, given the lack of evidence we see that this is a big problem right now. But again, AI is improving exponentially and people are not. So it is not, I think, unreasonable to think that in 10 or 20 years there's going to be a lot more AI interacting with us in harm-causing ways that we're all concerned about. And I'm running out of time, but just to end on this, I think thinking about AI being punished is not only interesting for thinking about AI being punished, but what it can tell us about criminal law theory and punishing people more generally, right? So there's a school of belief in philosophy of criminal law, determinism, that really there isn't, hard determinism, that we don't have free will, because if you were to recreate the exact situation of your life with your genetics and your family environment and all the opportunities you were exposed to, people could only really ever do one thing, right? So they make choices, but those choices have all been predetermined. And if your choices have all been predetermined and you don't have real free will, then it's not clear that culpability and blaming should play such an important role in the law. Because if you never had a choice to do some sort of antisocial behavioral thing, why would we punish you for it? And I think AI punishment provides an answer to that sort of thing, because with both AI and people, we're concerned about the same sorts of antisocial behavior and constraining it with discipline the same sorts of ways. And I think that AI is teaching us maybe that retributivism, or these theories of punishment we have about when someone is culpable, really doesn't require moral blameworthiness so much, right? Maybe it doesn't matter so much whether someone doing something bad really genuinely meant to be an awful person, or they were just acting in ways that demonstrated insufficient regard for legally protected interests, right? Criminal law seems to care more about that thinner thing. Are you behaving in a way that shows a lack of respect for my safety, rather than have you been fantasizing about murdering me for the past 30 years because you'd find it very enjoyable? And I think it also helps to immunize challenges based on hard determinism for criminal law, because it says, even if our choices aren't really morally blameworthy because they were predetermined for us, they are still antisocial and the thing that the criminal law is designed with preventing. Which I think also, have I run out of time? So I'll just end by saying robots.
Lily, thank you.
Great, good timing.
Oops, let's go into presentation mode. Cool. Excellent. Okay. I want to start today with a couple of hypotheticals. If my father is in the early stages of dementia, but has days when he's still pretty lucid, can he still validly change his will? Can doctors legally force feed through a nose tube and against her will an otherwise normal 18-year-old who has anorexia nervosa? Does her refusal of sustenance indicate that she can't decide rationally? And how is this any different from a Jehovah's Witness refusing a life-saving blood transfusion? These are the kinds of issues that regularly come before the Court of Protection here in the UK and in other mental health courts and tribunals around the world. Such courts are empowered to determine whether or not a person has the mental capacity to decide for themselves and to make decisions on behalf of those who don't. The court's decisions have fundamental consequences for some of the most visceral aspects of our lives and bodies: blood, food, sex, pregnancy, birth, marriage, death, liberty, property. These decisions impact us, the people we love, and the society that we live in. So why am I here at a conference about AI and law talking about mental incapacity? Well, because AI, as we've heard, is starting to colonise law and legal decision-making, and I want to argue that there are some areas in which it shouldn't. And I'm very fortunate that in giving sort of an illustration, more of an illustration of some of the theory, I'm very grateful to the previous speakers for articulating it, all those different debates so well. So specifically today, I'm going to try to convince you that the threshold for using AI in mental capacity decisions should be either very high or insurmountable. And of course, many people instantly recoil at the idea of AI being used in mental health and mental capacity determinations. But it's actually quite difficult to articulate exactly what the problem is. And the problem is that in the absence of a good rebuttal, mental health law is, like criminal law, technologically and politically vulnerable to AI colonisation. I'm going to argue that incapacity is a socially necessary concept, but also highly fact-sensitive, inherently uncertain, and unstable as a socio-legal construct. And because of that, we need a human and not a machine making the call, regardless of how advanced the technology might become. So even if we can, we shouldn't. So this is the statutory test for mental incapacity in the United Kingdom. So there'll be a lack of capacity in relation to a matter if on the balance of probabilities and at the time of the determination itself, a person is unable to make a decision about that matter for themselves, the so-called functional test, and that inability arises because the mind or brain is impaired or disturbed in its functioning, the so-called diagnostic test. And someone will be unable to make a decision if they can't understand, retain, use or weigh the information relevant to the decision, or they can't communicate that decision. I'm just going to grab some water. Okay. So, that's pretty clear, right? Well, it's not quite that simple. There's no single legal denotation of incapacity, no single way it's applied. The exact threshold will depend on potentially limitless combinations of circumstances concerning the unique individual in question. Also, the purported decision and relevant background issues. Identifying and weighing these can be exceedingly difficult. So in each case, the court must pragmatically apply its own conceptions of relevance, weight, and value in an attempt to reflect as well as possible the underlying concerns of the particular case alongside public policy concerns. And although some rules of thumb emerge from similar fact scenarios, most cases are really not generalisable into rules. For example, Gunn et al. Noted the difficulty and necessity of careful discussion in making the value judgments necessary to define which specific elements of a blood test it was essential for a patient to understand, and they had quite a lot of discussion about this, so you can imagine for more complex things it would be even more of an issue. But the indeterminacy of the concept of capacity is not really a failure of modern mental health law. Mental capacity has never been an objective, scientific, materially observable fact. It's a legal, clinical, ethical, and social construct contingent on social and political contexts. The law itself has been used to encode madness and forms of otherness into normative socio-medical ideas of who has legal capacity. And the notion of legal personhood itself is intrinsically but not uncontroversially linked to both embodying and employing reasonable and rational behaviour. I mean, we only have to look at the history of mental health science and the law around it for stark glimpses into this issue, and especially what it means to be neurotypical. For example, we might all smirk at the Idiots Act, 1886, which very helpfully distinguished between lunatics, idiots and imbeciles, and then they decided that that wasn't enough, and they added feeble-minded people and moral defectives in 1913. But it's probably also worth remembering that something like hysteria didn't leave the DSM, the Bible of modern psychiatry, until 1980. And we can see that the history of mental incapacity is incredibly gendered as well. Change to the definition has come from scientific developments, like better treatments, but also social contestation and more subtle shifts within judicial understandings. Today, most of the really controversial cases are decided on the use and weigh test in order to accommodate social disagreement. notably on risky or self-harming conduct. So to do this, the court has to make judgments about the reasonableness and relative status of beliefs, reasons and values. So they've made a distinction between someone refusing treatment for anorexia and intravenous blood transfusions by Jehovah's Witnesses, basically as part of a public policy recognition that it's a kind of socially recognised belief, a religious belief, as opposed to being so overwhelmed by the compulsion not to eat that basically your rationality no longer exists. But in such cases, there is no comprehensive... Oops, I might have missed a slide there. Okay. In such cases, there is no comprehensive evaluative standard to distinguish between pathology and eccentricity or unusual influences. Capacity assessments can't be purely technical or reduced to a set of static criteria or procedural principles. And Camelia Kong notes that the judge's own assessment of the social context really determines what counts as good and valid inferential reasoning in these kinds of cases. Landmark cases, therefore, often really light on legal authority. They draw explicitly from non-legal norms and they explicitly adjust the dominant rules, standards and principles over time. And then there's the question, therefore, of legitimacy. So for these kinds of decisions to be considered legitimate, the Court of Protection judges have to demonstrate what Kong calls articulatory disclosive rationality. So they have to explain, clarify, elaborate the implicit moral landscape and its qualitative values. And they have to be both aware of the values of the person and also self-reflexively aware of their own values. And they also have to be able to be aware of and also articulate and evaluate broader questions of public policy, so society and the impact of that decision. So what's considered a salient detail that a person needs to know, for example, to take an ironic example, the actual realities of parenthood are not required to be taken into account when deciding whether someone has capacity to make decisions about contraception, because they've decided that that would set the bar too high for the general population. So kinds of decisions like that, which, you know, kind of make you think a little bit. So even the assessment and incorporation of medical evidence itself isn't straightforward or value-free. So experts are in conflict in about 40% of cases. Judges are willing to override the pathological narrative. For example, if a psychiatrist hasn't really understood the burden or onus of proof, or the judge simply assesses the facts differently from the medical assessment. And these reflect the view that capacity is really not purely a medical or technical question. And so when it comes to the functions of the court as well, the exceptional practices and functions of the Court of Protection really reflect the context and nature of its decisions here. So it has pretty extensive inquisitorial powers because its function is to proactively reach its own assessment. It's not deciding a dispute. And for the same reason, proceedings are presumed to be private because its functions are to guard the person's interests, not to decide a dispute. And there are other non-legal functions of the court. For example, there's evidence that well-conducted assessments can depathologize, even be therapeutic, even improve capacity itself in the person. And obviously these decisions, if done well, can provide closure for families and care teams. So how might AI end up colonising mental capacity law? Medicine's long been a tantalising domain for AI applications, being used as early as the 1970s, for example, to diagnose and treat blood diseases. More recently, such as at the Alan Turing Institute, AI is being applied to try and improve and personalise the diagnosis and treatment of mental illness using routine, inexpensive medical information like questionnaires and cognitive tests. And this goes back to Sophia's point about the underlying rationale being less cost. More generally, we're obviously seeing judicial AI applications for risk assessments for pretrial release and sentencing to determinations of cases themselves, like in China and Estonia, and I won't go into that because it's already been well discussed. I haven't actually found an application for mental capacity assessments themselves in law, but I'd be very interested to know if someone actually does know of one of those, of one in existence. I'm going to very briefly float a few ideas as to why AI should be limited or excluded from mental capacity determinations. Some of these have already been passed. In one sense, mental capacity and incapacity is kind of low-hanging fruit, but I think the kind of difficulty when you start to get down and have a look at what's actually going on and why we think AI shouldn't be in this domain shows how difficult it might be in other areas of law as well. So firstly, machines lack the social reflexivity and normativity of human actors. Morality itself, which is created in these decisions, is both reflected and created by the Court of Protection's decisions. Machine learning, as we've heard, is also backward-looking and prone to lock-in. It can't project forward in the creative way that's often required of Court of Protection judges. And of course, there might be some areas of law where technical adherence to rules is both possible and sufficient. But as Lord Justice Jackson noted in the case RB, the cases which arise for decision under the relevant part of the Mental Capacity Act tend to be acutely difficult, not admitting of any obviously right answer. The Mental Capacity Act asks judges to apply its provisions to the unforeseen vicissitudes of human life, and decisions are not models to be followed, but merely examples which may or may not illuminate any new problem which arises. A finding of incapacity is really one of the few ways that our autonomy, which is a fundamental element of legal personhood, can be taken away. And I think the recoil factor at play here is based on the idea that only a person, a legitimately empowered person, should be able to adjudicate on the personhood of another. I think fundamentally this reflects a desire for empathy and recognition as human in these decisions. So the ability to understand what the loss of capacity and thereby an element of personhood would actually mean for that unique individual. And I think President Obama captured the point quite well, and I apologise, these are quite long quotes, but I thought they were quite good. Some kinds of judging, at the very least some kinds of judging, demand a socially reflexive and empathetic process to meet the purposes for which these areas of law are designed. The vulnerability of the individuals in question in capacity determinations and the democratic and human rights at stake make mental capacity law a prime candidate, I think, for drawing a red line against the use of AI in law. And that's, I think, the question that I've sought to answer, but I'm very keen to hear from everyone about what their thoughts are on that. Thank you.
Okay, my God, so how am I going to do this in 15 minutes? But we shall try. Let's start with a quote by Clifford Geertz, a famous anthropologist who studied law in non-state societies, where he says, and I'm going to repeat the quote because I think it's a fantastic quote. He says, law, as I have been saying, somewhat against the pretensions encoded in woolsack rhetoric, this I can repeat in a UK audience, is local knowledge. Local not just as to place, time, class and variety of issue, but also to accent vernacular characterizations of what happened connected to vernacular imaginings of what can happen. So just to pick on this, I've heard several people say technology is looking forward, the law is looking backward. You could summarize what I'm going to say in it's the other way around. The technologies that we're talking about are only capable of repeating the past, in brilliant ways, of course. We are capable of actually anticipating. And our looking back is a way to look back in order to anticipate. Because for us, we're alive, there's something at stake, which is not the case for a machine. It is this complex of characterizations and imagining stories about events cast in imagery, about principles that I have been calling a legal sensibility. This is doubtless more than a little vague. But as Wittgenstein, the patron saint of what is going on here, remarked, a veridical picture of an indistinct object is not, after all, a clear one, but an indistinct one. Better to paint the sea like Turner than attempt to make of it a constable cow. That also sort of summarizes what I have to say. Let's immediately take another quote. I'm sorry, I'm not going to read all this to you, but also keeping in mind the paper, which is on SSR and so can be found by everybody, by Chris and Simon, where they explore what are legal concepts, to what extent are legal concepts a compression of knowledge. If you wouldn't use those concepts, you would have to tell a very long line of argumentation. This is connected with legal realism, especially the Scandinavian brand. What is interesting here is that the people who write this paper are basically applying fuzzy logic and formal argumentation for legal interpretation. So they're saying, okay, lawyers are saying this is all about open texture, concepts, hard, ambiguity, etc. But we have the solution to that, and that is fuzzy logic. We are going to look at to what extent a concept denotates certain things, to what extent a certain connotation of context applies, and maybe how they overlap. So we're going to take all this critique of what we can't do and use it for fuzzy logic. I think that's very interesting, and it's something we should further investigate. But as I hope will be clear at the end, it does not at all address the problem that we are facing. So what's next? I want to very briefly say something about two different types of legal text, and actually three, because there are, of course, a lot of hybrids. Then I want to talk about what code-driven law does, because that's the best answer to what is law. Go and look what it does. I've just completed a book that's going to be published by Oxford University Press on law for computer scientists and other folk, based on 8 years of teaching law to master students of computer science. And the first part is called What Law Does, based on speech act theory. But I always tell my students, don't think law is social science. It's not thinking about things, having very nuanced discussions. If a lawyer defines murder like this, you are going to be in jail. If they define it like this, you are going to walk. And lawyers are very aware of this. So there are certain legal conditions. The law attributes certain legal effect to that, and it makes a difference to our world. And then I want to talk about the nature of code-driven normativity, and then talk about legal certainty. It already came up in previous discussions, and I totally disagree with much of what was said, so that's nice, because then we have an animated discussion later. So the original way that lawyers engaged with AI was GUFI. It's already been said, good old-fashioned artificial intelligence. I called within the ERC project that we have, the project that's called Counting as a Human Being in the Era of Computational Law, Cubicle. We discriminate between code-driven law and data-driven law. Code-driven law basically means that you translate prior knowledge, to use Gary Marcus' speak, translating prior knowledge, in this case legal knowledge, into computer code, developing decision trees based on legal analysis and argumentation, for instance, also mapping legislation and case law to infer relevant legal rules that can be translated. And it's very important to remember that here, case-based reasoning is rule-based reasoning. It's not at all inductive, it's, in the end, rule-based. What is assumed if you do code-driven law or code-driven whatever is you always have to formalize. Machines only speak one particular type of language in 0 and 1. You always have to formalize, and that means you always have to disambiguate. There are relationships with legal certainty. So after you have disambiguated The program will execute and give you the same an advice always based on the same rules. And it's also connected with explainability, of course, because these systems are fully explainable, because they follow a certain code that you have given them. The code can be very complex, absolutely, and from that moment onward, it may be that we can't keep all that in our heads, but on paper we can, in the end, always explain. If such code is self-executing, it's now called, under the heading of the hype of blockchain applications, smart contracts or smart regulation. Smart contracts, the person who invented them for Ethereum actually tweeted somewhere in the beginning of last year, I think, that he should never have called it that, because he says it's neither smart and it's also not a contract. I've confused all the lawyers. I should have just said persistent script, and then everybody would have gone bored, and this never would have happened. I retweet his tweet every 6 months, because very good to remind my tweets about this. Okay, so now we're in the era of big data, where people think, and you could say this is a very male thing, I have more big data than you do, look at me, yeah? Okay, there is a book where some people who I believe do not understand machine learning claim that the more data you have, the better the outcome is. That's absolutely, from a computer science perspective, not true. It may be, depending on a lot of factors, but there is no general rule. So we're now in the era of what computer scientists call artificial intelligence, the modern approach, data-driven. There is a sub-niche in, I don't know even if you call that computer science, which likes to talk about singularity. I think that's a metaphysical belief. That's okay. Many people have metaphysical beliefs, but it may not be very good to base everything that we see about the metaphysical belief of a small sect. Data-driven is basically about training a learner. That's an algorithm on relevant data. We hope they are relevant, and we call that the training data. These data are, if it's supervised, already framed in terms of a feature space. So we're going to say, okay, we're going to develop different features. That's a human activity. And then we're going to map the data in terms of those features. As you can imagine, whoever developed the feature space has enormous framing power. All the features that are not there are outside the vision of the system, because the system doesn't see anything but what you give it. Then there has to be a hypothesis space. Does anybody know what a hypothesis is in the framework of machine learning? Because hypothesis sounds like, well, if you do this, then that happens, because then you can go testing. Hypothesis here is a mathematical function, nothing else. And that mathematical function means to connect, let's say, the feature space with a certain outcome. And that mathematical function is going to be tweaked, optimized, we call it, and that's mathematics, mathematical optimization. It has nothing to do with whether that system actually optimizes in real life. You're just looking at the data set. So the optimization means that every time you give the machine input data, it gives you back the correct output. All based on the same mathematical formula. That is what machine learning does, and nothing more exciting, I'm afraid. After you have trained your learner on a set of data, you want to know whether it works for other data. So usually you keep separate data, the validation data, and you test. You can do that also by way of cross-validation, so you segment your data and do it a number of times, all very interesting. But the real verification, and I'm not even talking about falsification, which is what we want, but it's not there. The real verification, of course, is against test data that is out of sample data, data you did not have when you trained your learner. Okay, very quickly. This is all based on a machine-readable task because machines cannot understand us. You need to talk their language, and it's going to be measured by a performance metric. And I always say, what I understand from computer scientists, to make a good system, you need about 6, 7 performance metrics. And then you're going to say, okay, with this performance metric, it's 86%, with that one 43, etc., etc. And for a computer scientist, that's very important information, etc. If you're a consultant, however, and you have 6 performance metrics, and 2 are above 80 and the rest is below 40, tell me which ones you're going to show. Okay. How is it applied in LegalTech? Well, argumentation, mining, and prediction of judgment is what we focus on in the project. This can be based on text, natural language processing, but sometimes it's based on sensor data. The voting of judges in the United States has been correlated with the pitch of their voice in hearings. And as you can understand, the system outperformed lawyers. Behavioral data, this is about voter. So the wonderful system that Daniel Katz has built in the United States is based on voting behavior of judges, mixed with especially whether they're affiliated with Republican or Democratic political affiliation, and some other data. It has nothing to do with the content of the law, but based on those data, he can now predict with his system, based on a lot of previous cases, with very high accuracy. And I think it is extremely important that lawyers ask themselves the question, what does it mean that based on those data that have nothing to do with content, so let's not talk about content, that because of this mathematical function, we can simply predict what a court is going to say. And we must have answers to that. We can't just say, well, that's nonsense. We're not, the mathematics is not all. We must have answers to that. And so that's what we're working on. I just published on SSRN a chapter for a book, MIT book, where I discuss all the different framing powers, all the different biases, where the most important thing I try to say in the first part is machine learning means that you're looking for bias. So if you have a data set with a random distribution, you can't do machine learning on it because it will not find anything. Yeah? So to do machine learning, you must assume that there is bias in the simple sense of a non-distributive distribution. And that bias is productive. That's why we like machine learning. That's why we learn from it. So the next question is which of these biases applies here, is relevant, is it perhaps unlawful or unethical? Then, of course, the third one is hybrid. That means that you add prior knowledge or you add causality in the sense that you mathematically infer which correlations instantiate causality. Julia Pearl working on that. There's a lot of other research now on that. Of course, you could also say, well, I have a code-driven system, a legal expert system that maybe even self-executes decision trees, but at certain points that needs outside information. And we could say we take machine learning systems, the output, so we say, okay, people with, let's take the example of the previous speaker, people who score 13 out of 19 features, we determine that they have no capacity. Because we're going to put a threshold, because we're busy, we're not going to talk too much about it. We just take everybody with more than 13 of the 19. We then put it into the decision system, which executes by itself, and then you have this hybrid. For the law, I think one of the big mistakes is that the correlations that you can find in text can, of course, be spurious, like in any other system, but they can also be conceptual. If you're going to look for a correlation between fear and risk, There is conceptual overlap. So yes, you will find correlations, of course. And if you're then going to do all sorts of mathematical work to check whether that is causal, then you're keeping yourself busy with nonsense. Yeah? So I always see there is purist correlations, and now we have to do the causality, and then we get it right, and then we'll have some prior knowledge to constrain the system. But for us lawyers, it's much more interesting to look at conceptual overlap and relationships. And then, of course, what we do as lawyers is performative. We say, I declare you husband and wife. That's not a description. No, before you said that, they were not husband and wife. And from that moment, they are. And all sorts of legal effect starts. So this is something that these machines, of course, do not do unless we attribute to their output such effects. But that is something then we do. Okay, I have to rush. I'm just going to tell you what's in the paper and not give you all this because it would be too long and I want to get to the end of the presentation. So it's important to look at code-driven law at the parties. So if you're talking smart contracts, we're talking about contracting parties. Raises a lot of questions. If you're talking about public administration using these systems to attribute welfare benefits, again, raising a lot of questions. This is about public administration. And then, as we've already heard, you can have the legislator that decides to provide all its statutes and codes in terms of machine-readable text. And then everybody begins to say, oh, now we finally, everybody has access to justice. And I think the inverse is true, because big law and big tech will now develop analytics on those texts. And guess what? The best will be behind trade secret and IP rights. And this deliciously, nicely poor person that goes to an app that is available online does not get access to that analytics. Right? But they may be fighting against another party who does. So I'm not saying that it's not possible, but it's not, we cannot take it for granted that making these texts. It will definitely make everything more expensive because these systems are very expensive to buy, build, but they're much more expensive to maintain because they can be hacked. If you have a picture, so think of a system that does excellent image recognition, that's the highest performance now of these systems. In law, they are much below that. If you change 4 pixels in that picture, the system is getting it completely wrong. Now, with a picture, we can immediately check that, but with law, it's going to be very difficult. We're going to say, yeah, but it says 86% accuracy, yeah, so let's trust it. Okay, I'm also not going to go into that, but it's all in the paper, and I'm going to put it on SSR. And this is a series of principles of private law, public law, criminal law, and constitutional law that are challenged by code-driven law, because I'm now moving towards code-driven law, and though there are many interventions of the other type, this is what is at stake at this moment already within the different domains of law. My conclusion there is that what code-driven law does is it folds enactment, interpretation, and application. We're talking here about the rule of law, the trias politica, the 3 functions that are supposed to have built-in checks and balances. They're all folded into that moment when you translate a legal norm into computer code. So whoever does that, let's say it's lawyers, lawyer A, B, C, and D, maybe there are even 20, A to Z, with computer scientists A to Z, and they're going to do their translation, and then it's going to execute. Either self-execute or give advice, but we all know that it's going to be very difficult to go against that advice because the burden of proof will probably be on you why you didn't follow it, because the system has high accuracy or whatever other consultancy, sorry. So it folds enactment, interpretation, and application into one stroke. It collapses the distance between normally what is the role of a legislator, the court in public administration. And in that sense, it scales the past because it's entirely built on a decision, an interpretation from the past. And it actually freezes the future because that system is going to continue to apply these rules, while we would say with our natural language, yeah, but I think in this particular case we have to understand this concept slightly different. So many people say, oh, law is so old-fashioned and rigid, but now look at machine learning, how adaptive it is. No, it's natural language that's extremely adaptive, while still, for us to understand each other, there's also a constraint, a consolidation, otherwise we will not be able to communicate. Okay, the nature of data-driven, code-driven normativity. I want to very briefly say something about this, and then I will skip to the last slides. The whole point of our project is that we're going to start from this idea that there is something specific about not only natural language, but also text. So natural language can still be about speaking, but text means that you externalize text, and I'm also talking about the printing press. So what kind of normativity is afforded? And I just 2 or 3 minutes, something that is, you know, I've studied for years. So I don't know if you've heard of it, but think semiology and semiotics. So one word, like an employee, one word, an employee. If I ask you, what is an employee? Then you're going to answer me by using other words. So then I can say, oh, okay, but what is that? What is an employer? What is a boss? What is a hierarchy? What is an order? What is a place of authority? Blah, blah, blah. So words, the meaning of words depends on their relationship with other words. Yeah. But let's say that structuralism in French philosophy has taken that too far and thought that all that matters is intertextual meaning. Of course, that is nonsense. When we think about an employee, what we do is connect this very specific interrelationship web, network, however you want to call it, with something outside. That's why we speak with each other, because we have to navigate this world. Yeah? So meaning in language and in text is constituted on the nexus of intra-linguistic and extra-linguistic meaning frames. And I do hope, I don't have time now to expound, I do hope that you understand that these language systems are not given somewhere in heaven, or they don't grow out in the field. But every time I use language, I restructure just slightly this nexus of intra and extra systematic meaning, and so do you, and so does everybody, and that's how language grows. Now, you can say these things about a table or these glasses, so this is a physical object. But of course we're talking about law, so we're much more interested in things like a marriage, not the occasion, but a marriage that has certain legal effect. Whether an event has legal effect, let's think of the marriage, yeah, will depend on the multi-interpretability of these concepts that we use. And I would say that all concepts that we use, all words that we use, have this essentially open texture. That's not always relevant because usually we're creatures of habit, so, but when it matters in a court of law, why would you go to court if you already know the output? So these are the moments when it begins to matter. The open texture ensures that there is multi-interpretability, and that ensures contestability. Here we have the heart of the rule of law. So my position is the rule of law is not something that in a moment of great insight, ideologically, somebody said, let's build contestability. No, this was an affordance of the printing press because of the amount of text. And the rule of law, of course, add things like independent courts. We could go into that, but we're not going to do it. Yeah, I'm going to switch. So there is so much to say. Wow. Blah, 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 blah. Yeah. Okay, let's end here somewhere around this, and then I'll stop. So back to legal certainty. What has that to do with legal certainty? Well, there are two understandings of legal certainty. There are some people who think it's all about consistency. So you have a rule, and you must always apply it in the same way, and if you do that, you have legal certainty. I would say that's mistaking logic for reality. Reality is not logical. And it's extremely important to... So I'm not saying that logic is not important. Any good lawyer must have the capacity to argue logically. But if you think that consistency is all that there is to legal certainty, then you're mistaking legal certainty to something entirely different. And Lawrence Differ, who was first sitting there but now is dissolved because he has to take a train, actually coined the term computational legalism. Because under legalism, legalism is particularly that way of thinking about legal certainty, where you say, well, we have a rule and we have to apply it all the time, and if we do it the same way all the time, then we are sure. I would not go for merely consistency. Consistency is extremely important, but it's not at all enough. I would go, and then we draw on Dworkin's implied philosophy of the law, that when we have a rule that is that has been articulated in natural language, in text, that we can point at, here's where the court 6 years ago decided that rule. Or we can simply point at the statute. This is how it's being articulated. And then we come into this situation where we don't know what it means, but we are a court, so we have to decide, yeah, under uncertainty. And we're going to basically demarcate the connotation and the denotation of that particular norm and the concepts that are part of it. And Dworkin basically says, this is not discretion in the sense of arbitrary decisions. So this is where I slightly disagree with the paper of your paper on, because it's very much based on system theory, that when you encounter these new situations, that it would be without norms. I would agree with Dworkin that the court is bound by the implied philosophy of the norms of the law, and the court is bound to take care of the coherence and the integrity of the system. So it cannot just arbitrarily decide, well, this is a new case, let's do it this way. No, the court is constrained. So people who believe in legal realism and say, well, you know, these judges, they had a fight with their wife in the morning, they didn't sleep, their dog did something on the carpet and they stumbled over it. That's why they made this decision. And then my position is the role of the law is to say, okay, we know that people are biased and are going to make all sorts of decisions. What the law does is constrain the decision space of the court and say, okay, if you want to make that decision, go look for the reasoning, and you will have to keep that reasoning within the legal context. And I think integrity highlights the discretion that makes law. Law without discretion is not law, but force, discipline. So legalism is basically based on a naive assumption about rule following, what it is to follow a rule. It misunderstands the role of time and change in circumstances, and the fact that this requires interventions and not just mechanical application. Whereas legality is an entirely different thing. So legality certainly thinks that integrity and consistency, that consistency is important, but it sort of constrains the extent to which somebody can use their discretion. Let's see what other lovely things are there. Yeah, so, okay, the next slide is the final slide. So, it's already been said, legal singularity eliminates uncertainty. And I think that eliminating uncertainty is something extremely dangerous. So what we need, if we take recourse to machine learning and code-driven law, is not to think that now we finally have Hercules working. Now we finally know the one right answer because the machine tells us. But no, we're probably going to have 6, 7, 8 Herculi. And then we will still have to make a decision. And we sort of have to figure out when it is worth the investment in money, capital, time, labor, to build all these Herculi, because they're going to be very expensive also to keep. So I would say that legal singularity is actually the opposite of legal certainty, because legal certainty assumes multi-interpretability, contestability, and closure. Those three. And if you take the first two out and you only do closure, then you're not talking about the law, but about something else. And you wouldn't believe it, but...
Thanks very much indeed, Mireille. That was extremely interesting, and it's been another tremendous session. But I'm going to have to take an executive decision to suggest that we continue our discussion over beer, because we have to finish at 5:30, and there are a couple of things I need to do before we finish. And the most important one is just to say a word of thank you to all the people who have made this conference possible, including the speakers, the audience and the academics, but in particular the people here in the Intellectual Forum at Jesus College who've put on such a wonderful organisation of today's event for us. We're very grateful indeed. And I especially want to thank Kalia Kirkham, who's been behind the administration of this. We're very grateful to you. And I have a present for you, but Sarah will tell me which one it is, because there are several hiding under here. Right. Is it this one? Yes. Yes. This one? Yeah. So, Kalia, thank you very much.
We also wanted to thank our representatives from Nexus. I think we've seen some people go. Have they departed? Is anybody still here? No.
They said to give it to me.
And also from Thought River. And also, we had something to say thank you to Simon for all his help, because as I'm sure you're aware, with all the things going on in the background, with the books and various contacts that people have had, we thought we would also say thank you to you, Simon.
Thank you very much.
And you've had rather a stressful day with flight delays and such. So what I will say is that there's going to be drinks upstairs on the first floor foyer. Unfortunately, sorry, they're not beer. Okay. It's stuff with bubbles. It's just not beer.
Even better.
However, there is some time to capture everybody in the discussion and have a little bit more of an interaction interpersonally with people. So do head up to the first floor foyer where there will be service. And then I know that some of the speakers, there's a speakers dinner this evening. It isn't actually in this building, so you'll need to either get some guidance from the reception or look in your packs for the map. Thank you all for coming, and thank you to those who've joined us on the live stream. I'll let Simon say anything further that he wants to say, but thank you from the Jesus College side.
Well, just want to say, Sarah, Kalia, thank you very much indeed. Yeah, thanks.